Good morning, everyone. Welcome. Good morning, Gwen. I'm early. This is the motions. I mean, the jury motions, jury instructions.
Is it possible you don't have your track changes are off? And maybe that's why. That's the difference. In Word, under review, or I can just have Madam Clerk print out 2 more copies. And we could just work our way through that.
I don't think they're going to be done in time to start.
Quick track changes for everyone is still 31 pages.
Okay.
On time.
I just forwarded to Madam Clerk. I'm going to have her print out 2 copies. That way we've got hard copies, so we seem to be all on the same page.
And I think they knew that. Going in. Hey, KL. Good morning. Oh, my gosh. Dude. Oh, my gosh. The dagger in the heart was when he was like, God will prevail. He will get us out of this mess. And I was like, oh, if you only knew, Jorge, how he was going to get you out of this mess. Like, seriously, it was just devastating. And it just like, I was almost like so close to seeing her side for like a second. Like the whole battered spouse thing. And I was almost there because I thought, oh God, Jorge wasn't really that great of a guy. I was even saying those things. And then after seeing the videos, like she literally, like Gwen and I talked about it, like she literally videoed her own crimes, like herself committing these horrific abusive acts. Like she was the abuser. And I mean, I started leaning that way when I realized, wait a minute, she had all the power, all the control. She had the house, she had the car, she had the money, she had the everything. He had nothing, bless his little heart. So she controlled everything. She kept his personal things. Like it was awful. It just, it's weird. I think it's just hard for even still to this day for us to accept that women can do that to a man. But when he even said to the police, like, would you call if it was you? Like, so it kind of made me really sad. So sad. And the cop was even like, I don't know. I've never been in that kind of situation. Oh, so sad. So sad. And I don't even know now if Jorge ever really laid a hand on her. I'm beginning to wonder myself, actually. I don't know. But because every time the police came, he was completely taken aback and off guard, or he was passed out, asleep. So I don't know. It does make me wonder. Yeah, maybe. I don't know, but he seemed like in the videos, he seemed like such a happy drunk and like kind of just like he was, but he was also really sad. I could tell he was sad. And then I could tell that he just kind of like passed out. Like he just drank until he passed out. And he was very submissive. He was a very submissive and sad, happy, sad kind of like you could tell. I mean, alcohol's a depressant, so you could definitely tell that he went to the depressive part of that substance. So I don't know, man. It just like upset me just seeing him be sad and so submissive to her, like whatever she wanted. And he would take the blame. He would just be like, yeah, just take me. Just take me to jail. It's going to be my fault anyway. So just take me. And it was just sad. So sad. And the cop was like, why would it be your fault? He's like, it's going to be my fault anyway. So just take me. So I felt really bad for him. Really? I mean, he went to jail a lot. That's weird. Good morning, everyone. Join the chat if you can. That would be great. I appreciate everyone tuning in today. Right now, they're going over jury instructions. I finally get that right. And then they're going to go into prosecution finishing their rebuttal. And then they'll hopefully finish the jury instructions because these are very difficult instructions. One of them is like a very weird instruction. It has to do with the battered spouse syndrome that the defense obviously put in. So to explain what happened yesterday, just to recap, so the defense was using the battered spouse syndrome, which gave the prosecution no other choice but to put in these videos, these 911s, these videos that Sarah made on her phone, that she was trying to claim that Jorge was the aggressor and the abuser. And then, you know, as it turns out, it really looks like Sarah was definitely the instigator, the abuser, the control freak, whatever you want to call it. And it really did not paint her in a good light yesterday at all. And so, I mean, they kicked open that door. So as they say in the courtroom, they opened the door. They opened the door, and the prosecution brought in all the videos. They brought in the 911 calls. You could hear
Both
the
parties
911
have
calls where
provided to the
Sarah
court yesterday, a 34-page document, which includes the defense's red
basically
line
called
with
for no
regard to the
reason.
proposed jury instructions. We'll start on page 1 of 34. Instruction 3.1, Introduction to Final Instructions. Any objection to the form of this instruction state?
No, Your Honor.
Defense.
No, Your Honor.
Moving to page 2 of 34, instruction 3.2, Statement of the Charge. State.
No objection.
Defense.
No objection.
Moving to page 3 of 34, 7.1, Introduction to Homicide. Those 3 paragraphs, any objection?
No objection.
Good morning, everyone. Welcome.
Moving to the next portion, Justifiable Homicide in the singular paragraph. Any objection, state?
No objection.
Defense.
No objection.
Moving to Excusable Homicide and the 4 paragraphs, including paragraphs numbered 1, 2, and 3, state?
No objection. I have no objection to anything I submitted to the court.
Okay, thank you. Defense?
No objection.
Moving to page 434, 7.4, second-degree murder instruction. Defense, any objection to the form of the instruction?
No objection.
And
No objection.
also the removal of the lesser included chart on page 5 of 34, correct?
Correct.
Moving to page 6 of 34, instruction 3.4, when there are lesser included crimes or attempts. My only question is, if I understand from the defense, they're looking to see culpable negligence is a lesser included.
Yes, Your Honor.
Would that not need to be included here?
Yes, Your Honor.
Okay, so is the only addition to this, the balance of the 3.4 instruction would be correct with the exception of the last sentence, which would read the lesser crimes, plural,
Ow.
indicated in the definition of second degree murder is manslaughter.
Yeah, he was a
and
cutie. He
followed
was
by
a little bitty
culpable
thing, but he was a
negligence.
cutie.
Yeah, so it should go to R. Yes.
State?
State objects, there's no evidence to support a misdemeanor culpable negligence lesser included offense for a category 2 lesser to be included in the jury instructions. Both must be supported by the charging instrument as well as the evidence in the case. There is no evidence in this case that he only suffered culpable negligence. The crime for culpable negligence with death is manslaughter. Culpable negligence isn't even a category 1 lesser.
They want a misdemeanor added in as a lesser charge, the defense does.
By inference, there must be some evidence that her culpable negligence did not result in death.
You just did a defense of self-defense.
What's your response to that?
How can she be negligent if she's claiming self-defense?
Judge, the instruction that we're asking for is 8.9. It reads to prove the crime of culpable negligence. The state must prove the following 2 elements beyond a reasonable doubt. 1, Sarah Boone exposed Jorge Torres Jr. to personal injury. And 2, she did so through culpable negligence. As to the fact
Get my weenus.
that there is evidence of culpable negligence as to the case, in the fact that Ms. Boone, while Mr. Torres is still in the suitcase, goes upstairs. As to it being charged, it's a category 2 lesser included that's available to the defense. Defense can get category 2 lesser included offenses as long as there's evidence to support the category 2, and there is evidence in this case to support the category 2 lesser included. That's
And-
why we're asking.
Any other further argument, Mr. J?
No, Your Honor, thank you.
Okay, all right. At this point in time, the court is inclined to include
Oh.
culpable negligence
No,
as a lesser
no.
included. We'll get to the instruction momentarily.
Oh,
Any
no,
other
no.
revisions to the 3.4 instruction, defense?
No, Your Honor.
Moving now to 7.7 manslaughter, there are some objections. The defense is now objecting to paragraph 2C, the death of Jorge Torres was caused by the culpable negligence of Sarah Boone. So how could you ask for a culpable negligence instruction and then object
Come on,
to
come on.
2C in the manslaughter instruction? Logically having trouble understanding that.
Because this is my argument, because I'm not arguing that there isn't evidence of it, because I just.
Welcome, everyone. Hop in the chat. The
Uh,
defense is trying to have it all the
difference
ways as
is,
usual.
I think the burden is different from the state because it's not alleged in their information.
Does not the instruction say give 2A, 2B, and/or 2C depending upon allegations and proof?
Yes, the allegations would be the information.
Okay. Any response, Mr. J?
Judge, it's a category 1 lesser. All the theories are included in that, which does not need to be included in the charging instrument. And quite frankly, it's not inconsistent with the language in the charging instrument. She's accused of having a depraved mind when killing him, and what the evidence has also shown is that she was heavily intoxicated when she made this decision. That supports a conclusion for a trier of fact to reach that this was out of culpable negligence. And if they reject our argument that it was done knowingly and out of hatred, ill spite, etc.
Any other argument, sir?
No other argument.
At this point in time, the court is going to overrule the defense's objection as to the objection to 2C in the manslaughter instruction, including the final 2 paragraphs. of what the definition of culpable negligence is on the bottom of page 7 of 34. It seems like it's stipulated between the parties that 2B, Sarah Boone intentionally procured an act that caused the death of George Boone, should be Jorge Torres, is not applicable. Is that correct, state? Is that correct, defense? Okay, thank you. And also, since 2B is not applicable, the to procure definition will not be provided. Any other questions regarding the 7.7 instruction?
No, sir.
No, Your Honor.
No objection to what they suggest is the definition of culpable negligence.
With regard to the
Second lesser?
second lesser? Yeah, thank you.
No objection to that proposed instruction.
All right, very good. Thank you very much. What is the instruction number for the culpable negligence instruction? I think it's 8.9, isn't it?
8.9.
Okay, thank you very much. Moving now to page 10 of 34, 3.6D, voluntary intoxication. Does this now need to address culpable negligence? Or is that only?
No, yeah, we would request to add it, the culpable negligence since it's going to be given. So it should read second degree murder, comma, manslaughter, comma, or culpable negligence.
You're talking in the last sentence, correct? Voluntary intoxication is not a defense to second degree murder, manslaughter, or culpable negligence.
Yes,
correct?
Your Honor.
Thank you. Any objection, defense?
No, that one time he was like, denied.
Do we want to take an attempt to address the 3.6F?
I would
Woo.
suggest we do that later and see if we can just get not
This-
3.6 done.
At this time, we're just going to make a note that we're going to bypass the 3.6F instruction and 3.6G
I
instruction.
mean, that 3.6
That'll take
F,
us all the
man.
way to page 23 of 34, instruction 3.7. Plea of not guilty, reasonable doubt, and burden of proof. Any objection to the form of this instruction, defense?
What is the beeping?
No objection.
I've turned off the notifications.
Moving now to page 24 of 34. Weighing the evidence, 3.9 instruction.
Should we go to 3.7, plead not guilty?
Did I skip it?
Yes, sir, page 23 to 34.
I'm sorry, I thought that's what we just covered, Mr. J. I apologize.
Oh, I didn't. I was just making sure that there were no edits that either the court made or the defense made, so I was scrolling, but no objection to 3.7.
Okay, thank you. Moving now to page 24 of 34, 3.9, weighing the evidence. Looks like give as applicable paragraphs 6, 7, 9, and 10 have been struck. Is that acceptable, state?
Yes, Your Honor, I agree that 8, the inconsistent statement instruction should get bumped up to 6.
Agreed.
And the remainder should not be read.
With those revisions, is that instruction 3.9 acceptable to the defense?
Yes, Your Honor.
Moving now to page 25 of 34, the latter portion of the 3.9 instruction. Any objection to the language contained on this page, state?
Good morning, everyone. Join the chat if you can.
Defense?
We're waiting for court to actually
No, Your
start.
Honor.
Moving now, the 3.9A instruction was struck by virtue of Ms. Boone testifying in this matter, so that need not be addressed. The 3.9B defendant's statement instruction also included the
Trial
requested
junkies is
language by
here.
the
She's
state.
invisible. Good morning,
Is there any
Brandy.
objection to the form of this instruction at
How
this
are
time?
you?
Defense.
No, Your Honor.
Okay, Ms. Boone, earlier this week, and I can't recall if it was yesterday or the day before, the state had filed a motion seeking to add additional language to this instruction. And I had read that language to you at that time. Do you want me to read it again to you this morning? Okay, so I'm going to read you the entire 3.9B instruction.
No, I
3.9B
haven't.
defendant statements reads,
Did you send me
a
one?
statement
Wait.
claimed to have been made by the defendant outside of court has been placed before you. Such a statement should always be considered with caution and be weighed with great care to make
I'm
certain
awake.
it was freely and voluntarily made. Therefore, you must determine from the evidence that the defendant's alleged statement was knowingly, voluntarily, and freely made. In making this determination, you should consider the total circumstances, including, but not limited to, 1, whether, when the defendant made the statement, she had been threatened in order to get her to make it, and 2, whether anyone had promised her anything in order to get him to make it. That should be revised to the feminine. Any objection?
No, Your Honor.
Defense?
No, Your Honor.
That is the form instruction created by the Florida Supreme Court, ma'am. What has been added is the next paragraph, which reads, law enforcement is not legally required to ask a suspect whether he or she wants to talk to law enforcement after Miranda warnings are read to a suspect. This is, however, one of the factors you may consider whether the defendant's statements were voluntarily made. Similar to other conversations we've had this past week, ma'am, I don't want to know about specifics of any conversations that you had with you and your attorneys, just simply whether or not those conversations have been had. Did you and your lawyers discuss the proposed language that I just read to you?
Yes.
Do you have any questions with regard to that proposed language?
No.
Are you in agreement with this additional language being added to this defense?
Yes.
All right, thank you, or to this instruction rather. Thank you. The last sentence read, if you conclude the defendant's out-of-court statement, was not freely and voluntarily made, you should disregard it. Any other clarifications to that instruction statement?
No, Your Honor. Thank you.
Defense?
Judge, in looking at it, it says in the final part, consider whether the defendant's statements, can we replace and put rather Sarah Boone's statements?
Where are we specifically, sir?
In the state special that I have no objection to, it says, this is however one of the factors you may consider whether the defendant's statements, if we could have Sarah Boone's statements, were voluntarily made.
The language used all throughout the instruction is the defendant.
Yeah, I tend to agree with the state on that.
Okay.
Rule 3.10, or I'm sorry, instruction 3.10, rules for deliberation, page 28 of 34. Looks like the parties agree that paragraph 7 is not applicable.
Yes, sir.
I agree.
All right, that would change paragraph 8 to 7. Any other revisions to 3.10? Defense?
None from the defense.
Moving to 3.11, cautionary instruction. Defense?
No objection.
The court then interlineated on page 30, the 2.7 closing argument form instruction. Any objection to that instruction state?
If you're joining, they're going over jury instructions. They skipped over the big one, the one
Moving now
they
to
really need to
3.12
go over,
verdict
which is
instruction,
about
page 31 of
the
34.
battered
State?
spouse syndrome,
Okay.
Defense?
which I think is pretty much, I mean, I guess they have to do it now, but
Moving now to 32 of 34.
kind of null and void
Instruction
to me.
3.13, submitting case to jury. The only other question I have for the parties is with regard to, I believe it was Exhibit A, the suitcase. Are we going to send that back, or is that going to be
Oh,
viewable
yeah.
upon writing similar to the baseball bat?
No reason that it can't be sent back.
Okay, agreed?
Agree.
Okay, all right. Is this instruction acceptable to the state?
Yes, Your Honor.
Defense?
Yes, Your Honor.
Very good. And then moving to, that concludes the, except for the 3.6F and 3.6G instruction, that includes the verdict or the instructions. I'll have Anita clean that up and send it to the parties so that we have a cleaner red line to work with. The only other question that I think we can address this morning is the verdict form. I received the defense's verdict form, and it looks like manslaughter is no longer being sought in the verdict form. Manslaughter was struck out and it was just culpable negligence.
Under the defense's part, yes.
Right.
Yes,
Okay.
Your Honor.
So how do we want to address the verdict form then? Because if we're giving instructions on manslaughter, certainly needs to be included in the verdict form.
Oh, they thought they were
I
just going to
understand,
skip that.
Judge, but the defense isn't requesting manslaughter, but if it's instructed, it has to be in the verdict.
So the verdict form would read, we, the jury, find the defendant guilty of murder in the second degree as charged in the information. We, the jury, find the defendant guilty of the lesser included offense of manslaughter. We, the jury, find the defendant guilty of the lesser included offense
We've
of
got
culpable
4 bodyguards
negligence.
today.
We, the jury, find the defendant not guilty. Is that acceptable to the state?
Yes, sir.
Is that acceptable to the defense?
Yes.
All right. Similarly, I'll have Ms. Barrios make those revisions and submit them to the parties as soon as possible. Anything else, state, we need to address before? Bruce, do we have everybody as of this time? Everybody's here? Thank you, sir. Other than the 3.6 instructions and the state's request for other instructions, which I think we'll have to table for now,
Yes, sir.
are we prepared to go ahead and bring in our jury at this time?
Only thing I wanted to bring to the court and the defendant's attention was apparently yesterday at lunch, there was some sort of domestic violence event out in the quad. A coworker indicated that without believing it was any particular jurors in this case, that he did see people with juror badges in and about the area. So I don't know if that warrants inquiry by anybody.
Defense?
I think it should be mentioned.
I agree.
Okay.
I agree.
Just to see,
Sure.
we spent all this time, we've got a bunch of alternates. Let's utilize them, but I do have an issue.
Yes. What do we got?
I think the state attorney, the last piece of evidence is they extracted from Sarah Boone's phone a bunch of pages of text messages. And I believe their intent is to introduce all those text messages, which are quite a few, but I think they want to read specifically out a few to the jury. My only concern is I don't know which ones they're going to read out. And under the rule of completeness, if there's a thread where it needs to be put in context, we would ask that all of that be read. So I don't know exactly what their point is.
Mr. J, any response?
It's going back with them, just like I told them during some of the body worn cameras. Only some of it's published. It's all going to be there for them to use. I do not intend on reading all 108 pages. I don't intend on trying to delineate what contextually is one conversation from the other. I think it's just fair to say this is all going back with you. You're going to have to scrub.
I think they should have Sarah read it.
Mr. Owens, you can make any objections you deem necessary at the time, and we'll address it. Because it's just hard for me to say what should or should not be. I understand the state's position, but if it's something that's you believe in the rule of completeness should be provided at that time, regardless of it going back, we'll address it.
It's going to be about 40 minutes worth of reading text messages. Are we going to have some people come in to read the messages?
Again, I'm not sure how long it's going to take. I do not practice reading what I'm going to be reading in the mirror. Number two, no, I don't understand why a witness would be called. It's in evidence. The lawyers do not publish them.
Anything further, Mr. Owens? Okay, all right.
Not on that issue. I would like to take like 5 minutes to use the bathroom.
Sure, we can do that. Okay, so I don't want to highlight that it was a domestic violence event. So are the parties, is it acceptable to the parties to inquire of if anyone heard or participated, got any information, or observed anything of the event that transpired yesterday afternoon in the courtyard? Is that acceptable?
Yeah, you should definitely suggest what it was.
Agreed. Okay, got a thumbs up from Mr. Owens. All right, we'll take a 10-minute recess. We'll just plan on bringing back here at 9:30. We'll bring the jury in at that time. Thank you all very much.
Well, my question is, was it a event in favor of Jorge or in favor of Sarah Boone? And I wonder if any of those guys, the guys and gals sitting behind the judge that are like future attorneys or whatever, if they're looking at this and going, oh my gosh, what was I thinking? Now I'm like halfway through law school. Actually, those mock trials and stuff when you're in college is fun. So I hope they're having fun, but they're probably like, this is really tedious. But law is not always fun. It's not exciting. It's a lot of paperwork. So the defense got their thing in there, that lesser charge of culpable negligence. I don't know if they got that misdemeanor one in there. But I think they did get a win. I'm just curious about this battered woman syndrome clause or whatever jury instruction they're going to have put in. So there is all kinds of craziness going on with crime this week. I don't know if you guys heard about the 15-year-old that deleted almost his entire family and tried to blame his younger brother, but he deleted, I believe, 5 family members. Luckily, one of the family members survived and she escaped. She pretended to be deceased and she escaped and described what her brother did. He played like his younger brother did all of the damage and hid in the bathroom. They were very well off. They lived by the lake or whatever up in Washington, I believe. Big, beautiful house, but the 15-year-old brother just went on a spree in his home and took out each and every family member very target wise, like each and every one of them. The sister, the one that survived, I don't know how she survived, but she somehow managed to play dead because he actually went, when he took each family member out, he did it in the dome. So I don't know how she managed, but she got out and she described what happened, even though he tried to paint a picture to the police. When he called 911, he said that his younger brother went crazy and he had locked himself in the bathroom to get away, and he was the only survivor when he was in fact the one who did all of the deleting. So it was really bad. Sad. I don't know what caused that, but I'm wondering what is going to happen or what their thing is. But that's a horrible situation. I don't know what is going on with kids and why they resort to that type of violence. Yeah, that case is horrible too. I don't like, she used a game called Roblox and encouraged this 10-year-old. I also just watched yeah. Isn't that wild? I mean, that's just crazy to me that someone can reach out from a place they shouldn't be able to reach out to children. So you just have to be so super vigilant. But how, I don't know how you can stop. I mean, that's a kid's game that just doesn't, but people can get through these type of things. It's just wild to me. Then you have Leilani, they're back in jury deliberations today. Then you have obviously the Delphi trial, which I still am very, very confused about. The information is so limited that I just don't know about that case. I do believe that they want someone obviously to be to be guilty. They want the case to be over with. It's been 8 years, so of course they want someone, and something put them on Richard Allen. I don't know if he's the one who did it, but I just question how valid it is that he's on trial. But of course, I haven't seen the evidence, and no one can see the evidence unless you're in the courtroom. So I'm very curious about that situation. Then we have the the Kentucky mom, she finally pled guilty for taking her two sons out the same way with the fishing pole. They were two beautiful little boys, just absolutely adorable. And I don't know what possessed her either, but she was pleading not guilty by reason of insanity, and she changed her plea to guilty. They're going to sentence her. I don't think she's going to go to trial. Yes, and then the 13-year-old that took his 7-year-old sister's life. I mean, that's just crazy. And then we have Susan Smith, who is up for parole on November 4th, y'all. They did speak to her ex-husband, and he is terrified of her getting out, which oddly enough, she reached out to him for help to get out. Like, she thought that he would actually support her to get out of prison. And he is like, no. He's going to go to the parole board. And what's sad for him is she's going to be put up for parole. It could be every year. It could be every 5 years. It could be every 10 years. He doesn't know how many times he's going to have to go before the parole board and basically beg them to not let her out. So he has to continuously already have this reliving and memory of his boys and the way they were taken from him, and relive the whole publicity, behind that, but also have to go and relive it every single time she wants to get out of prison, and hope and pray that there's not some sympathetic parole person on the board that is going to be like, oh, you know what? We feel sorry for her. She should get out now. So, and then the Menendez brothers. So yesterday, they did have a press conference, saying that the district attorney or prosecutor, decided that he is going to go and plead for them to be released as soon as possible. So yeah. So yeah, it's wild, the stuff that is going on. There's more. I mean, there's so much more wild stuff. The girl in Florida, the 19-year-old that had her baby in her shared dorm space, that her roommates found, reported, that we have Carly Gregg is not getting a new trial. We're waiting to see if the ballerina is going to get a new trial. Gosh, you guys, there's just, oh yes, there was that woman. Yes. There's just like crazy wild stuff going on. I mean, I just cannot believe like why just why? And then you have, yeah, it's crazy. It's everywhere. And there's more cases going on in like local areas that we don't even know about. Like every time I turn on the local news here, I mean, I can't believe our red rum rate isn't higher in Austin, because literally every time I turn the news on, every day there is a new person has passed, and in a terrible way. So I don't know how our rate, I think it's like trying to catch up or something right here at the end of the year, because it's just getting out of control, the amount of people that are passing. And Austin is just like not doing anything or stepping up and saying like, we have a problem. So I don't know what's going on. Y'all, I just reset my computer. I did an update, and for some reason it keeps dinging and I don't know where the ding is coming from. So I apologize. It keeps making a ding sound, and I've turned all my notifications off, but apparently there's one still looming, and I don't know what it is. And I cannot find it. This Mac computer that I don't know how to work. So, yes, and then we had a huge, I know. Well, I updated it, and then it just like, now it's started fresh, and I don't know how to fix it. I updated it because people were coming in on the channel, and they said they couldn't get in the chat. So I thought, well, maybe it's my end, and I guess it's not. It's y'all's fault. So, no, then they had some, I think some daycare centers in Houston that were shut down because of trafficking. I mean, this is craziness. Just craziness. So many things. So many things. I mean, I can't keep up, y'all. There's just too much going on. You can't turn on. They used to say that when I was a kid. There was nothing but bad news on. But there's nothing but bad news on now. It's just wild. Also, the Ferris wheel trial is still going. I have not kept up with that. If anybody's kept up with that, then feel free to chime in. But I have not kept up with that trial. I just know that it is definitely a Ferris wheel. It is crazy. That family is crazy. I don't know what's going on with Young Thug. I heard that there might finally be a mistrial. For that trial has been going on for like 40 years. And I think that trial might be going into mistrial finally because the prosecution has just finally crossed the line. I don't know how now it's finally crossed the line, but we'll see. Oh, really? I haven't kept up with that trial. It just seems so confusing and so many twisted. I might look at it later, but I don't know how it could be possible that she did, because I think that man was like 6'4" and 300 pounds or something, and he lived downstairs. So I don't know how she would have gotten him to where she got him, or supposedly he was found. I don't know. I mean, y'all, I'm telling you, my mama, she's like 100 and something pound, like a little bitty thing. And when she falls, it is like a serious dead weight. Like, I mean, dead weight. Like, she's hard to pick up. So, like, I don't know how these people do this. It's like their job when they take someone out and you pick somebody up that literally is a limp, like noodle, like you can't move them. Right? I'm telling you. Well, Brandy, you're like nothing. You are teeny tiny. But I couldn't, like, if you were literally like no help whatsoever, like that's oh my gosh, why is your cat litter box 40 pounds?
Welcome to be seated. Thank you.
That's a lot of cat poop.
All right, we're back on the record. Case number 2020 CF 2603, State of Florida versus Sarah Boone. Let me get appearances for counsel, starting with counsel for the state.
Steve Castro on behalf of the state. William J. for the state.
James Owens for Sarah Boone.
Tony Henderson for Sarah Boone.
Ms. Boone is still seated at counsel's table. Are we ready to go ahead and bring in our jury at this time? State.
Yes, sir.
Defense.
Yes, sir.
All right, let's stand and bring in our jury.
I don't know, man. A body that just doesn't help you. Look how cute they all are. They're so cute and professional. They look like little mini politicians. I'm surprised they don't have that group, Future Politicians of America or something. We have Future Farmers of America. I don't know. Anybody in a suit is probably lying. It's probably why they stopped making car dealers dress in suits. We had Future Homemakers of America, Future Farmers of America. Probably the Future Politicians of America was like a cult, like a secret lair or something. Yeah, the back of her hair is never fixed.
State, do you recognize our jury?
Yes, Your Honor.
Defense, do you recognize our jury?
Yes.
All right, members of the jury, you can be
I wish
seated.
trial junkies would figure out how to get her invisibility fixed.
Members of the jury, good morning.
Wow, he's
Welcome
wearing
back
a
to
bright
12
side.
Alpha of the Orange County
He feels
Courthouse.
good today.
Just again, if you could raise those hands, confirm you complied with the court's instructions. All right, all hands have been raised. Thank you very much. Members of the jury, before the state continues with their evidence presentation today, I just have a couple of questions to go over with you.
Welcome, everyone.
Yesterday, there was an
Y'all should point
event
of
in the
view.
courtyard of
I'm
the Orange
Tracy.
County Courthouse. Did anyone happen to observe
Hop into
that
the
event?
chat.
If you did, please raise your hands at this time.
What do you mean by observe?
We'll get to it.
Okay.
Okay. Did anyone happen to hear anything during that event? All right. Record reflects no hands have been raised. Did anyone see anything during that event? All right. Juror number 2, first row. Thank you, ma'am. Did anyone participate in that event? Record reflect no hands have been raised. Did anyone receive any writings
so. I told
or
her to try
review any
X.
material from that event? Record reflect no one has raised their hands. Can the parties approach for a moment?
Does it? With the dot settings dot.
All right. Members of the jury, I'm going to send everyone out except for juror number 2 in the first row. We've got a couple follow-up questions for you individually, ma'am. Same instruction I've given you all previously. Please don't conduct any independent investigation or research as to the person, places, things, or charge involved, and don't have any discussions amongst yourselves or anyone else, and we'll bring you back in as promptly as possible.
Hold her
Thank you.
name and make a choice. Hold your name and make a choice. Trial junkies. Do I want to jump off the bridge or stay on the bridge? Uh-oh, juror number 2.
You all may be seated. Thank you.
Oh.
Juror in seat 2 on the first row from right to left. You had advised, based on the court's question, that you had observed something. You said what does observed means. And instead of getting that out in front of every other juror, we just want to have that individual conversation with you now. So tell me what it is that you saw or heard or anything yesterday in the courtyard yesterday.
When we were walking back from lunch and we saw that they were gathered, and I asked the deputy if he knew what was going on, and he said it was somebody Bain talking about domestic violence.
Okay. And you said we were walking. Who's we?
Another juror. I don't wanna say
Woo!
Okay. All right. Is that a juror that was on our panel here?
Yes.
Okay. All right. Do you recall where they may have been seated?
No, in the back over there.
Okay.
Bring them all
Do you
back.
recall what color her hair was?
Yes.
What?
Do you want me to tell you?
Please.
Dark brown or black?
Is it the shorter juror? Okay. Thank you very much. State any further questions?
It's the Asian one.
And after you were told what was going on, then what happened?
I walked back in.
All right. Did you hear any of the speakers?
I couldn't hear anything.
Anything further from the defense?
Ma'am, did that affect your ability to be fair and impartial?
Can the parties approach for a moment?
Woo. Both of those jurors are going to be excused. Okay, everyone, if you're in the live and you can't get in the chat, check your settings and make sure you're not in incognito mode so you can jump in the chat. Gwen and Brandy are fun. KL is in here somewhere too, in and out. But
We appreciate you, ma'am. Thank you so much. We're going to go ahead and bring in the balance of the panel. You can just hang out where you're at.
Criticize
Okay?
Gwen and Brandy anytime. No, just kidding. Don't criticize anyone. Just be nice. But feel free to pop in with your opinions.
We stand for you. You do not need to stand. We stand for you.
Say hello, introduce yourself. We're still waiting to actually start the trial today. Brandy would never.
Jury entering.
No, what we do here though is we would pray for each other and hope put out our best wishes and thoughts for everyone involved
State
in
you
these
recognize our
trials.
jury.
Because there are no
Defense, you
winners.
recognize
There's
our
never
jury.
any winners.
Y'all can be seated. Thank you. Again, members of the jury, if I could see those hands, you complied with the instructions during that really short break. Record reflect all hands have been raised. Thank you very much. Mr. J, you may proceed, sir.
Permission to publish from States 21, which was previously marked as P for identification.
You may proceed, sir.
Again, this is a DVD exhibit with two folders in the main directory. One entry is in a folder called Attachments. Another is a PDF labeled Extraction.
Okay, this is a continuation of yesterday with all the videos and 911 calls.
It will go back to the
Now these
jury.
are text
There will be a
messages
laptop provided to them
from Sarah's phone.
utilize this exhibit. For purposes of publication, I'm going to go by page number and date unless something requires more specificity. And for to and from, I'm going to just use the name of the contact if one exists or the phone number if one doesn't. On page 1, creation time for notes, 7:49, asking Jorge or George not to be despicable to me, making more drink after he guzzled his and I shared mine. On page 2, date March 8th, 2018. You are now in a relationship with Jorge or George on Facebook. Metadata entry 100014, etc. for Jorge Torres to Sarah Boone, owner. Page 3, May 21st, 2019, from 407-716-8684 to Melissa. And he can still live here, correct? Or until I decide to finally get him out if he doesn't clean up his act after tomorrow. On page 9, May 30th, 2019, from a contact labeled as Mom, Jorge or George, to 407-716-8684, which I will just refer to as owner in future references. Where is my clippers in the gray box? From owner to Mom, Jorge, all capitals, dumpster, separate message, like you, separate message, so is your 2 shirts, separate message, no more Rick and Morty,
a response from contact mom Jorge to owner. Okay. From owner to mom Jorge. Lucas cried when he saw the adventure fund was gone. Thank you. No wonder you're out. Fuck off. From owner, he's the one that broke it because you took it. From owner, wanted to go on an adventure. On to page 10. From owner, be proud, feel good. You made my, quote unquote, our son cry. Cheese stick, Lucas, your kids, get the fuck out of my life and my sons. No one, spinster, good, for nothing, dumpster diver, that's what you are, and the rest of you. Later on this same page, owner to mom Jorge, get all of you. Mean, selfish, fuck all you. Your firstborn is a joke. Going on to page 11, same date of May 30th, 2019. From owner to mom Jorge, get the fuck out of my life. Lucas 2, bad influence. From Jorge to owner, I am, as you can see, go drink your life away. From owner to mom Jorge, your kids are too. Yuck. Shucks, I only have one. Beaters, your 3 together. Yuck.
Dang.
Going on to page 12, from owner to mom Jorge, still dated 5/30/2019. Gross, and all the time, gross. Mom Jorge to owner, I love that guy. I love that guy. You're the one who kicked me out. Owner to Jorge, mom, finally, get your shot together and check me out in 2 to 3 months. Hope you're there. Unless I find someone better. Shit, together. From mom Jorge to owner, are you serious? Are you serious? Owner to mom Jorge, that's what happens? No. Mom Jorge to owner, I'm helping out dad right now. Call you in a few. Owner to mom Jorge, can you help me put out, fuck off? Jorge, mom to owner, how? No problem. From 267-216-5170 to owner, damn, you can only talk when you're drunk and talking shit. Owner to the previously mentioned 267 number, stop calling, texting my phone. He's not here anymore. And it's damn. 267 number to owner. NP, you didn't have to be a bitch about it. Owner to 267. Going on to page 13. Still May 30th, 2019. Yo, I like you all. He's a dick and the sheriff just left. Sorry I couldn't text back. I'll always respect you all. You know that he's not here anymore. And yes, I am a bitch. So are you. 267 to owner. Look, I'm not here to be taking shots at you. I never called you a bitch. I said you were acting like one. I'm not going to be here going back and forth on some childish shit. Have a good night. Owner to the 267 number. Friends forever, thank you. Would love to chat sometime. Call his parents, I guess. Further down on page 13, now on to May 31st, 2019, from owner to mom Jorge. Tell Jorge to call me. I want my things he took. I have his birth certificate and propane certificate until then if he wants those back. And I have your quote unquote art box. Mom Jorge to owner, stop being petty. I did not take anything that wasn't mine, I swear. owner to Mom Jorge. You're a liar. I never can believe you from all the other lies. You stop being petty and take shit like you always do. Another one bites the dust, Jorge. Hope you're miserable like you've made everyone else. Mom Jorge to owner, I'm not lying. Owner to Mom Jorge, Lucas said he won't miss you either. When I get mine back, you'll get yours. Mom Jorge to owner, I didn't take it. I'm coming over in a few to get my stuff, and I'm coming with Jean and Melissa. Going on to page 14. Owner to Mom Jorge, go for it. Bring mine W. Mom Jorge to owner, I don't have anything of yours. That's why I'm coming with them so they can vary that. Owner to Mom Jorge, I don't care. They're not going to babysit you because you're an asshole and got kicked out after being taken off the lease. Mom Jorge to owner, they seen what I had in my hands. Owner to Mom Jorge, still don't care or believe you. I'm going to get Lucas anyway, so don't waste their time or mine. Mom Jorge to owner, exactly. Owner to Mom Jorge, you were a visitor and a terrible resident, boyfriend too. Just go away unless you bring my stuff. Mom Jorge to owner, I don't have your shit, Sarah. I need my birth certificate. Owner to Mom Jorge, I don't give a shit either. I worked for that birth certificate, voter's registration, and your ID card. Just because your name is on them doesn't make them yours. Even paid for them. I needed you to be a man and take care of me, not beat me, call me names, and make me feel like I'm not a person. Not giving back until I have mine. Mom Jorge to owner, whatever, Sarah. Owner to Mom Jorge, next step is restraining order. Know that. You can come over here 100 times. Doesn't mean I have to open the door. Good one, Jorge. Go away. Mom Jorge to owner, whatever. Owner to Mom Jorge, it's been a great day without you. Will be from now on. Mom Jorge to owner, you need to do. Owner to Mom Jorge, enjoy living with your parents at 41 with no girlfriend and lonely. It was the inevitable, just like it has been before. Owner to Jorge, Mom, did you take Lucas's sunglasses? Mom Jorge to owner,
Oh my God.
OMFG, no, I did not. Turning to June 2nd, page 15, 1:10:57 a.m. from owner to Mom Jorge. Jorge, question mark, call me. If Jorge is with you, can you have him call me, please? Text to Mo.
Oh my gosh.
(1:18, 16 seconds on June 2nd. Owner to Mom Jorge, I beat you to the punch. Want to do the dartboard with me? Come. Owner to Mo, I know you won't answer, Mo. Tell him to come finish the dartboard with me, please. Owner to Mo, I miss him. Owner to Mom Jorge, ask Jorge to call me, please, when he gets a minute. June 2nd, 7:43:40 a.m. Can you have Jorge call me, please, when he gets a chance if he's with you? 7:45 a.m. Owner to Mo. Going on to page 16, June 2nd, 2019, 10:50 a.m., 55 seconds. Owner to Mo. Hello. Can you please have Jorge call me? Willing to give back. Don't know if he's there or at parents. Really want to see him.
Wow.
Owner to Mom Jorge at 10:52, 16 a.m. Not pursuing after 12 o'clock. Ever again. (12:19 p.m., 23 seconds. Owner to Mom Jorge. Please call. Come over. I'll come get you. Come over, please. I need a super hug. Hugs? Please, need. You.
Wow.
6:23 p.m. Owner to Anna. He doesn't live here anymore. Call parents or Mo in response to an incoming phone call that was made at 6:10 p.m. 54 seconds from Anna to owner.
That was fast.
Entries 9803, 9804 in the PDF timeline, June 2nd, 2019. Image 0092.heic. Capture time 6:33:01 p.m. Image 0093 HEIC captured 6:33:26 p.m. Publishing from attachments.
She literally lured him back and
Image
then
underscore 0092 metadata showing 6/2/2019 6:33 p.m.
wow.
And image or IMG underscore 0093 metadata date taken 6/2/2019 6:33 p.m.
What? Oh, Año. Ay, go.
6:34 p.m. 51 seconds June 2nd 2019. Outgoing from owner to mom Jorge. All up to you now, big boy. And for the record, those images were sent to mom Jorge at 6:34 p.m. 33 seconds. Look what you made me do. Or maybe your mom will for you. Response from mom Jorge to owner. Wow, that's really childish. Owner to mom Jorge, but effective. Mom Jorge to owner. Yeah, I see what you are doing. Did Lucas leave? Owner to mom Jorge. I'm watching shadows. Be gone for good. Minus birth certificate. Mom Jorge to owner. Okay, cool. Enjoy. Owner to mom Jorge. Am. Nice. You're not. And nice was from mom Jorge to owner. Going on to page 17. This is still June 2nd, 2019. Mom Jorge to owner. Yes, I am. You are not, though. Owner to mom Jorge. To who? Your mom? Brothers? Not me. Mom Jorge to owner. To everyone. Owner to mom Jorge, but me. Mom Jorge to owner. I love you. Owner to mom Jorge. I'm going out at 8. Get dressed. I've given you since noon. Peace out, Boy Scout. Mom Jorge to owner. I'm coming over with a handle. I was helping Pop all day cut grass. Owner to mom Jorge. Yay, you. Getting in the shower, then out. Bye-bye. Mom Jorge to owner.
Excuse me, can we approach the bench?
Yes.
I am like, what? She is, man. So again, this is where, like, she is a terrible, terrible manipulator. She's mean.
Objections overruled.
Poor Jorge was a sucker.
I'm already showered and dressed. Mom Jorge to owner. Hello? Text from Anna to owner. You're rude as hell, but okay. Owner to Anna. Your dad is a POS, but okay. At least you know and will stop calling. Owner to Anna. Futile. Anna, to owner, CTFU, as you are a piece of shit, but that's God's business, not mine. Have a good day, coke whore. Since you like to switch it up, I'll do the same. Don't text me back either, fake ass.
Oh my gosh, that's his daughter.
Page 20 of 108, June 9th, 2019, from owner to Philip. He's off the lease. The process has begun.
That's actually very hard to do, get somebody off a lease, just so you know. I don't know how they do it in Florida, but it's really hard here in Texas.
Page 22, June 11th, 2019. Metadata only shows to Mom Jorge. You tell your son he's not welcome here, taken off the lease and bound, worthless. Don't show his ugly, fucked up face around here again. Police will be called. Ask him if it was worth it and ride my bike he has. Stay Hispanic, that's what you all are. And he can watch all the porn he wants from the phone Mom gave him.
That is rude. What the heck is that supposed to mean? What is that supposed to mean? Stay Hispanic. What the? Okay. Is that supposed to be mean? I mean,
Page 26, June 14th, 2019, 11:38:56 p.m. To Mom Jorge. Wow, congrats, blackouts and whoring. We wanted to see him. Hot house, 7 people. Mission to work on my bike. Repeat. Candy Crush. Fuck himself. Shit job. Repeat.
wow.
Same page, June 15th, 2019, 7:37 p.m., 48 seconds. To Melissa, just an FYI, if my place gets effed up, I'm letting you know. He's in jail. Thanks for the prompts. I'm at my ex's house. Please don't let this reflect on me as a tenant. You said to call cops. I did. He's gone. We're both proud now. I consider you my friend. Melissa, why was he in your apartment?
Yeah, why was he there? He's not supposed to be there. This deliberation might take a while. They have a lot of evidence to go through. But I don't know. Will they go through it all?
Page 38, notes. Creation time, June 26, 2019, 5:56:57 a.m. 6:14, X videos, 10:03 a.m. Sarah Banks, 5:03 Bank, 6:13. Metro activation 6:12. Skipping down. X videos 6:2, 6:13 p.m. X videos 6:1. X videos 5:31, 9:56 a. Who's Christine? Paren FB. Going to meet up? Question. Calling her beautiful? Question. Said she thought you were avoiding her when down here. Said no, I was not beautiful. FB-nonchalant Quay. Thanks for adding me. You are exquisite. Facebook messaging Camille 6:13, 9:42, Facebook or FB, Pamela Erickson sending pictures of yourself, telling her good morning, 7:14, 12:13 a.m. FB-Crystal, going to woo her, sweep her off her feet, going to change her mind. Luck is my middle name. Sent her pics, kiss emojis, called her beautiful after returning to the convo. Said you had to pick up your brother, sent pics of beer. Sent her struts, could have been me. Sent her songs, but not me. Messaged bunny kiss emojis, convo. Sent puppy kiss emoji. Would love to take her out and see a movie. Told her about what we do in the shadows. Would love to watch Creed 2 with her. Want to snuggle with her and eat popcorn. Sent heart-hugging animal emoji. Want to play a board game with her. Asked to FaceTime call her. Called her amazing. Messaging at 7:30 a, 6:14, 6:15, 2 days. FB-Crystal liking all her posts. Quote, losing someone who doesn't respect or appreciate you is actually a gain, not a loss. Can't compare me to the next girl because there is no competition. I'm one of a kind and that's real.
Oh, she's notating everything he's doing on social media.
Continuing on to page 39, same note. I found everything on your phone, all your messenger texts, telling Christine you want to meet up with her when she's here, calling her beautiful, thanking nonchalant Quay for adding you and calling her exquisite, telling Pamela Erickson good morning and sending pictures at 12:38 a.m., messaging Camille, then the whole 2-day convo with Crystal, how dare you, and send pictures wearing my wedding ring. You're a cheating, lying scumbag. I will never trust you. Why don't you put your mugshot up, or I will, since I have your phone and login, and tell everyone why you were in jail for the 3rd time. Let them know you beat your wife and she put you there because she couldn't take it anymore. I want nothing to do with you ever again. I've become a different person since you've been gone, with less stress, anxiety, and worry. I feel safe, comfortable, happier with you not here or seeing you at all. I can say through I do have heartbreak after going through your phone. Thank you for always proving me right. I knew when you told me your mom gave you one that you'd be back to your slimy ways. You will never change. I hope it was all worth it, all of it, including losing my debit card for the 3rd time to buy beer and cigarettes, which put you back where you belong. I know for a fact you were not worth any of it. I just can't believe after everything I've done for you, including all I did to get you out of jail, and you do this to me. This is cheating. Goes on to page 40, goes on to page 41, and ends with never truly yours. Page 42, June 26th, 2019, 8:06 p.m., 16 seconds. Outgoing from owner to Mo. Just wanted to let you know to tell Jorge I found all his messages, hissy face heart emojis with Crystal and other bitches on FB, along with all his porn after he swore to me he wasn't doing any of that anymore. I'm not doing anything more for him, and he will try and keep him in jail as long as I can. Cheating snake weasel. Ask him all about it or have your parents the next time they talk to him. I'm not anymore. So hurtful after all I've done for him. He can rot in there for all I care. Going on to page 43, to Mo from owner. And I will be there for the hearing next week and his arraignment on both charges. Peace out, fucks, AKA Torres.
Wow.
Same page 43, from owner to Mo, 6/26/2019, 9:59:14 p.m. Begins, hi, I was thinking if you could get out, I'd really love it if you'd take me to a movie, or we could snuggle like we do and watch Creed 2, get some popcorn and pretzels. Maybe talk about what kind of other movies we like or find a fun board game to play together. I know your favorite is Alone. What do you think? I was also thinking the other day about how much I miss you sending me pictures of yourself throughout the day, sending me songs you wanted to hear or thought I'd like. But what I really miss are the kissy love emojis you would send, just because I really miss those, especially the ones with hearts. They'd always make me smile. I knew you were thinking about me. You do Crystal, though. Even asked her to FaceTime. What would you do if you found me having this convo with Ben or John or anyone other than you? I'd be beaten to a bloody pulp. And don't do any of these things anymore, but yet you wear your wedding ring and mine around your neck and tell me how much you love me. But you're telling this woman who looks like TPT you want to snuggle with, take out to a movie, play board games with questions, sending music, cutesy, kissy love emojis to like you used to me, telling her you want to woo her, sweep her off her feet. How do you think that makes me feel? Why don't you say that to me? Going on through the rest of page 43, page 44.
I don't know. What does TPT mean? Anyone?
On page 44, dirty cheat. Enjoy your porn and jerking yourself off secretly so your parents don't see you and your ugly new girlfriends. I can't wait to finally be with a real man, Ben, who will and has taken care of me. Can't wait to see what he's like in bed. I
What?
already know he kisses. Hope
What?
it was all worth it. I'm free. As you told Crystal in your messenger text, you're single with a little cutesy dancing dinosaur. Wow, now you really are. You're despicable. Next text is XOXO from Mo to owner.
Oh,
Page 50, 6/28, 2019, 10:55:47 p.m. from owner to Mo. Just know I can do so much more damage than all of you put together. Know that. Going on to page 51. Try me.
wow. And she was afraid they were going to come take her out. This is a complete opposite of someone who's being abused. Total opposite behavior. I'm going to figure out what the stinging is.
Page 72, July 20th, 2019, 11:34 p.m. From Janice to owner. No metadata, but from Janice. Sorry it's so late. I just read your text. He seemed fine when I saw him at your apartment this morning. He answered the door right away, but was quite bummed out that he overslept. But I was okay and told him, no problem, just get ready and come to work in about half an hour. Then I texted your phone and asked if he would rather work the afternoon shift and get some sleep, but he never answered, so I have no idea where he is or what he's doing. What happened last night, he had a black eye. He said it was new because I asked him and I told him to put makeup on it. He said he had that taken care of. Did you two get in it again? He acted like when I told him he had a black guy, at first he didn't know what I was talking about. I guess he kind of blacked out. You can call me back if you want. (11:30 p.m., 38 seconds. From owner to mom, Jorge. Janice just called me looking for Jorge and she's pissed. Congrats.
What? How did she take that? She wasn't pissed. Wow, that escalated quickly.
Page 82, 8/21, August 21st, 2019. From Jorge to owner. I love you, my friend, my love, my queen, my everything. Your Honor, that concludes everything I published to the jury.
That was faster than I thought it was going to be.
Judge, will we approach this?
Yes.
So I think there obviously this was a toxic relationship. We've had this discussion, very toxic. But I think she was definitely the main abuser and the main controller of the situation. Because even though Jorge was no angel, right? He probably did. Obviously, he talked to other women on Facebook or what have you. But I think that if she were the one who was being abused, I know for a fact, if she was the one being abused, if she was so afraid of his family and whatnot, you would never talk to the person abusing you or that family that way ever in a million trillion years. You would not talk to them that way. You just wouldn't, because if you were afraid of them or afraid of what they might do to you, if they had power over you, or if you felt like they had power over you, there's no way you would say things like that. Like, I could do so much more damage to you. There's no way. It just wouldn't happen. No, anyone who's ever been on the opposite end of that type of relationship or that dynamic, you would never do that. Obviously, they had more to lose or felt like they had more to lose in this situation than she did. So clearly, the power struggle was obviously she had the power. She was the one calling the cops. She was the one putting him in jail. She was the one sending the horrible messages to his family, to his daughters, she was horrible. And then she was calling him back, like, come back, I miss you, come play darts with me. And then she would call the cops on him. So yeah, this is horrible, horrible. You would just not do that. You would not do that. You would do everything in your power to lay low and just keep it, like, as all the psychologists and psychiatrists all testified to, you would do everything in your power to just to keep it calm, keep it chill, keep them from escalating as much as, because you don't want to be in the situation where you're having to take that abuse or beating or be in the moment of that person having to de-escalate them. That's just the way it is. You don't want to do that. And you don't want to, obviously, if their family is also just as abusive as they are, maybe not physically, but with the power dynamic, you definitely want to keep stuff as, you don't ever want it to even get to a simmer. You just want it to just stay cool, man. Just stay cool. Because you feel like you have so much to lose, so much. And when you're in that situation, you just either seriously, honestly, you feel like you want to die, or you, I mean, this is it. You feel hopeless and helpless. You would never, ever, ever act like she's acting, ever. Yeah, that was his family. So this is terrible. And his family, you can tell, like, never even, they were like, whatever, Sarah, whatever. Like, I think the only ones who ever stood up to her were probably his daughters. Were just like, you know what? You're nothing but a whatever. Like, they were the only ones who said anything. Even his own brothers didn't say anything. They were just like, we're not getting involved in this. Like, just whatever. But she was the one who was just constantly throwing punches. So, I mean, I'm not going to paint him as an angel, but he was definitely the more submissive one. I mean, okay, he watched porn, he flirted with some chicks on Facebook. And I'm not going to say he probably never laid a hand on her, but I don't know. I don't know about that part of their relationship. I can tell that the dynamic is definitely, I mean, when I was in my relationship, this is super triggering for me. This entire case is super triggering for me. I don't know why. It's just taking me back to a bad place. But I mean, I know why, but that's not how you would act. You would definitely not act like her in that situation. So, and the only thing I can see is like maybe the cheating part. You would feel less than, and you would feel like you would be trying to convince that other person, like, how could you do this to me? How could you make me feel this way? This, that, and the other. But that person really does not care if they're making you feel that way. But
Members of the jury, thank you for your patience. I just have a short instruction to read to you. Members of the jury, the state showed you portions of what was entered into as State's Exhibit 21. It is not the entirety of State's Exhibit 21. The entirety of State's Exhibit 1 will go back to you into the deliberation room with a laptop for you to review all the exhibits and text messages and the total conversations over and above what was highlighted by the state. With that, State, do you have any other witnesses, evidence, or testimony to provide?
Your Honor, at this time, the state rests its rebuttal case.
Okay. Anything further from the defense? You want to approach?
I just think we have some issues outside the presence of the jury. That we need to address.
Okay,
I have one thought, though, that requires a quick vote.
come on up.
oh my gosh, this is crazy. Yeah, so if any of you guys have any comments you want to share, any opinions you want to share, feel free. Definitely chime in. But I'm definitely, I just know based off personal experience that this is definitely not a way in a victim, survivor, whatever you want to call it, would act towards their so. Yeah, the defense team has done a very, very good job of dragging out this trial because it actually could have been done in about 3 days, I think. 4 tops. But I didn't know that his family has pretty much been there. I mean, I guess they've been there. I'm not really sure. They haven't really put the family there. But, I mean, this is terrible. This has been going on for 4 years, and she's just been doing everything she can.
All right, members of the jury, We're going to go ahead and excuse you for a couple minutes. I got some things I have to discuss with counsel outside of your presence. We'll bring you back in for additional instructions on where we think we're going to go after that. Similar instruction that I've given you over the last couple of days. Please do not conduct any independent research or investigation with regards to the persons, places, things, or charge involved in this case, and do not have any discussions amongst yourselves or anyone else about them. We'll bring you back in as promptly as possible. Thank you.
Whatever, you know, Gwen, when she gets found guilty, she ain't going back to county. She going to prison. She been in county all this time. If I'm too loud, y'all let me know because I can't tell. I should have earbuds in or something, but I really can't tell. So if I'm too loud.
Thank you. The state has
Because I'm talking
arrested
like y'all are
Mr.
all the way in
Owens.
Michigan.
Do you have any intention on putting on a sir rebuttal in this case, sir? Yes, sir.
A what? They are? What? A pillowcase filled with soap bars? Yeah, I mean, yes. No, yes.
Judge, we did not intend to put on a server level for the defense.
Okay, thank you.
Thank you.
All right,
Jesus.
Ms. Boone, I've got a couple of questions to go over with you, ma'am. You were previously sworn this morning. You've had the opportunity to review and participate in the trial. You've had the opportunity to review the rebuttal case as provided by the state. You've had the opportunity to review and listen to that evidence and witness any cross-examinations as it relates to the state's witnesses in their rebuttal case. Are you satisfied with your attorney's representation of you in this matter?
Definitely.
And are you still on
Definitely.
board with the strategy that has been utilized in your defense?
Yes.
Now, your lawyers yesterday told the court that they may want to put on a sur rebuttal, which would be a limited rebuttal to the evidence presented by the state in their rebuttal, both yesterday and today. Your lawyers have indicated that they do not intend on doing that. Similar to other conversations we've had, ma'am, I don't want to know specifics. I just want to know if you and your lawyers have had these conversations. Have you had a conversation with your attorneys about putting on a sur rebuttal or a reply in response to the state's rebuttal?
Yes.
You had that conversation.
Yes.
Are you on board with the strategy employed by your lawyers that they are not seeking to put on a sur rebuttal in this case?
I am.
Okay. All right. Is there anything else that we need to address? State.
Judge, you remember you were going to speak?
Yes. Thank you, sir. Ms. Boone, at the conclusion of the state's presentation of State's Exhibit 21, Mr. Owens had approached and had advised the court of some objections, specifically with regard to the co-ownership or co-usage of the phone. The court is not permitted to comment on the evidence, and your lawyer was seeking an instruction from the court to advise our jury that both you and Mr. Torres had access to that cell phone. I am prohibited from commenting on the evidence. Now, that doesn't prevent your lawyer or the state from speaking about that in their closing arguments. Just as a matter of law, I am not able to advise the jury as to what that evidence is. The second request pertained to the state moving from place to place through those 108 pages, moving from timestamp to timestamp. The state chose to present that evidence in that manner, which is why I gave that instruction to the jury that not the entirety of Exhibit 21 was provided to them as to what the state produced, and they'll have to have the opportunity to review that in its entirety when they go to deliberate. Do you have any questions about that so far?
So far, no.
Okay. The last portion, ma'am, pertained to the cadence or tone in which you and Mr. Torres communicated with each other. I have no knowledge as to how you and Mr. Torres communicated in text form as to what the tone was behind those words. Your lawyer advised me that there was an objection and you had some concerns as to the way Mr. J may have read those text messages to the jury. I found that the way that he read them was benign in a flat tone and did not exacerbate or excite any of the language that was in there. He'd read them in as a monotone way as possible in presenting to the jury, and I didn't notice any changes in his cadence or heightening or lowering in the volume or tense or tone utilized in presenting that information to the jury. Do you have any other questions for me, ma'am?
No.
Anything else we need to address, Mr. Owens?
No, sir.
Anything else we need to address, state?
No, sir.
Okay. How would we like to proceed with the charging conference? Do we want to bring back on our jury? It is 10:33 and advise them, this is when we think you want to come back because we're going to be addressing the law to provide to you. And that's something I need to do outside of your presence. How do we want to proceed at this time?
Oh, my Lord.
I think hopefully at 10:33 to about noon should do it for 3.6F. It is convoluted, but I think the parties have narrowed it down to really just a couple of things.
Okay.
So I would suggest saying something along the lines of, we have to finish up getting the jury instructions ready for you. That's something that we have to do now after the evidence is concluded.
I cannot figure out what this dinging
I
is.
say 1:30, Judge, in the abundance of caution, because, Mr. Henderson, I know this is gonna be an issue. And it's gonna take a little bit of time, and then we wanna go to lunch and give them a chance, because there's gonna be a 3-hour speech session. I don't know if you give them a break in between prosecutor's statement and my statement, or how you do
We
that.
may, depending on just the time of it.
Oh, my gosh.
But from 1:30, that's gonna go to 2:30, 3:30, 4:30. So just before 5, I think that's plenty of time in case he goes a little bit longer, or I go a little bit.
And I still have to read the jury instructions as well. So I mean, with 34 pages and I read quickly, as Madam Court Reporter will advise me.
Are they gonna have
yes.
you reading along with you?
Yes. So once we make all these changes, every member in the box will have a paper copy. You, Mr. Owens, and your team, along with Ms. Boone, will have a copy. The state will have a copy. Madam Court Reporter will have a copy, and I will. And I will read line by line all the way up into the 2.7 instruction. At that point in time, I will stop. I will advise our jury that we're going to begin with closings. State will go. You will go. State will have an opportunity for rebuttal. And then I'll finish with the verdict and final instructions. Discharge our alternates at that time. I'll go back and thank them and give them their jury certificate forms. And then we'll release the jury. I'll have a final colloquy with your client. And then we'll review all the evidence to send back with the exception of the baseball bat.
And perhaps in case they haven't inferred, let them know that they're getting the case tonight, so make plans to stay later.
Yes.
How late are you gonna keep them?
9 o'clock is the norm. I may, because it's the weekend and it's Friday, I may seek special dispensation from the chief to stay longer. I plan on communicating with
Oh,
the
we're
chief
gonna be watching
during
for a
the lunch
while.
hour as to that
Hope
issue.
y'all are in it.
I think that's
If she'll let me. I don't know if it's at her discretion. I know I have to seek
We all
approval
very
after
quiet,
7.
y'all, so we can catch
I'm
up
not
on a
worried about that.
lot of trials.
I know, and
While we're
I would
waiting.
prefer them to work late into the evening if they're on board with doing that,
I would prefer it too. I want
rather
a
than coming
verdict
back
today.
Monday. Okay, all right. If you all would be so kind to give me
Y'all
a
would be
moment
so
so I can
kind.
go back up to chambers, get with Ms. Barrios, and I'll give paper copies of everything from the revisions that we made this
Oh.
morning. Let's go ahead and bring back in our jury. And I agree with Mr. Owens. I'd rather us waiting on them than them waiting on us. So I think 1:30 is the way to fly. Let's go ahead and bring
because
back in our
Mr.
jury.
Owens is going to extend this out as long as humanly possible. Sarah Boone defense possible. Y'all, I have turned all the notifications off on this thing, and I don't know why what that beeping is on this computer.
Jury entering.
Yeah, especially if he tells them they're going to have to stay later. I wonder if they're going to be like, this chick ain't worth it.
State, do you recognize our jury?
Yes, Your Honor.
Defense, do you recognize our jury?
yes,
I thank you. Y'all can be seated. Members of the jury number 2 in the back, he's ready. He gets it. All right, can you
Always
raise those
gets
hands
it.
one more time for me? All right, record reflect, hands have been raised as compliance with regard to the court's instructions. Members of the jury, all the evidence and testimony sought to be provided by the state and the defense have been provided to us over the last week. At this point in time, the state and the defense and I need to discuss the law to be given to you in instructions. That's going to take a little bit of time. So we're going to go ahead and excuse you at this point in time for a longer lunch break than what you've had previously. And we're going to ask you to come back here at 1:30. At that point in time, the court will begin to instruct you on the law that you are to apply in this case. Then the parties will begin with their closing arguments. The state will go first, then the defense. Then the state will have the opportunity to rebut any of the defense's arguments. After hearing the closing arguments, the court will provide you final instructions before releasing you to deliberate in this matter. We may work past 9 o'clock tonight. We may go late into the evening. So if there are
That
any
is late into the
plans
evening.
or things that you need to reach out
9
to,
o'clock
as
is
we
like my
discussed
bedtime,
last
y'all.
week during jury selection, that we can work till late as 9, and we may work later than that this evening. If there's anyone that has any concerns as to working that late, please raise your hands at this time. Court sees no hands. I would also ask of you, if you could, please reach out to any family members or friends to, one, advise them that you're on the jury and will be deliberating this evening. And if there's any accommodations or issues with minor children or family that need to be taken care of, I would ask you that you take care of that during our lunch break.
And the emergency phone number, since they won't have phones for
Yes, we will provide you. The court deputy will provide you the emergency phone number when we get back from lunch so that you can provide that during a break that we'll have this afternoon to any friends or family or loved ones if they need to get in contact with you. I will give you a similar instruction that I've given you over the last couple of days. I know you're probably tired of it, but I got to give it to you one more time. Jurors, you must not conduct any investigation on your own. This includes reading newspapers, watching television, or using a computer, cell phone, the internet, any electronic device, or any other means at all
Unless you come
to get
here,
information
alternate point of
related to
view.
this case
Say that
or the people
every
and
time.
places involved in this case. This applies whether you are in the courthouse, at home, or anywhere
we
else.
will not sway you either
You
way.
must not visit places mentioned in the trial or use the internet to look at maps or pictures to see any place discussed during the trial. Jurors, do not watch local news or read local newspapers. Jurors must not have discussions of any sort with friends, family members, or even your fellow jurors about the case or the people and places involved. So do not let anyone make comments to you or ask questions about the trial. I want to stress again that just as you must not talk about this case face-to-face, you must not talk about this case by using an electronic device. You must not you must not use phones, computers, or electronic devices to communicate. Do not send or accept any messages related to this case or your jury service. Do not discuss this case or ask for advice by any means at all, including posting information on an internet website, chat room, or blog. With that, members of the jury, I thank you for your attentiveness, service, and sacrifice, and we'll see you at 1:30. Juror number 2 in the back. Yes, sir.
Question. So
Answer.
with the parking, we're gonna be here for some time. Can we leave and come back and get re-stamped with a new thing? Almost 3 hour long.
We will have you that answer when we come back.
Okay.
Madam Clerk's going to figure that out for you.
Okay.
All right, thank you very much.
Can we exit each?
Okay, so I don't know about where all of y'all are at, but when you say evening, to me, that's supper time. Okay, that's like 6, 7-ish maybe. That's evening, not 9 p.m. Okay, 9 p.m. Okay, I'm 50 now, y'all. So like 9 p.m. is getting like ready to get in the bed. And anything past 9, that's nighttime. That's Betty Bye time.
Okay.
So you talking like
Could you do that, Officer Jones?
10 or 11?
I've been advised, but you know what, rather than double speak, could you just tell me what it was? Say it for the record, what it
If
was.
judges approve that they are to go off campus or out of the courthouse garage, they can come back and get new stamps, cards. And everything.
So they can leave this point during lunchtime.
And I'll approve that. So, state, anything else we got to discuss other than the jury instructions? Defense.
Oh, yeah.
Okay, court's going to run upstairs, put the finishing touches on what we agreed to this morning. I'll bring back paper copies for everyone, and then we can continue the charging conference. At that time, court's going to be in a short recess. We'll be back as promptly as possible. Thank you.
Thank you.
Yeah, I mean, 11 is late, Brandy. I'm like, if I'm up at 11 and if I'm even functioning at that time, I'm barely functioning. It is a barely functioning. Okay, so let's see what else is going on in the world of. So we have Sarah's trial is all over the place. So we're staring at a wall for the verdict watch for the toddler. I hate to say toddler because that baby has a name. Of course, we have the Ferris wheel trial, which I have not been paying attention to. And I don't want to jump into that when I don't know what the heck is going on. But also, I don't know if you guys have heard about any. I have not been paying attention to Diddy, to be honest with y'all, because I just my short stint in the Hollyweird industry, I don't think that anything is going to come of it, to be honest. Everybody keeps talking about how all these people are going to get in trouble and all this stuff. And I just don't believe that to be so. I mean, look what happened with Epstein and Weinstein and all of those people. I don't think anything is going to actually happen. I think it's going to be, just like with R. Kelly. It took forever for anything. So I just don't think any of that is going to happen. No one cares. No one's going to care. It's just a bunch of famous people with a lot of money doing stupid stuff. And at the end of the day, I know it's awful and it's disgusting, but I don't think anyone really, I think R. Kelly's finally in prison, but I mean, look what happened. Epstein, accidentally took his own life. So I don't think anything's going to come of it at all. There are a lot of people coming to P. Diddy's defense, which is really wild. But the same thing happened with OJ, right? A lot of people came to his defense because he was so famous and so loved. And that's what happens with famous people. People get in this bubble and they think that they're so wonderful and they're so great and they've done so much humanitarian work or what have you. And they just lose sight of that these people are, at the end of the day, they're just people. So, so there's, bars. Sorry, Houston bars, not daycares. Thank God. There are 9 Houston bars that were caught in a human trafficking ring. So that happened. And still can't figure out what the beeping sound is. I will ask for you guys to pray for South Korea to not make the decision that they're making or possibly making. They are thinking about sending troops and weapons to Ukraine because North Korea is partnering with Russia, and South Korea obviously thinks that's a threat. So they're thinking about changing entire legislation, which South Korea has in written legislation that they would never send weapons or troops to help other countries. They are thinking about changing that and sending troops and weapons to Ukraine, which would change the entire landscape of the So, I don't know. I can't play this though on Legal Vice. I can't play it on my YouTube channel though. I'll get in trouble. So y'all can look up Legal Vice. Oh my gosh, that's terrible. Legal Vices made a video, a song of Sarah Boone. Y'all can look on Legal Vice's channel and see the video that they made of Sarah Boone. That's terrible. Let me look that up, Gwen. I can probably get away with playing that because it's on Court TV. Let's see. Because we have not heard from the family at all.
Special voices for the victim in the Suitcase murder trial for Jorge Torres. Prosecutors say that he was murdered by his longtime girlfriend, Sarah Boone, who had him trapped inside of a suitcase, beat him, and left him to die. The defense is saying that Sarah Boone was acting in self-defense. Now, Jorge Torres' family is speaking out this morning, saying that he's being unfairly depicted as an abuser and that it was Sarah Boone who was the real aggressor. Now, since early in this case, we've seen evidence of Boone's problems with Torres' family.
To know what we're here, what we're investigating, and that they're going to think I killed him.
Why would they think that?
They always have said that. They've always have said that.
What have they
I told you it's because I'm the blue-eyed white dragon. That's what they call me. Because they don't want him with me. So he's basically just not really been around his family because he chooses me over them.
I want to welcome in our special guests now. We have Jorge Torres' oldest daughter, Ana Victoria Torres, with us. We also have Dolores Ortiz with us, who is Jorge Torres' first wife, and she also brought with her this morning her youngest daughter, Destiny. First of all, my heart goes out to all of you, and for all of us here at Court TV, we are so sorry for your loss. Thank you for coming on the show, and I know that you really want to clear the air. And Ana Victoria, I know you've wanted to kind of be the family spokesperson, so I want to start with you, please. The way that your dad has been depicted as being an abuser in this trial, I know that it has upset you and you felt it's very unfair. Tell us why.
Story, and unfortunately we are the voices now, and the way the trial has gone and the way things have taken place have nobody has ever contacted us to hear our story or ask us questions in regards to our father, his character, or the relationship between him and Sarah Boone. Me and my siblings actually spoke to our father that night, and we have a lot of experiences with Ms. Boone that do not speak to what the media is stating she is, a victim or a gentle individual. I'm sure she's loved over there at jail due to the fact that Sarah Boone is very, very calculated. She by no means is a kind and sweet, soft-spoken woman. She is very calculated, very devious, very conniving. My father was sheltered and berated. He was kept from us. He was the real victim in this situation. Unfortunately, again, as stated, he is not here to tell his story, but we are here to give his side the best we can from the view that we were able to see things.
Sure. Ana Victoria, in one of the videos that we've all seen, Sarah Boone told police that George's family didn't like her and that they referred to her as the blue-eyed white dragon. Would you talk about where that nickname came from, and if it's true that you all didn't like her, and in particular, why?
I can definitely answer that. As far as the nickname is concerned, that was created all through Sarah's little brain. Other than that, she was definitely correct as far as us not liking her, and she should have stated that she didn't like us either, because that is very much correct as well. She, like I stated, is very evil, and what she is acting out there on the stand and within that courtroom is baffling to me, because that is not the real Sarah Boone at all. But yeah, she was correct. We don't like her. We didn't like her. That will never change. Unfortunately, I do feel bad for her and I wish her the best. But what I do wish is that my father receives his justice and she gets the time that she deserves. And a slap on the wrist is not it. Other than that, as far as a relationship with Sarah, one that was a good one, there wasn't one. We tried, we definitely tried, but she did not.
And Victoria, thank you for sharing all of that. I want to go to your mom now. Dolores, you were married to George for 14 years. I have three beautiful children with him. Two of them are here with us today, Destiny and Anna Victoria. We understand that at one point, Sarah Boone tried to fight you. Tell us about that.
Not per se fight me, because we've only, I want to say that we've had one engagement, which was for my children's birthday party that they attended later in the evening. So I really have never had like a confrontation. It was verbal over the phone. She had threatened me a couple times to come over and that she would dust her doormat for myself and my daughters. But it was basically verbal threats that she would give every time that George would call his children, any chance that he had, that he was able to call his children to speak, and I was present. It was a problem for George. She was very much jealous of me for what reason I'm not aware of, but we never had physical, altercations.
Well, and that's a very good thing. Tell us, Dolores, during your marriage to George, was he ever violent with you or any of your kids?
He was never violent with my children. We would have normal husband and wife family spats here and there, but never to the point where police were ever involved, DHS was ever involved. We were never that type of family. I can't relate to Sarah and the abuse that she so-called claims that she's received from George, because I never received abuse like that. I want to say the only thing that I can say about George is that he was a ladies' man.
Gotcha. Okay. And so just to be very clear here, did anything physical ever take place in terms of physical violence that he inflicted on you?
No.
Okay. And thank you for that. I know these are very personal questions, but we really want to get everything out here and get your side of all this, as everyone in the courtroom isn't hearing it. Destiny, we're so happy to have you here. You were a surprise this morning. We knew Anna Victoria was coming on and your mom, and we're so glad to see you too. What would you like to say about your dad, the kind of person that he was? What would you like the world to know about him?
My dad was an amazing person. He was my best friend. Nobody's perfect, but my dad was very loving. Everybody loved him back. He didn't deserve what happened to him. I don't think anybody deserves to die like that. I was 15 when it happened. I ended up being very depressed and going through suicidal thoughts and things of that nature. Yeah, we're just really trying to get my dad justice.
We know you are. We know you are. And Anna Victoria, back to you really quickly. You said that no one has reached out to you. Has the prosecutor's office reached out to your family?
As far as my father's mother, his father, his siblings are concerned, they have been communicated with due to the fact that they do live in Orlando. I live in Philadelphia, but nonetheless, I have communicated with the attorneys. The only thing I would say is I've never been contacted in regards to who my father was. I'm not sure if Sarah Boone deleted the calls or anything like that, but I'm sure those things were able to be, brought back up. But my siblings and I spoke to our father that night, and I do think that our encounter and what took place over the phone is very valuable to the case, as well as what their relationship was like and what Ms. Boone's plans may have been that night. Again, whether they have been premeditated or not, in my opinion, they very much were, due to the character of Sarah and all the experiences that we've had with her. But
what did your dad say on the phone?
If we were
Anna
contacted,
Victoria?
things could have been much better. So nothing in specific, but we talked on the phone for months at a time, every so often. I would say that I spoke to my father at least 3 times a week, maybe more. And we would stay on the phone as long as he possibly could stay on the phone with me, without Sarah getting agitated or whatever the case may be.
Sure.
I can't really put into words the way she would act.
Yeah. You all got to know a different Sarah Boone.
Just talk all
That's
the
for
time,
sure.
and my father that day seemed very uneasy.
Yeah. Yeah. Well, again, we are so sorry for your loss, and would love to continue the conversation with you as we're getting close to the jury getting the case. Anna Victoria, Dolores, Destiny, thank you all for coming on opening statements. And as we go to break, we want to remember Jorge Torres. Whatever allegedly happened between him and Sarah Boone, he sure didn't deserve to die. He was only 42 years old, and as you could see, had a beautiful family. You just saw 2 of his 3 kids, and he was deeply loved. All right.
Sorry, my bad. That's really sad, I was saying, and it's really sad that nobody's reached out to his family and asked how about him or how they were doing or anything. And it's sad that the only vision that we have of Jorge is him in the suitcase and his voice saying, Sarah, Sarah, I can't breathe. Sarah, Sarah. No one ever asked or got to know Jorge as a person. And the only thing actually, and thanks to the prosecution, kudos to them for showing those videos and us getting to laugh with Jorge and see his personality a little bit in those videos, because it actually backfired on Sarah. The videos that she was trying to make Jorge look bad, when it just showed that she was the devil incarnate and he was just a very calm, chill person. So Yeah, I think it's really, really, really sad because you don't see this very often where you see a man in this position. So I think it's a rare. It happens more often than people believe or want to believe. So I think that we getting to see this. But people should realize too, it doesn't just happen to guys that are as small as Jorge. He was a very small man, but there are men that put up with this. I mean, look at the case that also in Florida that we saw where the wife actually, ended up also taking out her husband in the garage where she pew-pewed him several times in the back while he was on the phone with 911. And she was also the aggressor. And she also she filmed it on her phone. And she thought she was going to catch him doing something to her when in fact she was chasing him down and she was the aggressor. And she didn't know he was on the phone with 911 when she decided to take his life. And he had his back turned. He had no idea. And he literally was on the phone and he's like, she just shot me. And then, I mean, so there's a lot, and he was an ex-Marine or a Marine. Once a Marine, always a Marine. Yeah. So, I mean, he was a Marine. So this is not just happening to men that are, Colin Coon. So Colin Coon, his wife took his life. And I mean, this doesn't just happen to small men. This happens to every type of person. So I think that's something people don't consider, is that this happens to men. So I hope the jury can see that this is something that is much more common than people think. And women are very, very manipulative. I mean, I think we can all speak to how manipulative women can be. I mean, yeah, most of her stressor was actually from work, apparently. She was Baker acted. So she was not mentally stable, but she was also going to therapy, but then she quit going to therapy. I don't know. That woman she had problems, but she didn't have to go that far. That was not cool. But she also called 911 several times that day. She did the same thing. She was trying to make it look like he was doing things. Remember, she put him outside with the child and acted like, he was trying to take her kids, but she locked him out of the house with the kids, which made no sense. Yeah, she did. She completely snapped. And then she tried to play it off like she did the same thing Sarah Boone's doing. She is trying to make it like battered spouse and what have you. The defense, I think this mental health defense is getting out of control. And then the whole like making yourself out to be a victim is really sad because it hurts people who actually are victims, like Jorge, who actually was the victim. And he actually is a victim because he's no longer with us. So that's really sad. But I will say Sarah Boone's defense has done their job. Right. You can't, anger and insanity. So insanity, obviously, which I see why it is so hard to prove, is we know what the definition of insanity is. It's doing the same thing over and over again and expecting a different result, right? So if you're doing the same thing over and over again, which is obviously staying in the same relationship and continuously putting yourself in that situation and then expecting something else, a different outcome, obviously that's insanity, right? But snapping and doing something out of a spur of the moment or anger or revenge or this is my time, I'm going to do this. That's not insanity. That's you snapped. That's not insanity. Snapping is not insanity. Snapping is I've had enough. I'm done with this. I'm doing it. So yeah, it's not, that's not insanity. Insanity is staying in that situation. Insanity is not leaving. Insanity, hey, China. Do you have the same shirt? If you don't have this shirt, you can get one with 10% off with code JUSTICE. That's right. Catch up with the cool kids and get a shirt. China's got one from Sixth Commandment. She's got a shirt. Yeah, because they were probably like, how are we going to present this as self-defense or battered spouse when, I mean, they probably just couldn't figure it out. I mean, I don't know. Maybe that was the case. But poor Jorge. He just kept going back. If anyone was insane in this relationship, it was Jorge. Because he kept going back. He kept sticking around. He kept trying to make it work. I mean, think about it. And as his ex-wife even said, like he was a ladies' man. He liked the ladies. He was a wooer. That's what he did. So, I mean, what can you say? That's, yeah. So I mean, that's insanity. That is insanity. What she did was cruel and evil. And she was definitely a horrible, horrible person. And people who do that to other people like that they're just not good people. They just they have no empathy. They are narcissistic. I don't care what any of those psychologists said. They do. I mean, they may have, obviously, they said she had narcissistic traits. Maybe she's not full on narcissistic, I guess, but definitely, I mean, I've definitely seen it, been there, done that, got the t-shirt, don't ever want to go back. So, but yeah. And they feed off other people's, what do you call it? Their sadness or, I can't think of the word. Yeah, they feed off that other person's, low self-esteem. They do. They feed off of it. They feed off of that person's need or think they need for you. So yeah, I wish I could play that video for you, Brandy, but I can't play that because it's on that other person's channel and they have lots and lots of followers and they will ding me. Okay, so we are almost back. So we're going to get to listen to them go back and forth on the jury instructions. These are very important instructions, especially that 3.7 instruction, I believe it is. Yes, they would. Legal Vices would totally do that, Brandy. He is cool. I've been watching Legal Vices since he started. Legal Vices started off with LawTube. But he's one of the reasons why I started my channel. He was part of that group of people. But they were no ones. Yeah, Ricada, man, it's so sad what happened to Ricada. That whole group, the whole group of those people were so fun, so cool. And then they just disbanded kind of and went their own separate ways. But he's only got a couple of guys in that group that are really his friends, that are truly his friend. So I do too. I really like Ricada. I hope he gets his stuff together, but you could see him declining on his channel. But he had a bunch of, Nate I've reached out to Nate. I really liked, I like Law of Self-Defense. I like him. I kind of like him. I liked him for a while. He's a really good friend to Ricada. I think Nate was a good friend up until a little while ago. What's her name? Yeah. Emily D. Baker, she started off on there. DUI guy, Legal Bites, all of them. And then I remember when they got into their first quarrel was over DUI guy at the Amber Heard trial, when DUI guy was taken aback by the testimony in the Amber Heard trial when the what was it? Oh, that entertainment reporter guy was like something about your 15 minutes of fame or something like that, and he was like, oh, and she said it was so unprofessional. Legal Bites was like, never again will you be on my channel. She just went off, and Ricada and all of them were like, what? And they just were in a quarrel with each other. And it was wild. It was wild. So Legal Bites lost a lot of followers because of that. And I guess she bounced back just fine. I don't know. But yeah, it was wild. They had a lot of, you remember that, Brandy? It was crazy. They're and then James from court was started out with DUI guy. Yeah, I followed them. I followed all of them. They were like the reason that I watched trials and all that stuff to begin with was because of Ricada and all of the LawTube people. So I really liked all of them. And then I did follow, I followed Nate. I followed all of them for a long time, but then they just kind of started getting a little weird. Yeah. Ever since that, yeah. I definitely followed all of them. Okay, here we go. We are back.
The self-defense.
When it was used in the previous case that I cited, that I used it in, 12 years ago, it's part of the instructions. Yes, where I would be requesting it.
And this is just so that we're all on the same page. Forgive me. This is the state's request for special jury instruction on causation.
Yes, sir. I suggest we table that for now and just get to the self-defense.
Okay, all right, so we'll revisit the state's request at that point in time. So is the the first full paragraph is read, is that acceptable to the defense?
Yes, Your Honor.
Okay, moving now to the deadly force definition. That seems to track the language of the proposed
I
jury
like Nate
instruction
okay.
completely.
I just can't
Any
understand
revisions to
anything he's
that
saying because he
state?
sounds like he's talking with his mouth full
Defense.
of marbles.
Your instruction, so I'm assuming you've got no quarrel with it.
Oh, Viva
Moving
and
to the
Barnes,
next
yeah.
paragraph, I also believe
I
that
like
that's
Viva.
from the
He was
Form
in South
3.6
Korea for a long
instruction.
time. I don't know if he's still there.
State, any issue with the third full paragraph?
So in my request, I struck through fourth thing to use each time because the evidence doesn't support that. What the evidence supports is she did actually use force. It wasn't a threat of force. So I think it's unnecessary and confusing and not supported by the evidence to have that clause in each of the paragraphs where it's mentioned.
Response, defense.
Judge,
And then,
I have no problem with that. I was just, when I put it in, I just was going on.
The lawyer you know.
Especially when I'm talking about aggravated assault.
Okay, so just so that I'm clear, you've got no objection to the removal of that language. So the third paragraph would now read, Sarah Boone does not have the burden of proving that she was justified in justified
Yeah.
in using deadly force. Instead, for you to find Sarah Boone guilty, the state must prove beyond a reasonable doubt that Sarah Boone was not justified in using deadly force. Is that correct, state? Is that correct, defense?
Yes.
All right, very good. Yes, sir.
To make it quicker.
And Mr. Henderson, you don't need to stand up every time, sir. I appreciate it.
I'm sorry, but it's old.
I get it.
I apologize. But it's out of habit. Judge, every time that comes up,
You lose it?
yes.
Understood. So then just let's go back to the title then. Can we revise the title to 3.6F, justifiable use of deadly force, and remove that bracketed or threatened use language?
It should just be used.
Okay, very good. All right.
Oh, did he? Yeah, I like Rory.
The
You know.
next
He's a
sentence,
good
the
guy.
law on the justifiable use of deadly force is as follows. Is that acceptable? State,
Just the strike through.
as I read it, yes. Is that acceptable defense?
Yes, Your Honor.
Randy, we've
Moving
known
now,
each other
Sarah
for a
Boone
long
was
time. Just
justified
know
in
it.
using deadly force if she reasonably believed that such force or threat of force was necessary to prevent A, imminent death or great bodily harm to herself. Is that acceptable to the state?
It's acceptable. Just confirm that they don't want me.
Yes, confirmed, only would be read would be A.
That's correct.
Okay, all right. Is that acceptable, state, with that understanding?
Yes, sir.
Okay, moving now to the next portion. Sarah Boone had no duty to retreat before using deadly force. I mean, my review of the case law, and I don't recall which one it is that if you're on your own home, you don't have to retreat.
No, not in Florida.
My understanding of the facts was that she used force first by zipping him up in the suitcase and doing so that, one, she could make him feel like he had made her feel in the past for choking and cheating on her, and two, to give her a platform to be able to speak to him as a captive audience, and he would have to listen. Because she took the actions of an initial aggressor, it is our position that there is a duty to retreat caused by the initial aggression, as that is addressed lower in the jury instructions.
Response, defense.
Judge, I have a different view of the evidence. I think what the evidence has said about the initial in the suitcase is that Mr. Torres was getting into the suitcase and positioning himself into the suitcase when Miss Boone came down. There was laughter between the two of them. The suitcase was zipped, and it was a consensual deal. It was a consensual thing.
I cannot find where it's coming from.
Or use of force at that time to zip him in the suitcase. Furthermore, during the demonstration and when they were demonstrating the suitcase and the zipping ability, I know time has passed, but I hadn't seen anything different to keep someone in there who didn't want to be in there, if someone didn't want to be in there, it would be almost literally impossible to zip that suitcase because how much force it took to zip that suitcase. So the evidence doesn't support it.
Doesn't support the duty to retreat?
Correct, because what they're saying, going back even before we had stand your ground, just going back to the castle doctrine, there was never a duty to retreat from your home.
So then if I understand your argument, you are not seeking to have this included then?
I am seeking.
Because if
I
you're
want-
saying she had no duty to retreat,
That's correct.
this talks about it. Hang on, let me just reread it. Okay, so I think I follow your argument. Okay.
What I'm saying is that it should be no duty to retreat, that Sarah Boone had no duty to retreat. That's what we're requesting. I believe the state's objecting to that and saying that it is a dispute. So they want the next paragraph as to the court. But there is nothing that showed at that time, because the state's arguing that she forcefully put him in the suitcase.
Response.
That's a straw man argument. That is not the state's argument. We know what the evidence in this case is. The evidence that she provided was he got into that suitcase by himself and they were playing hide and seek, and he was inside but not completely hidden. The lid was flapping over him. She came over and zipped it shut to whether it's 100% or near 100% shut. And it was all in fun and jest at first, but he did indicate, and we saw it on the video, image IMG_1062. Sarah, I can't breathe. Sarah, I can't breathe.
Okay, can y'all hear me? Because I'm
He
messing with
was
my
being held
sound
against
system
his
stuff.
will in that
See if I can stop
suitcase.
that ding.
That there is no requirement that she initially forced him into it or not. It's no different than two people wrestling and play fighting, and one person has another person in a headlock, and then there
Okay.
comes a point in time where I'm tapping out. Jorge Torres was tapping out, and that's on video, and it's in her testimony. It's uncontroverted. There is sufficient evidence for there to be a dispute as to whether or not she was the initial aggressor, and whether that generates a duty to retreat. And quite frankly, it's undisputed evidence because it's uniquely only her testimony coupled with the video. She restrained him in that suitcase on purpose and intentionally. And if you look at the elements of aggravated assault in our proposed jury instruction, that is exactly what was going on. She intended for him to feel fearful of an inability to breathe, to make it feel like he had made her feel when he had choked her. Aggravated assault is defined as follows: Sarah Boone intentionally and unlawfully threatened, either by word or act, to do violence to Jorge Torres. She would not let him out. She would not release the headlock when he indicated he could not breathe. At the time, Sarah Boone appeared to have the ability to carry out the threat. Well, the video evidence is res ipsa loquitur. He could not get out on his own. He could not get out on his own at 11:12 in the first movie. He could not get out on his own at 11:23 in the second movie. And quite frankly, he couldn't get out at 11:03 during the still photo as well. Element 3, the act of Sarah Boone created in the mind of Jorge Torres a well-founded fear that violence was about to take place. Absolutely. Sarah, I can't breathe. Babe, I can't fucking breathe. Sarah, shh, go fuck yourself. The assault was made with a deadly weapon, element 4. An object not designed to inflict bodily harm may nevertheless be a deadly weapon if it is used or threatened to be used in a manner likely to cause death or great bodily harm. Well, ladies and gentlemen, it did cause death. So that's not a dispute. So it's our position that she was the initial aggressor based on her testimony that we received in court, and that is going to put into play a duty to retreat, and that the parties can argue about that.
Anything further, Mr. Henderson?
Yes, Judge. I want to clarify this because what the initial thing in getting into the suitcase, the act is zipping the suitcase up. That act of zipping the suitcase up was not done forcefully. The testimony was He agreed. He was in the suitcase. He was the one who got into the suitcase to begin with. He agreed. The suitcase was zipped up, and there was no argument at that time. All right. And just by the demonstration that they gave, you could see somebody to get in that suitcase or not get out of it at that time wanted to be in that suitcase. And there's nothing to dispute what she says, that he agreed, she zipped the suitcase, and they both laughed and thought it was funny. Now, the next thing that the state goes to is an omission. It is not an act. It is an omission at that point in time where she's saying, when they say, oh, he can't breathe, well, she doesn't go let him out. So they're saying, so they're trying to make that an act when it is not, when she just did not let him out. It's different. And what we're talking about is just the duty to retreat at this time. We're not even talking about the other parts as the thing, but as to the duty to retreat, she's in her home. And at that point in time, when that act took place, she had no duty to retreat.
Here's what the form instruction says. If it is undisputed by the parties that the defendant had no duty to retreat, give the following sentence. Defendant had no duty to retreat before using or threatening to use deadly force. Instruction goes on to read, if the parties dispute whether the defendant had a duty to retreat, give the following paragraph. It sounds like both of y'all, are disputing whether or not there's a duty to retreat.
Yeah.
So I think I have to, based on what the Florida Supreme Court's instruction.
Oh no. It's on. I don't know what happened.
The red line from the defense as to Sarah Boone had no duty to retreat before using deadly force will be removed. And I will add in the state's proposed language, which tracks the form instruction. Is there any objection? Do you want me to read that to you, Mr. Henderson?
No, I'll read it real quick.
Okay. And I just want to make sure we're all on the same page. That's the state's proposed revisions to the 3.6F on the top of page 2 of 7.
Yes. I'd ask that the court would read it.
Sure. Okay. If Sarah Boone was not committing any crime other than the alleged second-degree murder or manslaughter okay, I will add that. Thank you. For which, so it'll read, if Sarah Boone was not committing any crime other than the alleged second-degree murder or manslaughter or culpable negligence for which the defendant is claiming self-defense or defense of others, and if she was in a place where she had a right to be, then the defendant had no duty to retreat before using deadly force. On the other hand, 1, if at the time Sarah Boone used deadly force, she was committing an aggravated assault, or if at the time Sarah Boone used deadly force, she was not in a place where she had a right to be, then the defendant had a duty to retreat. The duty to retreat means the defendant had the legal obligation to use every reasonable means to avoid any danger before using deadly force. The law does not require the defendant to retreat if she was placed in imminent danger of death or great bodily harm or imminent danger of the commission of parentheses applicable forcible felony end parentheses against herself, and it would have increased her own danger to retreat, or if retreat would have been futile. But if the defendant had a duty to retreat, and if she could have safely retreated but did not do so, then her use of deadly force was not justifiable. I do have a question as to the applicable forcible felony portion of that.
B. That's for her, for the A and B that we already previously discussed, not for the.
That is correct. So then that sentence would be revised to, the law does not require the defendant to retreat if she was placed in imminent danger of death or great bodily harm, and it would have increased her own danger to retreat. What say you, Mr. Henderson?
Judge, I enter objection as to the instruction as the state has included to get this instruction, an aggravated assault, which is not charged in the information.
State response.
Judge, I'm happy to hop up into that one as well.
Okay.
I understand what Martinez versus State says, and I'm sure you've all read the opinion. It's in my motions, and I understand what it holds. What it says all throughout the opinion is there needs to be an independent forcible felony. And then at the very, very end of the opinion, then it says there needs to be an independent felony charged. Why I'm asking for a special jury instruction, and I've made that request in writing, is because under the standard jury instruction that we are going through right now, it says, according to Martinez versus State, that the independent forcible felony needs to be charged. The whole purpose of this is you can't engage into a circular logic argument that defeats Ms. Boone's right to self-defense. So it would be preposterous to include in this jury instruction, Ms. Boone did not have a right to use justifiable use of deadly force by committing second-degree murder against the victim when that's the charged offense. Because she, of course, would have the right to use deadly force to defend herself against the victim, and that would be correct. But what we have in this case, and what the state has alerted the court and the defendant to well before trial, was the evidence shows that she committed a separate aggravated assault.
Dang, they're taking a long time, Gwen.
At the time that she had already zipped him shut in there, and again, just because she releases that quote-unquote chokehold by sitting on the couch, she is exerting that force through distance because she's the one that zipped him shut. So she, in using that force, is the one who did that on purpose to make him feel like he was choking and make him feel like he had made her feel like when she was getting cheated on, and to intentionally confine him in a place so that she could speak to him about her thoughts. As I already outlined, it's the state's position, and the evidence does support that this is an aggravated assault. She intentionally put him in fear of death, and she relished it. She relished it for that 2-minute video. That is prior to when she says, well, now he's sticking his fingers out and I get scared by that action. And by that action, it's Jorge Torres just trying to exert the will to live and to survive and be on this earth. That now that action, if his attempt to escape out of the suitcase that she has left him zipped up in, is this independent threat of great bodily harm and death to her. She testifies if he gets out, it's her belief that he will beat her up, kill her, disfigure her, so on and so forth. In her testimony at trial, I believe she said he said that I will end you. So what we have here is they, by their own admissions, through the testimony that she provided, that there is a separate and distinct independent forcible felony from what ends up being the second-degree murder. What ends up now being the second-degree murder is at this point in time when she says, well, he's trying to get out. I'm afraid if he gets out, I'm going to get disfigured or killed. And so that is why Ms. Boone makes the decision, and I'm not even going down the aggravated battery path, but she batters him with a bat on the hands and batters him, pokes him while he's in the suitcase, and basically beats him into submission so that he stops trying to escape. That's what the testimony was. And then she makes the decision to now leave him and go upstairs and go to sleep without having relieved him from the force that she exerted earlier committing aggravated assault. So like the example I gave you earlier, this is absolutely no different than me pointing a gun at you, Judge, and putting you in fear of your life that I'm going to shoot you and a projectile is going to enter your body and kill you or give you great bodily harm. And you, in turn, after having been placed in fear by me
He
pointing
keeps
the gun
using the
at you,
same analogy.
you begin to defend yourself and exert your right to live on this earth by pulling your own firearm. And now, do I, as the initial aggressor,
I think I need
the
to switch
initial
to a
person
standing
committed
desk.
the forcible felony of aggravated assault on you, under the law, I don't have the right now to defend myself against you. I need to retreat. I need to make it clear, sorry, man, my bad, drop my gun and walk away. That is what is the
Sorry,
law.
dude.
776041 is a very short and very, very simple statute.
Look, if you're going to point a fishing pole at somebody,
And
you
it
better
has
be
not
prepared to
changed
use it.
Since 2014. This has been the law.
You don't
This
just go
was the
willy-nilly
law
pointing one of
at the
those
time of this
fishing
offense
poles
in
at people.
2020. 776041 provides the justification described in the preceding sections of this chapter is not available to a person who, one, is attempting to commit, committing, or escaping the commission of a forcible felony. So taking away the firearm example, it's a chokehold. His cause of death, according to the medical examiner, was asphyxiation by position and environmental suffocation, caused by her not releasing a chokehold on him when he indicated, babe, I can't breathe, Sarah, help. That is an independent forcible felony, separate and distinct now from what she says is the victim, like you pulling a gun to defend yourself from me pulling a gun on you. Now, the threatened use of force that the victim is exerting is sticking his hands out and saying, I'm going to end you.
2 fingers.
That is the distinct
Little finger.
break between the aggravated assault and now her continuing to use this unlawful force, which she's not entitled to do because she started it. She was the initial aggressor in committing this aggravated assault. And she ends up just leaving him to die and never releasing the chokehold.
And the unlawful threat is what's on the video in your realm.
Yes.
Okay.
And any facts that support that should cause this jury instruction to be given. The absolute only hang up about whether or not this jury instruction should be given is because Martinez slightly overstates what is necessary to prevent this circular logic, which is not going to occur in this case. There is not going to be any arguments by the state that she does not have the right to defend herself if she is in imminent fear or death of great bodily harm by the victim. She testified that him sticking his hands out of the suitcase and saying, I'm going to end you, put her in fear of imminent death and great bodily harm. And in turn, what she did was she decided to not let him out. And he ended up dying. And that is second-degree murder. That is separate than what preceded that. What preceded that was her not letting him out when you can see him pushing up on the suitcase in the video, begging to get let out, and she doesn't because she is doing this out of anger, hatred, ill will, and spite to teach him a lesson and put him in fear of death or great bodily harm. That's an aggravated assault. I would absolutely charge her with aggravated assault and aggravated battery, separate independent forcible felonies, if I could. But I did not learn this information until after the statute of limitations had passed. That is through no fault of the states. So we absolutely would, if we could, and we are not going to make the argument and defeat her defense of second-degree murder by saying, well, you can't defend yourself with second. I understand what they're getting at in Martinez. That's not this case, though. It's broken down into those parts.
Can I have the citation for Martinez? Because unless I missed it in your motions, I didn't see Martinez cited in the motions.
I'm sorry.
And forgive me if I
No, it's been in previous motions.
This has been going on so long, Your Honor, that
You cited a
it's
Cologne
like
with
4
regard
years
to the
ago.
Miranda issue.
No, I'm referring to, there's a pleading entitled State's Request for Forcible Felony Instruction and Request for Initial Aggressor Instruction, which we've kind of hopped into now since aggravated assault is being mentioned in this paragraph. In paragraph,
Oh, there it is. I apologize.
yeah, paragraphs
Thank you.
12 through 31 are the legal analysis, and Martinez is cited in there at paragraph 19 at 981 Southern 2nd 449 Florida 2008. And more importantly, What Martinez doesn't say is that there's like some requirement that the verdicts would be interlocking. Like there's no requirement that second-degree murder be count 1 and aggravated assault be count 2, and then if they return a not guilty verdict on aggravated assault, then there has to be a not guilty verdict on the second-degree murder. That's not the case, because there's so many different prongs to the self-defense instructions. So it's not required to be charged for some reason of an interlocking verdict. And the whole spirit of that opinion is that it is to make sure that we do not defeat her self-defense argument that she's entitled to make about why she committed second-degree murder. All we're saying is you're not entitled to defend yourself in that manner if you committed an aggravated assault to start this. And that's what the facts show. It's a little complicated, and there's another special jury instruction related to this force by distance. It's like tying somebody to some train tracks and walking away. I mean, are you still choking the person? No, but are they restrained in a manner that if a train comes, they will die? Yes. So the special circumstances of this case and the facts are going to warrant, in the state's estimation, the forcible felony paragraph, and then that language being placed into this initial paragraph that we're talking about.
She could have it much worse if it weren't for statute of limitations. She could be being charged with like aggravated assault.
And then just for the record, the 3 prongs for a special jury instruction, which I cited in a couple of my other pleadings. A special jury instruction is warranted when A, the special instruction is supported by the evidence, which is the case. It's in fact undisputed since there was only one.
Thanks everyone for tuning in. Join the
standard
chat if you
instruction is not
can.
adequate
That would be
coverage
awesome.
of
Introduce
period
yourself.
10 2.
Welcome to the alternate point of
That is
view.
also true.
We are watching
C,
Sarah Boone.
Special instruction was a
They're
correct
going over
statement of
jury
the law, not
instructions right
disputed.
now.
That is also the case.
Trying to
Stevens,
compromise.
S versus state, 787, Southern Second, 747, and I mistakenly put 657, I imagine.
I think it's 755 is the pinpoint.
2001.
Yeah, I reviewed that already. Thank you. Response.
Response is clear, Judge.
We don't
They're
want
trying
it.
to make exceptions for the law. That doesn't work here. Simply this, what the requirement is under Martinez
Please
to
like,
get the aggressor
subscribe,
is this.
share, say hello.
It's only applicable
My name is Tracy Lee.
and only in cases
Welcome,
where
welcome.
the defendant was charged with either an independent forcible felony, that's Martinez, or B, felony murder. That's a different case. And Martinez, they have not charged an independent forcible felony. So it doesn't apply. It tells us right there, that's the standard jury instruction. For him to come back here and say, well, really, Judge, they overstated Martinez. Martinez is still good law. It has not been changed. That's the rule. That's the requirement.
But this is relying, Martinez's opinion states, indeed, consistent with this case law in 2006, we approved an amendment to the self-defense jury instruction to specifically provide that the forcible felony instruction should be given, quote, only if the defendant is charged with more than one forcible felony. That doesn't seem to be what the new instruction says, unless I'm missing something.
There.
I'm sorry, can you repeat that?
Sure. The sentence says, indeed, consistent with this case law, in 2006, we approved an amendment to the self-defense jury instruction to specifically provide that the forcible felony instruction should be given, quote, only if the defendant is charged with more than one forcible felony. And unless I'm missing something, a 3.6F instruction doesn't say that now.
Oh yeah, you
Form
try to
instruction.
make a misdemeanor.
Judge, when it comes to the aggressor in the standard jury instructions, when it comes to aggressor and they're talking about under 776.041 sub 1, it's to only be given if and only in cases where the defendant is charged with either an independent forcible felony. You cannot give this instruction unless there's an independent forcible felony that Ms. Boone has been charged with. And there just isn't one.
But where does it say that in the form instruction?
Judge,
Yes.
page 14 of 28. Aggressor 776.041(1), Florida statute, give if applicable and only in cases where the defendant is charged with either A, an independent forcible felony, Martinez versus State, 981-449, Florida 2008.
Hang on.
For the felony. And we're acknowledging that. But when you look at the case and what it is stating is the purpose of that is there has to be in the evidence an independent forcible felony. And that is what occurred in this case. She committed an aggravated assault. After that, the defendant is saying the victim.
We're going to start having workout
fear of
time
imminent harm or
during these
death
cases.
by trying to escape her aggravated
Too long to
assault.
sit on my
By
butt.
sticking his fingers out and by saying, as he's trying to escape, I'm going to end you.
But isn't that in the giving the aggressor definition? I mean, is that, but unless I missed something, that's not what we're talking about right now.
I agree, but I think it cohabitates together.
Okay.
And it's our position, we absolutely would charge her. And it's a legal technicality and part of this standard instruction that we can't because of the statute of limitations. We all know, all of us here together as attorneys know that those facts, if believed by the jury, support that she violated Chapter 776.041(1). She should not be able to get away with murder because of a statute of limitations technicality that was through no fault of the state's own. The purpose and spirit of Martinez is to make sure that we're not up there arguing, ladies and gentlemen of the jury, she had no right to defend herself from an imminent threat of harm by killing somebody. That's not what we're going to say. We understand that. What we are going to say is, ladies and gentlemen of the jury, she had no right to leave him in that suitcase out of fear and great bodily harm or imminent death because she committed an aggravated assault to put him in that predicament. That's the evidence in the case. That's the arguments that's going to be made. That's why we're making a special instruction request based on the unique facts and circumstances of this particular case.
Give me a second.
I mean, can they argue that if it's the statute has passed? I'm interested. If you can't charge her with it, are they even allowed to mention it?
Proposed, the language in the instruction in pertinent part says he or she was committing an act, insert the defendant's criminal activity that the defendant act, but the criminal activity cannot be the charged crimes for which the defendant is claiming self-defense or the defense of others. The charged crime, second-degree murder. So I'm struggling with understanding as the other crime is, because I'm not hearing any argument as to the applicability of aggravated assault.
Judge, because, and I didn't make any argument about aggravated assault applying because they can't get over the first hurdle. The first hurdle is it has to be charged. It's not charged. That's what the case law says. I mean, this is pretty clear to me unless I'm looking at it wrong when it says this is not to be given if there isn't an independent forcible felony charged.
Any other response, State?
Just that it defeats the purpose of the statute and is manifestly unjust when it is a legal technicality of no import. There is no interlocking verdict required. If we were able to charge aggravated assault, there's no requirement that they both be found guilty. They could go ahead and hear this instruction and find her not guilty of aggravated assault and still convict her of second-degree murder because of all the plethora of permutations we have in these instructions.
But in Martinez, the underlying charge was attempted murder and aggravated battery, both of which were charged, and we don't have that here.
But it's still going to the one act. And of those facts, we are talking about separate, clearly distinct facts here that support there's an aggravated assault that separately gets committed first, and then in response to the victim responding to that aggravated assault, she leaves him in the chokehold to die because if she lets him out, it's her belief she's going to face death or great bodily harm because she committed a forcible felony against him. This is purely a legal technicality. The entire opinion on Martinez, until the very last paragraph, uses this language.
I don't know.
They use language like the underlying facts of the present case demonstrate why it would be illogical to conclude that section 776041 paren 1 applies where there is no independent forcible felony. It doesn't say where there is no independent forcible felony charged. It goes on and uses that same language all throughout the opinion, and then in the very last paragraph in the conclusion, it changes to, in conclusion, we hold that it is error for a trial court to read the forcible felony instruction to the jury where the defendant is not charged with an independent forcible felony. But there is an independent forcible felony in the facts. There is a statute that says that Ms. Boone should not be able to avoid the girth of this jury instruction. She violated, according to the facts that she gave us, she violated 776041 paren 1. She was committing an independent forcible felony and therefore should not be able to get away with this instruction not being given because the technicality that the state can't charge a case or can't charge a count that is not required to be interlocked by verdict. Thank you.
Man. And we're still not even to the major jury instruction, are we?
Footnote 4 provides, explanation in the Martinez opinion as to certain circumstances and whether or not in that hypothetical that the Supreme Court gave, whether the robbery is a separate and independent forcible felony and the forcible felony instruction is applicable. But the conclusion seems to state that it has to be charged, that it is an error for the trial court to read the forcible felony instruction to the jury where the defendant is not charged with the independent forcible felony.
Uh-oh.
Anything else, Mr. J?
No, sir.
Then how do we want to accomplish this? Because I don't know how I can read the proposed language by the state. And there's a disagreement as to whether there's a duty to retreat. It's not undisputed. It is, in fact, disputed.
Well, their complaint is in the sentence, on the other hand, if at the time Sarah Boone used deadly force, she was, then I just think we strike through committing an aggravated assault. We go to if at the time Sarah Boone used deadly force. Okay.
And unless you just want to go to 2, on the other hand, if at the time defendant used deadly force, she was not in a place where she had a right to be, then the defendant had an obligation to, or excuse me, then the defendant had a duty to retreat, just excise 1 completely. I don't know what else to do.
But she has a right to be there.
Right. Under the Castle Doctrine and the case law.
Okay, then I think we go with the first paragraph and then we just deal with the initial aggressor at the end, which is kind of the exception to that. So
Okay, so then
Sarah
Boone had no duty to retreat before using deadly force.
Yes.
Okay, is that acceptable to the defense?
Yes.
I think it puts us back in the position where we started at anyway. Okay, all right.
Oh my gosh.
I just object for the record in case some assistant attorney general wants to potentially cross appeal.
Objection noted. It looks like the next parts of the form instruction, if the defendant was in a dwelling, was excised, the give A, B, or C was excised. Are you on board with that state?
Yes.
Then the next paragraph, a person is not justified in using force to resist an arrest. Clearly, that's not applicable. I don't think that's at odds. However, if an officer used excessive, I also don't believe that's applicable based on the facts. We then proceed to the give in all cases language. Any objection to this language state? Sure. It's the bottom of page 2 of the defendant's 3.6F red line.
I'm just finding where it's in
On the form instruction, it's the bottom of page 3 of 7. Give in all cases, right after Jackson v. State.
This judge, he's like so tired. And this is going to go on into the night, not the evening, y'all, as they said. This is going on into the night, okay? I don't know where they're coming from with 9 o'clock.
Any objection?
Evening. That's at
No
night.
objection to that, Judge.
We'll excise the threatened use, so it'll all read use of deadly force in that paragraph.
These are going to be some long jury instructions.
All right. Now we have a proposed instruction, I believe, from the defense regarding battered spouse.
We table the battered spouse proposed instruction since both parties have that.
Sure.
Oh my gosh. They're going to keep.
Moving now to the presumption of fear. That's been struck out by both parties and agreed to. Moving to the exceptions of presumption of fear. That's been struck out by both parties and not necessary. That takes us to a person who unlawfully by force enters or attempts to enter. That's not applicable. Definition of dwelling is not applicable. Residence and vehicle are not applicable. That takes us now to the aggressor language.
No additional arguments as to why the facts show she was the initial aggressor.
Oh, well, I've heard it. Mike listens to him.
There's no requirement under this
provision that there be an independent forcible felon.
Okay. Looks like we have a disagreement between the parties as to the application of the aggressor instruction. It's struck out on the defense's side and not in the state side. What say you, Mr. Henderson?
Give me 1 second.
Sure.
Please.
Yes, sir.
I know. Well, they're younger and more up to date.
All right, are we on 776.041 sub 2?
Yes, sir.
If I could have one more.
Yes, sir.
So this is the tedious side of law. It's not always fun. This is the behind the scenes.
Judge, my argument would be that the only evidence, the evidence from Sarah Boone stated that she did not do anything forcefully wise until after Mr. Torres had made verbal threats and was coming out of the suitcase. So that's my objection is based on that. No other legal argument.
Any other argument, state?
Just, it's play wrestling and not releasing the chokehold when your buddy tapped out.
And I mean, isn't there evidence as to what Ms. Boone had told the experts, which seems to be at odds with that issue? And it's really a factual issue and a determination for the jury to make that determination on what the real facts are.
I can't disagree with that.
Okay. Then with regard to the proposed language as the 776.041 sub 2 instruction, however, the use of deadly force is not justified if you find that Sarah Boone was attempting to committing, or escaping after the commission of aggravated assault. An aggravated assault is defined.
No.
No? Am I on the wrong section? I apologize. I am at the wrong section. Forgive me. So it is the, however,
With my strike throughs, it's however, the use of deadly force
is not justified if you find that Sarah Boone used force to initially provoke the threatened use of force against herself unless, one, the threat of force asserted towards the defendant was so great that she reasonably believed that she was in imminent danger of death or great bodily harm and had exhausted every reasonable means to escape the danger other than using deadly force on George, that's spelled incorrectly, Torres, or two, in good faith, Sarah Boone withdrew from physical contact with George Torres as clearly indicated to George Torres that she wanted to withdraw and stop the use of deadly force, but George Torres continued or resumed threatened use of force.
Yes, sir.
What's your just for clarification purposes, anything else as to that instruction, defense?
Just one thing I need to put on the record, Judge.
Yes, sir.
The force at that time, as testified to, was the poking of the bat on the outside of the suitcase. There was one strike when the hand was outside. These were bruises. I think there was something that came to the injury to the head area, though. The injury to the head could be serious, but in this instruction, it's talking about deadly force. And none of those, as to the testimony from the medical examiner, none of those injuries caused the death.
The continued restraint on him that she did not undo is the force that we're talking about. It's just like in the cases that I cited in my special state's request for special jury instruction regarding withdrawing from physical contact. Batteries don't need to be skin to skin. You can commit a battery on somebody while driving your car and striking their car. A false imprisonment does not mean you have to choke somebody. You can falsely imprison somebody by barricading them into a room with a grocery cart. She unlawfully exerted that force and did not withdraw from using that force when her wrestling partner, so to speak, tapped out.
Okay. I'm going to include the instruction for now. The next paragraph reads, if you find that Sarah Boone, who, because of prior threats or difficulties, all right, that'll be included. The next paragraph, if you find that at the time of the alleged aggravated assault and or criminal mischief.
Yeah, there just needs to be secondary murder, manslaughter, or culpable negligence, and we don't object. There were specific acts put in evidence.
Any objection to changing the beginning of that sentence, defense, if you find that at the time of the alleged murder in the second degree, manslaughter, culpable negligence, Sarah Boone knew that Jorge Torres had committed an act?
Yes.
Okay, thank you.
And we requested the strike at the end or threatened to use.
Agreed.
Give me a moment. So that sentence would now, or that section would now read, if you find that at the time of the alleged second degree murder, manslaughter, or culpable negligence, Sarah Boone knew that Jorge Torres Jr. had committed an act or acts of violence, you may consider that fact in determining whether Sarah Boone reasonably believed it was necessary for her to use deadly force. Acceptable?
Yes, sir. I just don't know that we used Junior after his name anywhere else.
Give me a moment. Yeah, Junior's not used anywhere else, so I'll excise that. Is that acceptable to you, Mr. Henderson?
Yes, Your Honor.
All right, moving to the next line. If you consider that Jorge Torres, removing Junior, had a reputation for being a violent and dangerous person. I don't know, did we hear evidence of reputation?
The state's position is going to be there's no reputation evidence. Ms. Boone offered an opinion, but as everybody knows, reputation evidence has to come from a broad enough aspect of the community, whether it be a church or a neighborhood or perhaps even a large family. But
Defense?
I'm rethinking that, Judge.
No worries, take your time.
I know generally, and reputation evidence, generally, it has to be something that is known based on a community standard, and if that was the community. I know the only thing that I can relate to is the fact that individually, she experienced certain things that could build that reputation, but that's on her. I think there's evidence, though, from people, at least that they knew about it or were told about it. Most of that was stopped. but I could go to at least the one situation on a text message that was introduced earlier today that talked about him beating his former wife or ex-wife.
How's that reputation? It sounds like that's a specific instance based on that text message.
Correct. I agree.
Okay, so in agreeing, we're going to excise the reputation section, correct? Okay, thank you. The court will
Just
excise that.
concede. Y'all brought no reputation witnesses up there for either side, technically. I mean,
What about the one that precedes that? If you find that George Torres had a reputation, well, also that reputation would be removed as well, correct, Mr. Henderson? If you find that George Torres Jr. had a reputation for being a violent and dangerous person, you may consider this fact in determining whether he was the initial aggressor.
That's correct.
Okay, so that'll be excised as well. State has no objection to the physical ability section. I'll just remove the word junior after Torres.
oh my goodness.
Any other questions with regard to the 3.6F instruction?
Your Honor, state doesn't object to what we have produced as the final product. I'm impressed we did it so quickly. We just note our objection for the record to preserve a challenge to Martinez.
Understood. Do the parties, well, let me ask this question. Mr. Henderson, anything else we need to address with regard to the 3.6F instruction?
No, sir, I'd just like to preserve the objections that I made during this conference.
Objections preserved. Do the parties wish the court to reread the 3.6F instruction that we just went through, just to make sure we're all on the same page?
Yes, sir. Can we do it at a time where it
Is in final form? Yeah,
Yes.
absolutely. Okay,
Perhaps a written copy that we can take during snack time.
sure, absolutely. All right. Where does that take us now? Does that take us to the 3.6G instruction?
I believe so.
Okay, give me a moment.
Where's Mr. Owens? Mr. I object. Can we approach? I have something to say. Can we delay this trial another 40 years?
I have state's proposed 3G instruction. I have the form instruction from the Supreme Court. And I have the defense's proposed revisions. Just move everything around here. Give me a second. Okay. All right. As to the title, I believe that based on what we've discussed, the or threatened use should be removed. Is that correct?
That's correct.
All right. As to the first sentence, it is a defense to the crimes of second-degree murder and culpable negligence if the actions of Sarah Boone constituted the justifiable use of threatened use, as we're removing justifiable use of non-deadly force. Would be removing threatening, and we would also be including manslaughter, correct?
That's correct.
State?
Yes, sir. It is a defense to the crime of second-degree murder, manslaughter, in Oxford, or culpable negligence if the actions of Sarah Boone constitute the justifiable use of non-deadly force.
I too am a big fan of the Oxford comma. So the defense would, or the instruction would now read, it is a defense to the crimes of second-degree murder, manslaughter, and culpable negligence if the actions of Sarah Boone constituted the justifiable use of non-deadly force. Acceptable state?
Yes, sir.
Acceptable defense?
Yes, sure.
Definition of non-deadly force is not at issue. Next paragraph. Sarah Boone does not have the burden of proving that she was justified in using non-deadly force. Instead, for you to find Sarah Boone guilty, the state must prove beyond a reasonable doubt that Sarah Boone was not justified in using non-deadly force. Acceptable state?
Yes, sir.
Defense?
Yes, sure.
The law on justifiable use of non-deadly force is as follows. Sarah Boone was justified in using non-deadly force against George Torres, excising Jr., and had no duty to retreat if she reasonably believed that such conduct was necessary to defend herself against A, George Torres, excising Jr., imminent use of unlawful force. Is that instruction acceptable?
Yes, sir. I don't know if you mean to include the A if we're not using the B. I would just suggest you make one sentence.
Any objection?
No objection.
Any other issues with the instruction as read so far? State.
No, sir. Thank you.
Defense.
None, Your Honor.
Okay. Looks like there are several agreements with the balance of this instruction as to the defense of property is not applicable, the 776.0134 dwelling and residence and vehicle, and force with regard to law enforcement, all of which is not applicable in the
So
instant
I'd like
case.
to hear what
That takes
everyone
us to the
thinks
give in
the
all cases.
major hangup will
We
be.
would be removing the threatened use of
There's
non-deadly
6
force in
people,
that
remember,
section.
on the jury. 6.
Any other changes is to the given all
So-
cases section.
What do you think the major hangup would be
Defense.
for 6 people?
None, Judge, no objection.
If you were on the jury and you're not biased, this is your, you go back there and you're like trying to decide.
Let's table the proposed instruction on the battered spouse for the moment.
Then the state will be making its request for the forcible felony instruction.
Under Martinez.
Yes, and we understand the court's ruling, and we're sending a strongly worded disagreement to the court's report.
Received and understood, but based on what the court said earlier as to the conclusion in the Martinez section, I'm disinclined to add your proposed instruction.
I understand why.
That takes us now to the 776.0412 section. Looks like we have a little bit of a disagreement here. Is it the same arguments that we received in the 3.6F instruction?
It's the same fact.
Any other additional arguments, sir?
No, Your Honor.
All right, for the reasons previously identified, the court will accept the state's proposed portion as to the 776.0412 instruction.
I would say the biggest hangup is going to be that he got.
And it takes us to the
Suitcase
prior
willingly.
threats.
Same requests and objections as in 3.6F from the state.
I know that sounds terrible, but
For the end of the instruction.
I agree that it should track what the,
and it does seem like it's
Forgive
not a
me.
far stretch.
Other
that they
than
would play
reputation,
hide and seek.
what were the
Just
other
based
issues?
off the
Prior threats
the
should come in.
videos.
Mhm.
Specific acts should come in.
Okay, thank you. Reputation should be excised.
The 2 paragraphs of reputation excised, and then physical abilities gets read in all cases.
Agreed?
correct,
Okay,
agree.
all right. And then we'll remove the threaten language in there, correct?
Yes, that's correct.
I think that some people would just find it hard to believe that
Okay.
someone would get
Any
into a
other
suitcase willingly.
Questions with
then
regard to the
If you look at
3.6G
everything as a whole,
No, thank you, sir.
defense?
No, Your Honor.
Okay. I believe then,
and you see those videos
check
and
my
you
notes.
see how they, played around with each other. Like the video of them, are you filming me, filming you, filming you, filming
I
me?
believe then that addresses those issues based on what we did not discuss this morning in the charging conference. And I think that now takes us to the state's requests in the defense's request for special instructions.
Can we do the battered spouse one first? Conflicting requests.
Yes. We're making reference to the state's request for special jury instruction regarding battered spouse syndrome filed, I believe it was It's not dated, but I think it was either the 23rd or the 24th that you filed these, Mr. J, and the court record will speak for itself as to when they were filed. Okay. Courts reviewed that motion and reviewed the proposed instruction by the defense. State, let me hear from you first.
With their instruction, I think the problem with it is that it kind of blurs the subjectivity component versus the objective reasonable person standard. So if we make this change to their instruction, then I'm actually okay with it. And what I would suggest that change be is in the second paragraph. If you find the evidence that Sarah Boone suffers from battered spouse syndrome credible, you may consider this evidence to assist you in determining whether a person in Sarah Boone's circumstances would reasonably believe that such force was necessary to defend herself against the imminent use of unlawful force by the victim, no junior. I don't know if it's necessary with the date. That makes it clear, because that's what the case law says. The case law makes it very clear it's about the objective component.
I agree with you.
And then I would just ask for my last sentence, which is like other witnesses, you may believe or disbelieve all or any part of the testimony regarding battered spouse.
Let's say the defense. And if necessary, I can read.
Yes, could you do that?
So it looks like there's no, first of all, just so the record's very clear, Stevens v. State identifies the special instruction circumstances. Special instruction is supported by the evidence in this case. Yes, absolutely. The standard instruction did not adequately cover the legal theory it is meant to. There is no standard instruction on battered spouse over and above what's included in the self-defense instruction. The special instruction was a correct statement of law and not misleading or confusing. We're addressing that third prong of Stevens at this time. The proposed instruction would read, you have heard evidence that Sarah Boone suffers from battered spouse syndrome. If you find the evidence that Sarah Boone suffers from battered spouse syndrome credible, you may consider this evidence to assist you in determining whether a person in Sarah Boone's circumstances would reasonably believe that such force was necessary to defend herself against the imminent use of unlawful force by Jorge Torres. It would then go on to read, like other witnesses, you may believe or disbelieve all or any part of the testimony regarding battered spouse syndrome.
Agreeable.
Okay. Appreciate y'all working together on that. Give me a moment to finalize this. As such, the third prong of Stevens has been made, and the court will give the special instruction as identified on the record. Now, the only question I also have is, do we want this as its own instruction, or do we want this included where it currently is in the 3.6F and 3.6G instruction? State.
I would suggest it be 3.65, right after the two instructions about use of force.
I agree with that.
Okay. Do we want to label it or just have it as special instruction and then read it? Do we want to have the title special instruction on battered spouse? I welcome.
I'm fine with just saying battered spouse syndrome. That's fine.
Okay, so it'll be special instruction on battered spouse syndrome. Is that acceptable?
Yes, sir.
Is that acceptable?
Yes, sir.
All right, thank you.
That can't be it. They acted like this was going to be.
And that will follow after the 3.6G instruction, correct?
Yes, sir.
Acceptable,
Yes.
Mr. Henderson?
Yes, sir.
All right, that takes care of that.
All that should be left. Oh, go ahead.
Yes, I'm sorry, sir.
I'm sorry. I think we might be required to read it both times after each one.
I have no problem with adding a paragraph into it that says this applies to both the justifiable use of deadly force and non-deadly force.
That's fixed.
Okay. Where, gentlemen, do you want that?
After the big paragraph that ends with Jorge Torres and before like any other witness.
Sure. Okay, so let's go over that language one more time so that we're all on the same page. Mr. J, what is it that you propose?
To put between the paragraph that ends with Jorge Torres and before the paragraph paragraph.
130.
Like other witnesses, whatever I said.
Mhm.
You can consider this testimony and evidence in the applicability or the use of whatever word people agree on of both deadly force and non-deadly force instructions, something to that effect. If that's too convoluted, I'm fine with it just being repeated.
I tell you what, I'd rather just repeat it.
I think so.
That gets way complicated. I'd rather just repeat it under 3.6F and 3.6G. Okay.
Oh, honey,
that
we have
work for you,
so
Mr.
long to
Anderson?
go.
All right. Thank you, sir.
They have to give closings, rebuttal,
All right.
instructions.
Okay. Moving now to the state's request for special instruction regarding withdrawing from physical contact, filed October 23, 2024. Court has reviewed it. I guess the first question is, is there proposed language?
I'm not
Trying to see
looking
if I'd
for the
actually put that in
closings
there.
for defense.
I don't know that I see it, Mr. J.
Oh, paragraph 15. Physical contact includes any restraint on George Torres, apostrophe, movement.
And this would be after the initial aggressor portion in the 3.6F and 3.6G, correct?
Yes.
Okay. What say you, Mr. Henderson?
If I can have one.
Yes, of course.
Oh my gracious day. She should have taken the plea deal. I mean, I don't know. I got to look up if, who does the sentencing? Does the judge or the jury? The judge. So the judge is going to do the sentencing. Let me see. What is she? So we've been listening to this whole time. What is exactly she's being charged with? Now I gotta re-listen. What are her exact charges? Because I want to know what she's looking at. Now I gotta look at Vinny. Okay, second degree. Okay.
Judge, this is what I'm having a problem with, but I think it can be corrected.
Mhm.
Because they talk about it as, therefore, at the conclusion of the two paragraphs regarding initial aggressor, it should come in not there, but shouldn't it come in? Because that's not there anymore.
I need a standing desk.
Yeah, in the 3.6F instruction, references to initial aggressor have been removed.
Yes, so now is the state asking for it to come in as the initially provoked?
Unless I missed something.
My understanding was that it was the two paragraphs about aggressor are coming in. What's not coming in is the Martinez forcible felony. The facts of the case.
Right, but the language you said at the conclusion of the paragraphs regarding initial aggressor, The words initial aggressor don't appear in the 3.6F. It's only after that. However, the use of deadly force is not justified if you find Sarah Boone used force to initially provoke the threatened use of force against herself unless, and then it's paragraphs 1 and 2. Is that where you're asking it to be?
Hold on, let me pull through.
Sure.
I understand. So in 3.6F,
Mm-hmm.
Oh.
it should be, however, the use of deadly force is not justified if you find that Sarah
What's
Boone used force to initially provoke
Correct.
the
That's what I
threatened
have.
use of force against herself unless, parens 1 and 2.
Correct.
And then after 2, as an explanation for what is listed in paren 2 as from physical contact.
Oh,
just
she could
a
get as little as
elaboration
10
of
years.
What we're talking about.
I got it.
Because
Okay.
the unique circumstances of this case, the remote force.
Okay, I got it. I just want to make sure we're all on the same page as to where. What say you as to the proposed language of physical contact includes any restraint on George Torres's movement as that portion in 3.6F and in 3.6G?
No.
Okay, all right. So court's going to grant the state's request for special instruction regarding withdrawing from physical contact. And the language of physical contact includes any restraint on George Torres's movement will be included after the, however, the use of deadly force language after paragraph 2 in the 3.6F instruction. And in the 3.6G instruction, it will be at the end after the physical abilities section. Also, it's George is spelled incorrectly. That will be remedied.
I thought the 2 paragraphs about aggressor were being mirrored in 3.6G. It shouldn't go after physical abilities. It should go after.
Oh, I'm sorry. You're correct. I apologize.
No problem.
So it says, I just looked
Got
it
it.
up again. It says
That takes us now to the state's request for special jury instructions on causation, filed October 23, 2024.
a minimum
I
of
have
at least
reviewed it
16
and the
3/4
proposed
years
instruction
in
on
prison
paragraph 3
without the
therein.
chance of parole
Judge, the reason we're bringing this up is just
and a maximum
during the
of life.
cross-examination of Dr. Z or Zadovich, we poked the
But
bear a
that's
little
if
bit
they
about
use
his
a
cardiovascular
fishing
condition.
pole.
My memory of the testimony was that she's emphatic that that was not the cause of his death. But because of that, and because of now
I think the
request
minimum
for
is 10
culpable
years.
negligence,
Could be
that
10 to 16
misdemeanor
years.
for a
but-
lesser, I feel it might be warranted to give this explanation of causation in the
But she
second
could get
degree
up to
murder,
life,
and manslaughter.
but that's with the possibility of parole too. So
Defense, what say you?
Judge, I would object. I believe that just the instruction.
and don't forget, she's been in jail for 4 years,
I have.
so she will get that time served
Criminal Act,
probably.
which we have a standard jury instruction that said the death was caused by the criminal act of the defendant, and that's what they're required to prove. This language, to me, would lessen that requirement by saying, but for the defendant's criminal act. Then the second part, when it goes up to George Torres' death, was not beyond the scope of any fair assessment of the danger created by the defendant's criminal act. I think that's covered, Judge, in the fact that the state does not have to prove that Ms. Boone had the intent to kill George Torres. So that makes it confusing to me when the standard instruction basically says.
Well, it's second degree, so second degree.
And it keeps them right where they're supposed to be with that instruction. They don't have to prove that she had the intent. Then as to the third part.
I'll withdraw my request for that.
Okay.
If heart disease gets brought up in closing.
All right, fine. So withdrawn. Court takes no action on the state's request for special jury instruction on causation. That leaves us now with state's request for forcible felony instruction or request
Is
for
not
initial
premeditated.
arrestor instruction.
That's already been,
That's already been addressed, has it not?
I was just treating this as special jury instruction for my argument.
Understood. All right, are there any other instructions sought by the state at this time?
I believe we've concluded this exercise.
Defense.
No other ones.
All right, here's what I'm going to do. I'm going to take all this upstairs. I'm going to re-review it. I'm going to merge it all into one document, and I will send it to all the parties. Let's plan on being back here at 1:30, and we'll address any other concerns of the jury instructions at that point in time. State, anything else we need to address?
125.
Wow.
Well, let's make it 1:20.
All right. Thank you.
Yes,
All right,
120.
defense.
Nothing else.
All right, we'll see you all at 1:20. Thank you.
Wow. Well, they can't charge. They're not charging her a first degree. They're charging her a second, which means she didn't have any intent. So in Florida, second degree is the unlawful taking of a life of a person through an act that was dangerous and showed a depraved mind, but was not premeditated. The dangerous act, the act was inherently dangerous and likely to cause the taking of the life. For example, striking someone with a bottle during a bar fight. Depraved mind, the act showed a disregard for human life. The second degree is a lesser charge than first degree, but more severe than voluntary or involuntary manslaughter. The mandatory minimum sentence for second degree is 10 years in prison, but is 25 years if a fishing pole was used. So the factors that can affect the sentencing include aggravating factors, cruel or brutal acts or previous convictions, mitigating factors, mental illness or a troubled childhood. So that's what the defense is trying to include, are these mitigating factors of the spousal abuse. The aggravating factors, of course, is what the prosecution is trying to include, which are the cruel, brutal acts of Sarah Boone. So they're trying to have it all the ways, obviously. So we'll just have to see. But I'm going to see if I can. So we're waiting on Sarah Boone. She is. I don't know. I hear county is really, really bad, y'all. And I think that's anywhere you go. So here you can see some of their, every defense attorney does this proof beyond a reasonable doubt, does not mean proof beyond all doubt. So they always have that. So I think where the jury, whenever they get this case, again, their hiccup, if they have a hiccup, would be he got in the suitcase willingly, right? So that would be the first hurdle that they would have to get over is he got in the suitcase on his own, of his own accord. Other than that, you again have to take all the evidence as a whole, and then you look at all of the videos, all of the stuff together. Yeah, Wayne County is disgusting, and I've heard so many horror stories about it. I have seen people out protesting outside of Wayne County, and they even oh, you did, Brandy? Is she in there, or she's been in there? I've seen people protesting outside of Wayne County and talking about how bad it is in there. And people whose family members have been in there because they say, and I mean, we've known Michael was in there. Perna has told me how disgusting it is in there. So I can't, and even the new part that they built, they say is just infested with rats and roaches and feces, and it's just disgusting. So I mean, a lot of people have really terrible things to say about I get it, like prisoners, inmates, they say that we shouldn't care, but they're human. At the end of the day, they are human. And some of those people are innocent. So again, we have the whole innocent until proven guilty, right? And if you're in county, you're innocent until proven guilty. Most people in county are not violent criminals. Most people in county are just locked up for speeding or something small. And they're not in there because they did anything just absolutely crazy. But county is a mixture of all kinds of people. So you don't know who you're in there with. It's a pretty scary place from what I understand. So she's been in county, not prison. So she's going to be in for an even bigger awakening when she gets to prison. Yeah. DUIs. And then, I mean, there's people in there for all kinds of things. So you just don't know what you're walking into when you go into a county. Also, I think we brought it up yesterday, but I'm not sure if you guys heard the story about the Walmart employee. Yes, prison I think is better because it is a little cleaner. So, but it's still prison, so no one wants to go there. Snacks. She will get her snacks in prison if someone will fund them for her commissary. I don't know if you guys heard the Walmart story. Let me see if I can find it, but it's absolutely horrific and disgusting. I don't know if they talked about it on. It was in Halifax. Where's Halifax? Is that in New York? They didn't really put this out there too much.
Through these new details that were released
so
today.
Awful.
So, Jacqueline, what we knew to this point was that Halifax police were investigating what they have described as a sudden death of a 19-year-old female employee at a Walmart, and that her body was found at the store 9:30 p.m. on Saturday night. Today, they are coming out in a press briefing, clarifying some more details here, just exactly where in the store her body was discovered. Take a listen.
The female was located in the walk-in oven in the bakery within the store.
She was inside the oven?
Yes, in the oven inside the store.
Do we know whether it was on when she was in this oven?
That's part of our investigation, which is ongoing at this time.
Now, police caution against jumping to any conclusions as to the nature of this death. They say that they have not yet determined the manner in which she died or the cause of death here. To that, they say that that investigation, that part of the investigation could take, quote, a significant amount of time, and that they are working with occupational health and safety in the province, as well as the Nova Scotia Medical Examiner's Office. Jacqueline?
So, Sarah, what more is known about this 19-year-old woman?
Over the weekend on Sunday, the Maritime Sikh Association confirmed that she is a member of the local Sikh community. And in that interview, alluding to the fact that she had immigrated at some point. Her name has not been released publicly. There are flowers outside of the store, notes being left in condolence and in memory of her. As of Tuesday, the store remained temporarily closed. And we know from the Department of Labor in Nova Scotia that a stop work order was issued for the bakery in the store and specifically one piece of equipment. Walmart has said that they are offering support to employees as well as grief counseling on scene. Jacqueline?
Okay, Sarah, thank you. That is CBC's Sarah Galashan.
Oh, y'all, that's terrible. That is terrible. So I didn't know that background. I wonder if it was I did hear that apparently you can only shut that door can't be opened from the inside of that walk-in oven, y'all. So yes, it's a walk-in oven, and you can't get out from the inside, but it can only be apparently locked from the outside. So they're saying that she was locked in there from someone. So I don't know. And now to know that she was a member of the Sikh community is I'm kind of wondering if it wasn't a possibility of a hate crime, because that's pretty disturbing. I mean, it's disturbing anyway, because what the heck? I mean, it just makes me think of like horror films. Like they think of the craziest ways for people to be taken out in a horror film. And that reminds me of a horror film that I watched with Patrick Dempsey, and it was disgusting. So yeah, that would be a horrible way to go. Ugh, y'all. So I didn't know that was in Canada. I thought I don't know why I thought Halifax was in New York. But then we have the kid in, I think I get now, apparently I don't know where the heck I'm at. In Washington that took out his entire family except his sister, who faked her had to fake her own demise in order for him to get caught, because he would have probably been believed.
The King County Sheriff's Office gets a 911 call from a house near Falls City. The 15-year-old suspect allegedly told the dispatcher his brother, quote, just shot my whole family and committed suicide too. Nearly 7 minutes later, a neighbor calls 911 saying an 11-year-old girl came to their door telling them her 15-year-old brother shot and killed the rest of her family. That girl later told investigators that her 15-year-old brother shot her too, in the neck and hand, but she held her breath and played dead, waited for him to leave, then used a fire window in her room to escape. When deputies arrived at the home where the shooting took place, court documents say the evidence led to the arrest of the 15-year-old for shooting and killing his parents, Mark and Sarah Humiston, and 3 of his siblings, 13-year-old Benjamin, 9-year-old Joshua, and 7-year-old Catherine. Court documents revealed the suspect was the only child in the home who had access to the lockbox where his father kept his Glock handgun, which he is now accused of using to kill his family. People who live in Falls City, like Carol Gunderson, can't stop thinking about that horrific tragedy.
Every day, yeah.
As of now, this case is set to be heard in juvenile court. The prosecuting attorney's office plans to ask a judge to move the case to adult court.
Although it's not the same as saying the 15-year-old is being tried as an adult, because state law has different sentencing guidelines for juveniles in adult court.
If the case remains in juvenile court, the 15-year-old could only be held until age 25 if found guilty, which is less than 10 years from now. However, the sentence would be longer if the case moves to an adult court.
The sentence set by state lawmakers is 25 years to life with a presumption of release after 25 years.
The 11-year-old girl who was shot is out of the hospital and is now recovering. The 15-year-old suspect is expected to be in front of a judge on Friday. Steve Solis, King 5 News.
Wow, y'all. That's pretty wild. That's wild that he could I mean, he took out his entire family except his sister. And they're talking about he could be like 10 years. 10 years. I mean, I know he's 15, but dang, y'all. That's wild. And he clearly calculated like calling 911 and faking and saying that his brother did it. His 13-year-old brother did it. And in another video I saw that he actually took the fishing pole and put it beside his brother and tried to make it look like his brother did it. Like by making it look like a red rum and self-infliction. So, and then locked himself in the bathroom and called 911. So he planned it. Like he planned this all out. But oh my gosh. But how do you make it red rum and self-infliction if you're going to take yourself out in the head multiple times? That just doesn't make any sense. So okay, so I'm going to put it on Vinny. Wait, no. Is that Law? Is Vinny on Law and Crime or Court TV? He's on Court TV. Okay, I'm going to let y'all finish watching yesterday's video from China's video. From lunch yesterday.
Malcolm Ponder. He was the bridge inspector for the Florida Department of Transportation. He shared the moment he found the suitcase that contained Gannon's body under the bridge in Florida on March the 17th. Let's watch. Now, I am going to warn you that this testimony is probably about 8 to 10 minutes long.
Over, the suitcase was right next to the edge of a bent where we were taking the measurement. Had it been in the middle of a bent or in the middle of a span, we may have not even noticed it. But because of its location, it was right next to where we dropped our profile tape, is what we call it, to take the measurement. We immediately saw it as soon as we dropped it down.
And so I'm not a Navy guy. When you say deck, are you talking about the road area of the bridge where the vehicles go?
Yes, sir. That's what we call the deck. We take our measurements at the top of the barrier wall and over a bridge. The concrete walls on the outside is where we take our measurements from.
And so are you and Mr. Goins looking over the edge of the bridge and you see a suitcase directly down below?
Yes, sir.
What side of the bridge are you on, the eastbound lanes or the westbound lanes?
We're on the eastbound lane and we were on the east or the right side of the structure.
And so you note that there's a suitcase there, but then you go on with the inspection?
Yes, sir.
And tell us about that. Do you go all the way across the bridge and then work your way back, or how does that work?
We'll generally, when we're taking a profile, we'll start at what we call the near end, which for our reference is we work from west to east or south to north. In this case, we were working west to east. We started on the right side of the bridge heading east. When we finish that profile, then yes, we do turn back around and we work from east to west back to where we started. And that's when we get into the truck and start our under bridge inspection.
And when you start your under bridge inspection, is that when you get back to the area where the suitcase is?
It wasn't for, no, sir. It wasn't for probably roughly an hour, hour and a half later, maybe even a little bit longer, because when we started the under inspection, we start back at the beginning of the bridge. Okay. And where we found the suitcase was almost at the very end of the bridge.
And this bridge goes east and west, is that right?
Yes, sir.
So you're starting the undercarriage portion on the east side, working your way west, is that right?
No, sir. We're starting on the west end, working towards the east.
Okay. And so what happens when you get back to that area where the suitcase is?
Because of the profile and as the bridge, there's the hump in the bridge. When we got towards the end of the structure, the bridge starts to become lower, closer to the ground. And at that point, we didn't need the truck anymore. So we were able to lower the basket down to the ground line and get out, and was going to finish our inspection from there. And that's when we lowered down to the ground, we remembered that we had seen the suitcase. We finished up our inspection and then went back to the suitcase.
And why did you go back to the suitcase?
Pure curiosity.
Okay. And again, is Mr. Goins with you at this point in time as well?
Yes, sir.
So what happens when you get back to the suitcase?
We got back to the suitcase, and where it was lying kind of an odd angle, but the handle was towards the underside of the bridge. So I reached out for the handle and immediately noticed it was very, very heavy. And I looked back and remember telling Matt, I said, I don't know what's in this. I said, but it's heavy. I said, and where it was at, it had a possibility of being waterlogged. We didn't know if there was clothing or something in it. We just noticed that whatever it was probably waterlogged and saturated, just due to how heavy it was.
And I imagine you get a lot of rain in Florida?
Yes, sir.
Do you get a lot of rain in the months of February and March?
We can. March normally is fairly rainy season, but again, where the suitcase was really right at the edge of the marsh, and depending on tide, you don't necessarily have to have a lot of rain for that area to be influenced by tide.
Okay. So you, Mr. Goins, get up to the suitcase. You said it appeared to be heavy. What happened after that?
Because of where it was at, it was very, very marshy and muddy. We, of course, didn't know what was in it, but underneath the bridge where it was at was very flat and sandy. And we kind of made a decision, let's pull it out of the mud and pull it underneath the bridge where it was flat and sandy, and whatever it was in it, we'll just open it there rather than in the muddy marsh, just sticks and a lot of sticks and stuff there. So we pulled it underneath the bridge.
And what, did you open it?
Yes, sir.
Tell us about that.
I was the first one to unzip it. And before we opened it, as soon as we unzipped it, we immediately noticed the smell. That's what hit us first. I remember looking up at Matt, who's quite a bit taller than me. And I said, Matt, I think there's something dead in here. And unfortunately, we do come across, sometimes somebody will throw out a litter of puppies or something in a bag, and that's not uncommon. And it smelled, but it was so strong. It was different that day. So I didn't initially open it, and we kind of thought about what we were going to do first. When we finally went ahead and unzipped the rest of it, the smell was so overpowering. We kind of took a step back. And the first thing I remember seeing was just 2 little feet, and that had little football socks on them. The best I remember, I remember there being little socks on them. And before anything else happened, we couldn't really make out what it was. Matt dumped the suitcase over, and of course we initially immediately knew it was a body. But after looking at it, it was we couldn't tell male or female, boy or girl. We didn't know. A lot of black hair. And then I turned away.
What was the size of this suitcase? Do you remember?
Roughly the size of a checked bag. It wouldn't have been it was too big to be a carry-on, but roughly the size of an older checked bag suitcase.
And was there anything else in the suitcase besides the body?
Lots of blankets. There may have been a pillow or something. I just remember a lot of bedding in there and blankets. It was kind of the body was in a fetal position and partially wrapped up, so we couldn't tell a whole lot until we dumped it out. And again, I turned my head.
What did you do after that?
Walked away. I immediately said we went ahead and called the inspection right there. I didn't have my cell phone with me. Matt did at the time. He's a volunteer firefighter, and he's dealt with some of this stuff, and I was very thankful to have him there. We immediately dialed 911 and got them on their way. And then I walked up back to the top of the bridge and talked to our truck operator and told him kind of what was going on, that they were shutting it down. And then just waited for authorities to get there.
Okay. And did members of the Santa Rosa Sheriff's Office eventually show up?
Yes, sir.
Now, FBI agent Jonathan Grusing was called in by prosecution to assist with the location of Gannon. He testifies that during the interview with Letitia, she showed more concern for herself than finding Gannon. FBI agent John Grusing testifies that Stout checked Google, "I don't like my stepson," and blood spreading from arterial bleed in the past. He, along with Agent Coron, worked with Al, and he agreed to have his phone calls with Letitia recorded in the hopes of finding Gannon. Agent Cronin also testified that Letitia told multiple stories during her recorded phone calls about what happened to Gannon. During the multiple calls, Letitia and Al argued and talked about the events surrounding Gannon's death. Al was coached by FBI agents during these calls of what questions to ask Letitia. The goal was to keep her talking to get as much information from her as possible. Now, in one of the calls, Al confronts Letitia about Quincy Brown. Now, Quincy Brown was the person, or one of the persons, that Letitia claimed assaulted her and took Gannon. Now, FBI learned that Quincy Brown was wanted at the time of Gannon's disappearance in El Paso County for not registering as a sex offender. And he was in Mexico at the time of Gannon's death. And Letitia learned when she learned of Brown is when he appeared on local news as a wanted man. At this point, Letitia tells Al another story to cover her life. She admits that Brown wasn't involved and that Gannon was abducted from her car while she was at Petco. Letitia even go as far in one of the recorded calls and accusing Landon, Gannon's own mother, of taking Gannon out of the country. In many of the calls, Letitia gets upset at Al for not supporting her and letting her live with him during the investigation. She was also upset that Gannon's mom was staying at the home while searching for Gannon. Through every phone conversation, Letitia continues to claim she's in Colorado, despite having left Colorado to South Carolina weeks earlier, according to numerous pieces of evidence shown throughout the trial. Now, Dr. Torres, one of the forensic psychologists who conducted Stouch's sanitary examination 2 weeks after she arrived at the mental hospital, testifies that she believed that Letitia was lying about having dissociative identity disorder, and that this is all seemed too far-fetched for her. So She sat in the room and she's interviewed her and she's listened to her and she's performing. And she just felt like it was all too far-fetched. Dr. Torres said during the 2020 evaluation, Stouch never mentioned being psychologically hospitalized. Dr. Torres said during the sanitary evaluation in 2022, Stout said she was hospitalized in Canada, but wasn't able to tell them what hospital or in what city. Really? Now, Kevin Clark, a former analyst with the Colorado Springs Police Department, talked about Letitia's Google searches and her online history prior to Ganon's disappearance. Now, these are some of the things that he talked about that she was searching. Need a fake ID legit. Several searches regarding face transplants or plastic surgery. What do they do when they find a body in another state? How do they identify bodies found in other states? Spanish girl names. How long before a body starts to decompose in a bag? And how do people avoid the FBI? He also gave more insight on the search that Letitia did for fakepolygraph.com. He explained that when Letitia entered 5 questions to make her look innocent at the end of each question, she was given the option to click pass or fail. After Letitia paid for the test, it was learned that she Googled, "Can you get away with a fake lie detector test?" Many others took the stand as witnesses for the prosecution. But let's talk about Dr. Susan. I'm not going to mess up her last name. She was an associate medical examiner. She testified that during Ganon's autopsy, hydrocodone was found in his liver. Now, Al had testified that those meds were prescribed to him due to an accident that involved him cutting off his finger. Now, only him and Letitia knew where those meds were located, so it is believed that at some point before Ganon was murdered, Letitia administered those drugs to him. She also noted that Ganon had 18 sharp force injuries, 4 lacerations due to blunt force trauma, and 1 gunshot wound to the head. Now, many of Ganon's wounds were on his arms and hands, suggesting he was trying to defend himself. However, she suggested that the blunt force trauma injuries the gunshot wound was the ultimate cause of his death. Even though she had drugged him, Ganon tried to fight for his life. During the entire trial, Letitia didn't shed 1 tear, or she didn't show any amount of remorse. Instead, she decided to be disrespectful to witnesses by sticking her middle finger up during testimony. Let's watch.
384.
People's Exhibit 384 is now a close-up photograph of the possible blood stains identified using placard B.
Our positive reaction photograph after the bag had been removed.
457.
We've rotated slightly to the east. This is a photograph of the southeast corner of the garage, highlighting those boards and the box directly south of the boards.
It's come to our attention that during I think mostly the afternoon session of witnesses today, that the defendant has been flipping the bird potentially to witnesses or to our family that are here for Ganon. And there have been pictures that have been passed to me during this process. One, it's disrespectful to this court. It's disrespectful to this process. And I would ask the court to admonish her to refrain from acting this way in the future during the pendency of this case.
Okay. I've not seen any of that, but on the other hand, the defendant is to my far right. I can see her some on a screen, but I'll just take it as is. Ms. Stout, what you need to understand is that I can control the conduct of an awful lot of people in the courtroom, including yours. And don't do that. Don't show that kind of, don't be making disrespectful gestures to witnesses, to people, to family members, anything like that. You need to understand that if that continues, I can have you removed and the trial will continue without you. And you will sit in a holding cell in this building And every time we take a break, I'll bring you back up to ask whether or not you can conform your conduct to what I'm requiring. If you choose to act in a disruptive behavior or disruptive fashion, I'll just have you removed and we'll continue on without you. And then we'll check and see if you want to come back and behave in a respectful manner. So I'll just leave it at that. And we will see where we are on Monday.
Now, the prosecution rests and the defense provides 2 witnesses to help their case. Now, they never said that Letitia didn't kill Gannon, but they claim that she had a psychotic break. And this brought on as the reason why she killed Gannon. Now, supposedly, this break is due to years of suppressed trauma from childhood abuse. This witness here, to me, was a mess. She was late for court every day of her testimony, and she was never prepared. It was even found testimony with Letitia, during her interview with Letitia, her son was present in the room. And she claims that she doesn't know who this person is when she is questioned. So definitely the prosecution brings up to her, they definitely bring it up on cross-examination about the person in the room. And she claims that she doesn't know who the person is. And it's clearly seen on the video that it's her son. When she gets on the stand and is cross-examined by prosecution, she is tested on her credibility. Dr. Lewis claimed that during her 14-hour interview with Stout, she seemed to shift into different personalities when they would communicate, and sometimes that Letitia would identify herself as Maria. Now, Maria apparently was a physically abusive personality. So when Maria came out, she was angry, and that she began to believe she was actually talking to this person that killed Gannon. Dr. Lewis testified that she found Stout to be insane at the time she allegedly killed Gannon, and that she diagnosed Stout with dissociative identity disorder. Now, the first psychologist that the defense team had, and this psychologist had 2 different reports on Letitia after meeting with her. The first one believed that Letitia was suffering from anxiety disorder, but she didn't observe any signs of her being psychotic. This one is saying totally the opposite. So I'm not for sure why the defense team will bring on 2 psychiatrists that are saying totally 2 different things. I don't see where this helps their case at all. May 8, 2023, finally, Letitia is found guilty of all charges. Now, the family didn't want to wait for sentencing, so the judge agreed to continue with her sentencing. Let's watch.
Letitia Stout guilty of count number 2, murder in the first degree, child under 12, position of trust. With respect to count number 3, charge of tampering with a deceased human body, we, the jury, find the defendant, Letitia Stout, guilty of count number 3, tampering with a deceased human body. With respect to count number 4, charge of tampering with physical evidence, we, the jury, find the defendant, Letitia Stout, guilty of count number 4, tampering with physical evidence.
Hello, Your Honor. My name is Landon Bullard, also referred to as Hyatt in this case, but Bullard's B-U-L-L-A-R-D. I miss you, Gannon, and I love you to the moon and back again. I know every day you're with me and your sisters, but that will never be taken away. The ache that I have for you, to hold you, to hug you, to tell you how much I love you, and to see your smile and your innocence. I remember all the pain your dad and I suffered with having children. It was never easy, and we were always fearful through the process. On September the 29th, 2008, our lives were forever changed. Our first biggest blessing came into the world, weighing only 1 pound and 6 ounces. You fought all the odds and developed a personality and a smile that's larger than life. You became my hero that day. You forever changed my heart and my life, and that will never change. That is something that can never be taken away from me. You came into this world fighting. And unfortunately, you left this world fighting. Your Honor, she fought against someone that he loved and trusted. Someone that myself and Albert both trusted and loved. Someone who can never understand what it means to love or trust anyone but herself. For more than 3 agonizing years, I've often wondered what I may say, or if I would even be able to. For 3 years, I have questioned every single possibility and scenario. For 3 years, I have tried to forgive you, but I can't. I want to. But no parent should have to bury their child. No parent should have to see or hear the horrific things you have done to the whole family. She has taken away the most precious gift in this world. Not just my family, not Al's family, but your own family. She destroyed dozens of lives of people who never wanted to believe that she could have done this. She knew how special Gannon was, and she knew what meant to most to me. I, in my heart, can never understand her hatred and insecurities. When it came to me, I did love her. Mother to mother, I trusted her with my children while trying to survive a complicated life with my 3rd child. And she used every opportunity to write a narrative of my life to try to take pieces of my life. When she already took some of it, that still wasn't enough. She searched. I lost my place. I don't know where I'm at now. She searched so hard for love when all along she had it, but she took it for granted. I didn't hold anger against you then. I still kept my heart open to her. You had so much love from Lena and Gannon, from Harley, her own daughter, that you willingly subjected to the chance of serving time for her crimes. Such an indicator of her inability to love anyone herself. You had support, appreciation for me, even when we couldn't see eye to eye, because I valued her for helping me with our children when I physically couldn't. Even when I was fighting for my kids, as you wrote, a false smear campaign against me and my children, and also Al. For me, I still appreciated that they were loved by you. So I thought. She had everyone fooled. She projected abuse and addiction claims against all of us, not just me, when all along she was the one harming innocent children. Anything to take the light off.
And we're back. We're going back to Sarah Boone. Hello, hello, hello. Welcome everybody back. Welcome to the alternate point of view. I am Tracy Lee. Thank you all. Hope you enjoyed your lunch. Hope you enjoyed that video, well, portion of it. One of my subscribers, she has her own channel. She does amazing recaps of cases So definitely check her out. But we are back, you guys, to the Boone's Farm madness of Sarah Boone. So I hope you guys are back with me. So the judge and the lawyers are going to come back and go over these jury instructions. They're going to make sure everybody's on the same page. The jury instructions are typed up correctly and everyone is in agreement. I thought the jury instructions were going to be a little bit more complicated, especially with the battered spouse, but apparently it turned out to be a lot easier than we expected. So, and then it's going to go to closing arguments. The jury is going to deliberate into the night. So here we go. It's finally happening. I just don't know how long the closing arguments are going to be. We're going to fingers crossed for between the two. we're going to hope 3 hours. We're going to hope they're going to be done by 5. That's what we're going to hope for. Oh, wow. Okay, so it looks like in the Leilani trial, they have decided to resume deliberations tomorrow. So let's see. Hold on. Let me see what's going on.
Jurors listened to 9 days of testimony and closing arguments today. What's it been like in the courtroom today?
Yes, in closing arguments, it's clear that both the prosecution and the defense were focusing on the first 4 counts of the indictment. That's the murder charges and the concealing a death of another charge.
That's my biggest fear. You're going to base it on emotion or something that's not completely or at all relevant to the issue.
Leilani Simon's defense attorney pleading with the jury that there is not enough physical evidence in the case to convict her on murder or concealing the death of another, pointing to testimony that a forensic examiner couldn't determine how Quentin died. Prosecutor Tim Dean warning the jury that that's exactly what Simon wanted when she killed Quentin.
If you do that, you're bringing her plan to completion.
Dean spent almost an hour and a half demonstrating the timeline of the night Quentin went missing for the jury, putting a bow on the narrative that the state says almost 40 witnesses and 100 pieces of evidence proved. That Simon's relationship with boyfriend Daniel Youngkin was in turmoil, so she was having an affair with her drug dealer to get male attention. When her drug dealer wasn't available that night, she got high and snapped, killing Quentin and throwing him in a dumpster.
She seriously underestimated and did not understand the capabilities of people like the Chatham County Police Department and Detective Lemons, agencies like the FBI.
Quentin's remains were ultimately recovered in an area of a landfill that investigators say was traced back to the dumpster Simon admitted to being at in the early morning hours the day she reported Quentin missing. Still, Hilliard casting suspicion on Youngkin and saying again that the state hasn't proved the murder or the concealing a death charges.
And here's the thing, ladies and gentlemen, about the burden of proof and circumstantial evidence. When there's a tie in the evidence like that, the tie goes to the defendant every single time.
The state leaving the jury with a powerful message about Quentin before the jury headed for deliberation.
But what we can do for baby Quentin now is give him justice. He deserves justice. You can give him the justice he deserves, and you can give her the justice she deserves.
Jury went into deliberations around 3 o'clock this afternoon, and I just got word from the courtroom that Judge Stokes has called the jury back in, not because they've delivered a verdict, but because they are requesting a copy of the indictment against Leilani Simon, and because they are asking to go home for the night and resume deliberations tomorrow. There is no official decision yet from Stokes, but I'm being told that it seems
Sorry. That was yesterday. It said 3 hours ago, so I was like, what? They already wanted to go home? Okay, so that was not today. I was wondering, I was like, what? How could they already want to go home? So we're still on verdict watch. Okay. Okay. Sorry, I lost connection. So now I've dropped, everyone is lost. Sorry. Sorry. I accidentally hit the wrong button. Now I have to start all over again. I'm back now. Everyone come back. Sorry. Well, it might just be the four of us, whoever the four of us are. Just lost everyone that was watching. That was my fault. Oh, gracious. Yep. Gwen's here. I'm here. The other 80 some odd people that were on here are gone. Sorry. I messed that up. Hopefully people will find it again. Okay, we are waiting for them to come back from lunch. I know when you have a bunch of people on here, people want to stay. But then when they only see it in the live, they dip out. Now we're down to 2. It's just me and you, Gwen. Now we're back up to 3. Okay, I'm sorry. I lost the connection and it messed up the live. Hopefully it will bring it back up. People will see we're back. Sorry, y'all. Messed up the live. We are waiting for jury instructions and closing arguments. It was literally gone for like a second. But I have a cute dog now. Who has the breath of Satan. Oh, you were never disconnected, Gwen? I don't know. I guess everybody got, I don't know. Oh, you're here, Brandy. Okay. I don't know who all's here. Hello. Welcome to the alternate point of view. We are watching Sarah Boone. Well, actually, we're watching the Great Seal of the state of Florida right now. We're still waiting for them to come back from lunch. And I'm trying not to die here in my clofus with this, my dog's breath. This is Neo. As you can tell, I love Keanu Reeves. So my dog's name is Neo. But he clearly does not deserve to have Keanu's name because his breath is atrocious. Oh my gosh. And yes, I have tried everything. Yes, I noticed that. Yeah, that leg was way up in the air. I was like, how rude. Thanks, Brandy. I can't believe I hit the wrong button. Well, yes, I can. I can totally believe I did that. Yo, dude. Look, she's just being the animal that God made. All right, court. We're behind. We're 7 minutes behind. Well, yeah, you got to have that. I mean, there's one thing you can't control, and that's what an animal does. And what comes out of a kid's mouth. And usually what goes in their mouth, because they try their darndest to put stuff in their mouth that doesn't go in there. I'm going to make sure I have the mute button. Oh, see, I knew I didn't. Before I hit the wrong button on something again. Well, hopefully everyone will come back, or they'll find the alternate point of view, or they'll find me when they search Sarah Boone or Livestream or something like that. So we are looking at second degree in this case. You have a whole farm up there, Gwen. I just got my 2 dogs. Neo is loud enough. He barks at the lawnmower man and the dumpster truck. Other YouTubers, like, they have this, their dogs and cats, they're so good. They just sit there. They look all cute and lay there all quiet in the background, you know. And my dog just loses his mind at the drop of a hat. And not other YouTubers, no, their animals are just like chill, relaxed. They look almost fake. But mine, no. He's good for the most part. Yeah, I would have a bunch, but they get bored. Like, he gets bored. They don't like when I sit in my office. Augie can't stand it. He does not like going without attention, but he just lays in the other room all lonely. Neo has to be like right up under me the whole time. Or sitting in my lap. He likes to have his camera appearance every now and then. But because he's so bored all day, he is up all night. So hopefully this trial will, I don't know. I did not realize until seeing that video about Leilani that they did not have any actual evidence of her hurting Quentin. So that is what's taking so long. They don't have any is that what the jury's questioning, I guess? It's just all circumstantial. But I mean, how does she explain that? I mean, she called 911 and reported him missing. Oh, they used an ADT to prove she went out a door. Oh my gosh. Yeah, I call it my closet. Yeah. I'm in a closet. I'm in the closet, Brandy. Oh, her boyfriend called. So, but are they saying that she went on TV? I did see the TV appearances she made, like asking for people to help find him, and that if she had anything to do with it, she would turn herself in. Yeah, I haven't really looked into that case at all, so I really don't know a lot about it, but yeah. So they're using ADT alarm too. I mean, I just like, it's not evidence though. I know, but I like my cloffice setup. I just wish that I don't like sitting. I can't sit. It hurts my butt, my left butt cheek. Y'all know that. My left butt cheek is Are you serious, Gwen? That's wild. But yeah, I did see that, the vomit, but how does that connect her to harming him? I guess I just have to look at the evidence because I mean, at least in the, was it Robin Howington? I mean, at least that crazy chick cried. Like she was crying and squalling like a baby the whole time. Yeah. Yeah, I mean, even in the Robin Howington trial, she was a squaller. She was an ugly crier. Well, yeah, I mean, yeah, that would make sense. I mean, that doesn't surprise me actually. It's not. Yeah, that Howington lady was messed up in so many ways. Oh, dang, Brandy. Yeah, that Howington chick. I can't believe. I mean, it's just the whole story is unbelievable for her. There's no way. There's just it's not possible. And what's sad is they're going to have to go and do studies now with 2-year-olds to see if that's even a feasible thing. Like, what 2-year-old are you going to traumatize to do that study to see if you can even, if it's even possible to pull a stool up to a closet and reach for? I mean, it's not. I just don't even know how they would do that type of study. Okay, we're almost 20 minutes late, you guys. 20 minutes. Hello, welcome to the alternate point of view. Sorry, we got disconnected for a second. So if anyone is joining back, welcome back. Yeah, she's a terrible person. And then she even testified. I mean, and Leilani chose not to testify, which I thought she was going to testify because I did see her stand before the judge and I was like, oh, she's going to testify. Because most of the time that does not work out well. Oh, dang. Wait, what? I got to look back at that. Wait, he drug a stool from the kitchen, though. All the way from the kitchen to the bedroom. In heels? That's wild. Okay, court. You're waiting patiently. My sister just signed the closing on her house today, y'all. It is official. She is a homeowner. And I am going to Arizona in a couple of weeks. I know, right? I'm so happy for her. She just did her closing today, and she is going to be hopefully moving in this weekend. Hopefully by the time I get there, all I have to do is pick out my stuff. She's got a pool, and it's Arizona, so it's still hot. I know, right? And you know, in Arizona, all their yard, they don't have fences; they have concrete walls. So, luckily, nobody will have to see this in a bathing suit. So everyone is spared. Not that I get into the pool anyway. She's so excited to have a pool. Oh, you can't. I'm voting Monday. I'm going when I go get my hair done. I'm going to go vote. I'm so excited. Again, I cannot say enough. If you are registered, please vote. Very, very important. I'm so excited. Yeah, I just can't say enough. Like, again, please pray for the whole world, you guys. We are in a debacle right now. At all these countries that are fighting each other. I'm highly concerned about my home country that, they are talking about sending troops to Ukraine and weapons to Ukraine. They're talking about changing entire legislation to do that, and that is just insane for South Korea to do, because that will change the entire landscape of everything. So, oh, that's right, Gwen. It is your birthday. Yes, my sister actually has grass in her backyard. She got the whole shebang. She got grass. She got a pool. She got this beautiful covered patio with beautiful patio furniture. She got fruit trees. She got a garage, and she got a color. Her house is a color. It's not salmon. So she actually got like a really great deal. Yeah, so yeah, she got all of that stuff. So it's great. All right, Gwen, what are you going to do for your birthday? I love birthday cake. Gwen has a birthday tomorrow. This is great. Maybe for your birthday, Gwen, there'll be a verdict in for Sarah Boone and a verdict in for Leilani. What kind of brownies, Gwen? That'll be nice. Speaking of sons, I need to call and check on my son. I have not talked to him all week. It's so random. Uh-huh. Caramel swirled. Oh yeah. Yeah, Trump was there yesterday. My sister was gonna go see him. Yeah, and he was also like he was in like 4 different states yesterday. I don't know how he did it, but he was all over the place. Yeah, I'm hoping to see Tucker and Charlie Kirk in December. Well, I love the Cartiers. Oh my gosh, they're such good guys. I love them. I've been following them since before they had anybody. When they were just in a yes, when there was a whole bunch of them in a small little room before they have their gold YouTube plaque. Ah, they're such good guys. I just love them. Yeah, I've been following them. They had Vivek on their show. Oh man. So excited for them. Yeah. They're such a good group. I really like them. Yeah, I've been watching them since before they had like hardly anybody following them. Such a good group of kids. Yeah, I like them. I watch them all the time. I remember when they just had a laptop and they were just using a laptop to show their reaction videos, and now they're adorable. I don't know what that is, Gwen. See, now you guys are talking about making stuff again and cooking stuff. So who's coming there for 3 different events? I used to like Crowder, but I don't really follow him much anymore. Oh yeah, caramel apples. Man, I haven't had caramel apples in forever. Oh yeah, I saw that. Yeah. They've really like risen up. I'm really proud of them. Oh, like funnel cakes. Okay. Oh, Temple. Yeah. I don't really listen to Temple. Yeah, it's almost I don't know what's taking. I knew it as soon as Owens got back. This was going to take a while. After they've already written up the final. Yes. I really messed up my boy, just glitching for that second. I just really messed up my whole live. I know. I looked up a picture of him, Brandy, and I was like, ew, that's not. No wonder he's always wearing that beanie. Oh my gosh. Charlie LaDuff is in a graveyard talking about there are 16,666 people actively registered to vote who are over the age of 100. In Jocelyn, Benson, Michigan. That is wild. Yeah, well, Dave and then his wife. I kind of got away from Crowder when he and his wife had that situation in on their back patio. He was quite abusive, verbally abusive to her. And I was like, ugh. Like that's pretty rude. Oh, really? Because that's election lies. Those terrible, terrible lies. Cannot say that out loud. Voter fraud? What? Those things are hideous, Brandy. They're everywhere down here. I swear. That was an arm and a leg just to show that rich people will pay an astronomical amount of money for the most god-awful looking thing just to say that they could afford it. I mean, those trucks are disgustingly ugly. I can't stand Dana Nessel. She's disgusting to me. The fact that she doesn't want to solve Samantha's death is absolutely disgusting to me. She supposedly was her friend. My entire half of my body is falling asleep because this dog. Yeah, Slotkin they're all shady. Like, people don't understand, but like, though, all of those people have to be voted out up there. They have to, because they're not good for the state. And they're literally like, they are the reason that so many people are being put in prison wrongfully. Yeah, I mean, all of those people up there. Oh my word. What in the devil? Okay, boo-boo. Okay. No such thing. It's fake news. Fake news. Okay, I have to stand. My dog just put my whole lower half of my body to sleep, sitting on me. Oh my, now my dog's upset with me because I made him get up. Okay, Mark Jacobs. You didn't make it. I wonder why you didn't make it, Mark. What did you say? Hey, so when I very first moved to Austin, like back in whenever ago, I saw my first Tesla, and I wanted a Tesla, not the Model S's or the normal ones everybody sees. This was a coupe, and it was a convertible coupe. Okay, it was beautiful. And I took a picture of it and sent it to my boyfriend and was like, "What is this car? I have got to have one. It is so beautiful. I've got to have it." He didn't even know what it was. And it was only here. Had never seen one. I mean, mind you, I was from dang Alabama, and even in living in Charlotte, North Carolina, had not seen one of these cars. And I sent him a picture. I was like, "I want this car. I want one." And I looked it up, and we looked it up and found out it was like over $100,000 for that car. And needless to say, I never got to have one, but I always wanted a Tesla. And then I moved to Austin officially years later, and every other stinking car here is a dang Tesla. Hey, Kirsten, welcome. How have you been doing? Guten Tag, guten Tag. Ah. Finally. Hello, hello. We are back.
We're back on the record. Case number 2020 CF 2603, State of Florida versus Sarah Boone. Limited appearances for the state, please.
Dave Ketchcore on behalf of the state. Will J for the state.
Defense.
James Owens for Ms. Boone. Tony Anderson for Sarah Boone. Coming back over here.
Ms. Boone is seated at counsel's table wearing the same clothing
And
from
you
this
missed a
morning.
good day
I
yesterday,
apologize for my
Kirsten.
lateness. I realized that there were some typos after I'd sent this to print and needed to take them all apart to fix it. So thank you for your patience as we work through that. State.
We noticed that in the non-deadly force,
Page 12.
there was a couple strike-throughs with the use.
I saw.
However, there was also a mistake with leaving a paragraph about reputation in at the very end of the 3.6G, and that should have been a mirror of the relative physical capabilities of the parties.
I do see that.
Other than that, I saw the he, she bracketed still.
I fixed that on page 16.
Then it's just that one, I think that Mr. Henderson and I noticed.
Okay, all right. I can have Madam Clerk start fixing them here.
Yeah, I think we should proceed and get going if we can.
But they will have nothing in their hands.
All right. Well,
That's the issue.
all right. Let's face that one.
Sorry.
Oh my
All right, thank you.
gosh.
Just give us a minute to fix all this.
Lord have mercy. It was really, you know what
And just so that I'm clear, back on the record, we're referring to the bottom of page 12,
was hard,
3.6G,
Kirsten,
paragraph 2, where the use is struck through, correct?
the staircase part was hard. I actually
And then we're
jumped
referring
back.
to
um
the top of page 13 as to that 2 lines as to
because
reputation.
I
Is
was
that
actually
correct?
the way she was egging him on. They're finishing up the jury instructions
Pull back up to
right now.
3.6G.
It took them forever to agree. They've been working on jury instructions since early this morning. Yeah, yesterday was tough. And then the video where he was saying how wonderful she was, that she was the best thing that ever happened to him. And then he said, God will prevail and he will get us out of this mess. It was seriously like a dagger to the heart, because I
That
was like, you
reputation
just
paragraph
have
should
no
be
idea how God
removed
is going to
in its
get you out of
entirety,
this.
and it should be the
Yeah, it was heart-wrenching, because I was like, man, Jorge, if you only knew.
Thank you.
She was a horrible, horrible person.
10, 12, and 13. Thank you.
But it showed that Jorge was a very sweet, submissive, sad person. It was, she's a terrible person. She ripped up his birth certificate. She was very, very mean to his family, to his daughters.
Correct.
She was very mean. And she was the one saying that she thought that, yes.
Was there anything else other than that? If you find Jorge Torres had a reputation for being a violent and dangerous person, you may consider this fact in determining whether he was the initial aggressor. Anything else that needs to be added to the jury instructions from the state side of the ledger?
The reputation should be deleted.
Correct. I agree with you. Yes. I'm sorry. What the heck? What's going on here?
So many jury instructions. So
That's correct.
yeah, she definitely, again, as I've been saying a lot, she had all the power. She had the car, she had the house, she had the money, she had all of his personal information, his birth certificate, she had the phone. He didn't have the code to get into the phone. He had to hold the phone up to her face in order to use it. He wasn't allowed to call his family unless she said so.
Mr. Jay, was there another line that we had added to the end of that?
And even his daughter said that whenever he would be on the phone with them, she would be in the background. Like he couldn't have a conversation with them without her basically listening in.
Where it should be.
Okay. Maybe that's what I was making. Maybe that's what I was thinking of. So the sentence should read, in considering the issue of self-defense, you may take into account the relative physical capabilities and capacities of Sarah Boone and Jorge Torres. Is that correct?
Yes, sir.
All right, thank you. Correct. It matches 36F now. I apologize. I'm going to have Madam Clerk, I'll email it to her now, have her print out pages 25 copies of 12 and 13, and we'll start taking apart our jury instructions and re-adding them. I thank you for your patience. 12 and 13, that's it.
Yeah, I don't know what our next trial is, you guys. You'll have to remind me. But I don't think I can do another DV YouTube kind terms for a while. That was too much for me to listen to. Especially when someone is not really a victim. Not a true victim. I do believe they had a toxic relationship, but I don't believe that she was the.
Mr. J, are you going to be utilizing the verdict form in closing?
I am not.
Mr. Owens, are you going to be utilizing the verdict form in closing?
Where's is going to be?
Oh my gosh.
Very good, sir. Thank you.
Judge, when you get a chance.
No, go ahead, sir. I can multitask.
I know there's a mic here. I know there's a mic right here.
I will confirm with court admin that microphone is on. I believe it is. They turned it on during openings. I'll confirm now.
And then, Judge, last time I used this
Yeah.
fingerprint table as my podium.
That's fine.
I may just slide it back so I'm.
That's fine, sir.
And then, Judge, I've got 2 tripods. And I've got some demonstrative aids. One is this, it was originally a quote by Dr. Michael Brannon.
Okay.
Okay, may proceed. What are the other enlargements, sir?
It's it's the one I tried to get in.
I hear no
an
objection.
Opening, which was the justifiable use of non-deadly force.
No objection.
Those 2. And then, you remember my reasonable doubt? I was using it for.
You've seen them?
I
Okay.
had no objection to those 5. I didn't like the 3 charts. The defense agreed that we kind of reasonable doubt charts they won't use. So I think we're all good on your charts.
All right, very good.
And the only other thing I want to use.
We're good with their demonstrative aids during closings that we were used during trial.
Okay, very good.
I've got 2 videos that I'm going to want to play, and Shelby Andrews is going to walk up.
They're in evidence, right?
They are.
Yep.
Okay,
One of them's been pared down.
that's fine. As long as it's in evidence, you can present whatever you'd like.
And Judge, do you want to talk about time for closing?
We can. What do you think, State? You advised an hour and a half.
Yeah. I think we both said hour and a half.
Oh, I don't know when that's going. You know, I am interested in what in the world.
How much do you anticipate, sir?
Well, Judge, she's charged with murder. We've had a 2-week trial. I've got a lot to say. I've got a lot of notes.
Oh my gosh, dude.
We're good.
Say again?
I'm not hearing any,
Okay.
stammering
The only thing I
clamoring
would
from the
ask
state.
is after the state has had their first opening, give them a
Agreed.
short break, and then let me start.
Agreed. We'll take our afternoon break at that point in time, then we can proceed with the defense closing and then rebuttal. I have received approval from the chief to work after 9 o'clock. So we can go till about 10, maybe a little bit thereafter.
No, I need a verdict
You're saying
today.
jury, and
Correct.
then at 10 o'clock, if we hit some number, 10 or 11, then when we come back Monday,
That's correct.
No, I have a hair appointment on Monday. I don't know when he's going to trial, Brandy. It just says he's going to move forward to trial. Oh, come on, y'all. Look, I cannot move this hair again. I have to be selfish. Kirsten, I think if you look at the totality of the evidence, I think their only hang up, I guess if you have to say, would be that he got in the suitcase willingly. Yes, that one too, Brandy. That's a good one. other than that, I mean, I don't think that she's going to get this battered spouse thing. I don't think that.
Thank you.
Yeah, I don't think that she wins this argument. I think if anyone wins the argument, Jorge wins that argument. I mean, and then also in one of those videos, Kirsten, Jorge says to the police officers, would you call if it was you, would you call? Like saying, if you were the one being abused, would you call? And the cop says to him, I don't know. I've not been the one in that position. And Jorge says to him, exactly, man, because you're a beefcake, meaning you're a big dude, like you're big. And the cop is like, man, I've seen guys bigger than me, or guys, I've arrested all types of people. So, it happens to guys too. So I felt so badly for Jorge when he was like, just take me in. Then he was just like, I'm guilty. Just take me. You're going to arrest me anyway. It's my fault. It's always my fault. And I was just like, oh, it was just so sickening, so sad. And he just always took it. He was like, she's my woman. It's my fault. It's always my fault. You're going to take me anyway. There's the no contact. So just take me. And I just felt badly for him. And he was always caught off guard whenever the cops would show up. He was always passed out or asleep or something. He never was like aware that they were going to be there. So he was always like, what are you talking about? What happened? What's going on? She would always wait till he was out cold. And then, yeah. And then, the whole filming him, all of that, it was almost like she would be doing something to try to catch him, set him up. And then when he was in the hallway, that video was so demeaning and so terrible, where she was like, I told you not to wake me up, not to bother me. Like, who talks to someone like that? It's so terrible. She's treating him like worse than an animal. It's just so bad. And he was like, yes, ma'am. Yes, ma'am. Like, I think the jury would be more on her side if they could have actually shown, if the defense could have actually shown that Jorge was just this repeat offender, horrible abuser, that, they just had no evidence of that, even though she called 911 a lot and he was arrested a lot and he had the no contact orders. Yes, that all is true. But at the same time, if you look at all of the 911 calls and all of the arrests, he was passed out and had no idea the cops were even called. And she was, you could see she was basically poking him, like poking the bear. When the cops would come in and he would be passed out, she'd be like, see there? See, you didn't think I'd do it, did you? Ha, 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 ha. Gotcha. Like, that's kind of how she would be acting whenever the cops would come. And he'd be like, what the heck is going on? What are they doing here? Sarah, are you serious? Like, he's just like, what? Are you serious? And she's like, yeah, ha, 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 ha. You didn't think I'd do it. You're done for this time. Like, she was using the police as a tool, a little in her little arsenal to use against Jorge the best that she could. Just like when she would call 911 for no reason. She'd be like, yeah, this isn't really an emergency. I don't really need you guys. But just in case I need you guys, I just want to call. Like, you're calling the fire department and be like, yeah, there's not a fire, but in case there's a fire, is there any way you can be ready? As if they're not ready anyway. Yeah. Yeah. Much like Jeffrey Herbstman, right? I'm going to call 911 on myself and say that I admitted to doing something to my girlfriend, and I'm going to have this criminal defense attorney on call just in case I admit to doing something criminal and need to get off and blame a complete stranger. And that worked. That did work for him, though. Oh, put those little bodyguards to work. There you go, Judge. Look at them. They're all like, I have no idea what I'm doing. What do you want me to do with these papers again? I mean, you know what's sad too, Gwen, is I bet he probably did not think that he was not going to come out of that suitcase. Actually, I was thinking about the TV and the baseball bat, Brandy, and I was thinking that I bet that was another game. I bet it was another game that they were playing. They were both intoxicated, right? I bet it wasn't out of anger. Because I bet you they were, because she didn't say anything. She was filming him doing it, but she wasn't saying a word. I bet it was kind of like, I dare you. I bet you won't hit the TV with the baseball bat, or I bet you can't knock the TV down, or something like that. I bet it was just something silly and stupid, and she was like, "I'm going to film you doing this, and I bet you won't do it," or something like that. I bet it was just something completely asinine like that. It wasn't him like being angry. And it was also right after he was sitting there saying, you can go out, do whatever you want. I don't care. Just tell me where you're at so I can know that you're okay. It's not an unreasonable request. My man's the same way. Of course, I'm epileptic and he worries about me 24/7, but that's not unrealistic to be like, I just need to make sure I know where you're at just in case something happens. I don't care who you're with, because at the end of the day, if you're with the wrong person, I'm going to anyway. That's the last time. The only time and last time, so don't worry. But yeah, it was that same video where he was saying to her, you can go do whatever you want. And then she was the one getting pretty aggravated in that video, where she was like, so I can hang out with Boo. I can do this with Boo. I can do whatever. And he was like, yes, whatever, yeah, and then the next thing you know, the TV's being busted. But I really do believe that it was another one of their stupid, silly, as stupid as it sounds, because Jorge seemed like he was just a silly drinker. And she was the not nice drinker.
State, are you ready to proceed? Defense, are you ready to proceed? Yes, sir.
Oh, I knew as soon as Owens got back.
We're ready, Judge.
Let's go ahead and bring in our jury.
Thank you. What time is it? Oh my gosh, y'all. It's an hour longer. They've had the jury back there an hour longer. So we're not going to get to defense closings before 5, I don't think. Well, Gwen, the good news is, I mean, so I know you want a verdict back really quickly, but it can't all be like OJ, okay? Where a 9-month trial turned into a 4-hour verdict really fast. So at least they're actually taking in the evidence and the trial, and they're not coming back very, very quickly. And they're not letting their emotions take over, because whenever there's a trial dealing with a child, it's so easy to let your emotions take over and not allow yourself to take in the evidence. So at least they're doing that.
Jury entering.
Hello, look at that. We've got everybody back. Hey, 40 Graham. What's up? What's up? Welcome. Oh my gosh. You don't know anyone that was
Thank you
in
for your
that
patience. We had a long conversation about the jury instructions, and I missed a typo or
incident.
two after I printed everything, and took us a while to print everything out.
saw it on
And
the
asked
news
courtroom deputy
yesterday.
to come forward and pass these out to you. If you could, if you can, please raise your hands to confirm that you complied with the court's instructions during the break. All right, record reflect all hands have been raised.
It was like a
Members of the
fire
jury,
or something.
we are at the conclusion of the evidence and
Oh gosh, now I have to
testimony.
look it up.
In this case, the court is now going to instruct you on the law. The courtroom deputy is providing you copies of the jury instructions. Like I said at the beginning, you're going to be able to take these back with you into the deliberation room. There's not going to be a quiz or a test at the end. You don't need to memorize anything. If you'd like to read along, you can. If you just want to listen, you can. It's completely up to you. Court's going to read most of the instructions and then turn it over to the lawyers for their closing arguments. The state will go first, as they have the burden. Then the defense will go. And then the state will have the opportunity to rebut. Then I will conclude the instructions and release you for your deliberations. After the state's closing, we're going to take our afternoon recess. At that point in time, I'll have the courtroom deputy provide you that emergency number. So if you need to reach out and to family or loved ones to let them know that you are on the jury and are deliberating, you can do that at that time. With that, members of the jury, the court's going to go ahead and begin reading you the jury instructions. Instruction 3.1, Introduction to Final Instructions.
They're reading jury
Members of the
instructions
jury,
right now.
I thank you for your attention during this trial. Please pay attention to the instructions I am about to give to you. 3.2, Statement of the Charge. Sarah Boone, the defendant in this case, has been accused of the crime of second-degree murder. 7.1, Introduction to Homicide. Sarah Boone is accused of second-degree murder.
Although
Murder in the second degree
fire, 40
includes
Graham.
the lesser crime of manslaughter, both of which are unlawful. However, a killing that was excusable or that was committed by the justifiable use of deadly force is lawful. If you find Jorge Torres was killed by Sarah Boone, you will then consider the circumstances surrounding the killing in deciding if the killing was second-degree murder or was manslaughter, or whether the killing was excusable or resulted from justifiable use of deadly force. Justifiable homicide. The killing of a human being is justifiable homicide and lawful if necessarily done while resisting an attempt to murder or commit a felony upon the defendant, or to commit a felony in any dwelling house in which the defendant was at the time of the killing. excusable homicide. The killing of a human being is excusable and therefore lawful under any one of the following three circumstances. 1, when the killing is committed by accident and misfortune in doing any lawful act by lawful means with usual, ordinary caution and without any unlawful intent. Or 2, when the killing occurs by accident and misfortune in the heat of passion upon any sudden and sufficient provocation. Or 3, when the killing is committed by accident and misfortune resulting from a sudden combat, if a dangerous weapon is not used and the killing is not done in a cruel or unusual manner. A dangerous weapon is any object that will likely cause death or great bodily harm if used in the ordinary and usual manner contemplated by its design and construction. Great bodily harm means great, as distinguished from slight, trivial, minor, or moderate harm, and as such, does not include mere bruises. I now instruct you on the circumstances that must be proved before Sarah Boone may be found guilty of second-degree murder or any lesser included crime. 7.4, murder, second degree. To prove the crime of second-degree murder, the state must prove the following three elements beyond a reasonable doubt. 1, George Torres is dead. 2, the death was caused by the criminal act of Sarah Boone. 3, there was an unlawful killing of George Torres by an act imminently dangerous to another and demonstrating a depraved mind without regard for human life. An act includes a series of related actions arising from and performed pursuant to a single design or purpose. An act is imminently dangerous to another and demonstrating a depraved mind if it is an act or series of acts that, 1, a person of ordinary judgment would know is reasonably certain to kill or do serious bodily injury to another, and 2, is done from ill will, hatred, spite, or an evil intent, and 3, is of such a nature that the act itself indicates an indifference to human life. In order to convict of second-degree murder, it is not necessary for the state to prove the defendant had an intent to cause death. 3.4, when there are lesser included crimes or attempts. In considering the evidence, you should consider the possibility that although the evidence may not convince you that the defendant committed the main crime of which she is charged, there may be evidence that she committed other acts that would constitute a lesser included crime or crimes. Therefore, if you decide that the main accusation has not been proved beyond a reasonable doubt, you will next need to decide if the defendant is guilty of any lesser included crime. The lesser crimes indicated in the definition of second-degree murder is manslaughter, culpable negligence. 7.7, manslaughter. To prove the crime of manslaughter, the state must prove the following two elements beyond a reasonable doubt. 1, George Torres is dead. 2A, Sarah Boone intentionally committed an act or acts that caused the death of George Torres. B, the death of George Torres was caused by the culpable negligence of Sarah Boone. Yes? I apologize. Or, thank you for that clarification. Sarah Boone I'll reread those for you. 2A, Sarah Boone intentionally committed an act or acts that caused the death of George Torres. Or B, the death of George Torres was caused by the culpable negligence of Sarah Boone. Every person has a duty to act reasonably towards others. If there is a violation of that duty without any conscious intent to harm, that violation is negligence. The defendant cannot be guilty of manslaughter by committing a merely negligent act, or if the killing was either justifiable or excusable homicide, as I have previously instructed you. In order to convict of manslaughter by act, it is not necessary for the state to prove that the defendant had an intent to cause death, only an intent to commit an act that was not merely negligent, justified, or excusable, and which caused death. I will now define culpable negligence for you. As I have said, every person has a duty to act reasonably towards others. If there is a violation of that duty without any conscious intention to harm, that violation is negligence. But culpable negligence is more than a failure to use ordinary care towards others. In order for negligence to be culpable, it must be gross and flagrant. Capable negligence is a course of conduct showing reckless disregard of human life or of the safety of persons exposed to its dangerous effects, or such an entire want of care as to raise a presumption of a conscious indifference to consequences, or which shows wantonness or recklessness, or a grossly careless disregard for the safety and welfare of the public, or such an indifference to the rights of others as is equivalent to an intentional violation of such rights. The negligent act or omission must have been committed with an utter disregard for the safety of others. Culpable negligence is consciously doing an act or following a course of conduct that the defendant must have known or reasonably should have known was likely to cause death or great bodily injury. 8.9, culpable negligence. To prove the crime of culpable negligence, the state must prove the following two elements beyond a reasonable doubt. 1, Sarah Boone exposed Jorge Torres Jr. to a personal injury. 2, she did so through culpable negligence. Actual injury is not required. I will now define culpable negligence for you. Each of us has a duty to act reasonably towards others. If there is a violation of that duty without any conscious intent to harm, that violation is negligence. But culpable negligence is more than a failure to use ordinary care for others. In order for negligence to be culpable, it must be gross and flagrant. Culpable negligence is a course of conduct showing reckless disregard for human life or for the safety of persons exposed to its dangerous effects, or such an entire want of care as to raise a presumption of a conscious indifference to consequences, or which shows wantonness or recklessness, or a grossly careless disregard for the safety and welfare of the public, or shows such indifference to the rights of others as is equivalent to an intentional violation of such rights. 3.6D, as in Delta, voluntary intoxication. Voluntary intoxication resulting from the use of alcohol is not a defense to a crime. Evidence of a defendant's voluntary intoxication may not be taken into consideration to show that she lacked the specific intent to commit any crime. A person is voluntarily intoxicated if he or she knowingly consumed a substance that he or she knew or should have known could cause intoxication. Voluntary intoxication is not a defense to second-degree murder, manslaughter, or culpable negligence. 3.6F, as in Foxtrot, justifiable use of deadly force. It is a defense to the crimes of second-degree murder, manslaughter, and culpable negligence if the actions of Sarah Boone constituted the justifiable use or threatened use of deadly force. Deadly force means force likely to cause death or great bodily harm. Great bodily harm means great, as distinguished from slight, trivial, minor, or moderate harm. Sarah Boone does not have the burden of proving that she was justified in using deadly force. Instead, For you to find Sarah Boone guilty, the state must prove beyond a reasonable doubt that Sarah
What through
Boone was
8
not
for this
justified in using deadly force. The law on the justifiable use deadly force is as follows. Sarah Boone was justified in using deadly force if she reasonably believed that such force or threat of force was necessary to prevent imminent death or great bodily harm to herself. Sarah Boone had no duty to retreat before using deadly force. In deciding whether Sarah Boone was justified in the use of deadly force, you must consider the circumstances at the time the force or threat of force was used. The danger need not have been actual. However, to justify the use of deadly force, the appearance of imminent danger must have been so real that Sarah Boone actually believed the use of deadly force was necessary. Moreover, to justify the use of deadly force, a reasonably cautious and prudent person under the same circumstances would have believed the use of deadly force was necessary. However, the use of deadly force is not justified if you find that Sarah Boone used force to initially provoke the threatened use of force against herself, unless 1. The threat of force asserted towards the defendant was so great that she reasonably believed that she was in imminent danger of death or great bodily harm. Please silence your cell phones. And had exhausted every... Out. Whose ever phone is on, get out right now.
Oh!
Members of the jury, I apologize. I'm going to read that over for you for the beginning. Paragraph 1. The threat of force asserted toward the defendant was so great that she reasonably
I'll
believed
make sure your phones are
that
off.
she was in imminent danger of death or great bodily harm, and had exhausted every reasonable means to escape the danger other than using deadly force on Jorge Torres. Or 2, in good faith, Sarah Boone withdrew from physical contact with Jorge Torres and clearly indicated to Jorge Torres that she wanted to withdraw and stop the use of deadly force. But Jorge Torres continued or resumed the threatened use of force. Physical contact includes any restraint on Jorge Torres's movement. If you find that Sarah Boone, because of prior threats or difficulties with Jorge Torres Jr., had reasonable grounds to believe that she was in danger of death or great bodily harm at the hands of Jorge Torres, you may consider this fact in determining whether the actions of Sarah Boone were those of a reasonable person. If you find that at the time of the alleged second-degree murder, manslaughter, or culpable negligence, Sarah Boone knew that Jorge Torres had committed an act or acts of violence, you may consider that fact in determining whether Sarah Boone reasonably believed it was necessary for her to use deadly force. In considering the issue of self-defense, you may take into account the relative physical abilities and capacities of Sarah Boone and Jorge Torres.
I'm missing page 10 and 11.
I am too.
Okay. We will remedy that. Thank you, sir. Is it just your copy, Mr. Owens?
Anybody else missing 10 and 11?
Okay, y'all. So while we're letting him get the page, let's pray real quick. Quickly. Y'all, in Jesus' name, we pray for Jorge and his family to get justice. We know that the jury hopefully will take their time to look at all the evidence, but we pray that they will see that Sarah Boone clearly was the aggressor and the abuser, and Jorge didn't have a chance. He just kept going back He obviously was
Thank you.
in
Record reflect all thumbs
an
went
abusive
up.
relationship. It was
Page
toxic,
11,
but Lord, please
special
put your hands on the
instruction
jury
on
and the
battered
judge
spouse
and these
syndrome.
lawyers
You
and
have heard
Jorge's
evidence that
family
Sarah Boone
and
suffers from
Sarah's
battered spouse
son
syndrome.
and
If you
ex-husband
find the evidence
and
that
everyone
Sarah Boone
involved. There are
suffers
no
from
winners.
battered
In Jesus'
spouse
name we
syndrome
pray.
credible,
Amen.
you may consider this evidence to assist you in determining whether a person in Sarah Boone's circumstances would reasonably believe that such force was necessary to defend herself against the imminent use of unlawful force by Jorge Torres. Like other witnesses, you may believe or disbelieve all or any part of the testimony regarding battered spouse syndrome. 3.6G, justifiable use of non-deadly force. It is a defense to the crimes of second-degree murder, manslaughter, and culpable negligence if the actions of Sarah Boone constituted the justifiable use non-deadly force. Non-deadly force means force not likely to cause death or great bodily harm. Great bodily harm means great, as distinguished from slight, trivial, minor, or moderate harm. Sarah Boone does not have the burden of proving that she was justified in using non-deadly force. Instead, for you to find Sarah Boone guilty, the state must prove beyond a reasonable doubt that Sarah Boone was not justified in using non-deadly force. The law on the justifiable use of non-deadly is as follows. Sarah Boone was justified in using non-deadly force against Jorge Torres and had no duty to retreat if she reasonably believed that such conduct was necessary to defend herself against Jorge Torres's imminent use of unlawful force. In deciding whether Sarah Boone was justified in the use of non-deadly force, you must consider the circumstances at the time the force or threat of force was used. The danger need not have been actual. However, to justify the use of non-deadly force, the appearance of imminent danger must have been so real that Sarah Boone actually believed the use of non-deadly force was necessary. Moreover, a reasonably cautious and prudent person under the same circumstances would have believed the use of non-deadly force was necessary. However, the use of non-deadly force is not justified if you find that Sarah Boone used force to initially provoke or threatened use of force against herself, unless one, the threatened force asserted towards Sarah Boone was so great that she reasonably believed that she was in imminent danger of death or great bodily harm and had exhausted every reasonable means to escape the danger other than using non-deadly force on Jorge Torres. Or 2, in good faith, Sarah Boone withdrew from physical contact with Jorge Torres and indicated clearly to Jorge Torres that she wanted to withdraw and stop the use of non-deadly force. But Jorge Torres continued or resumed or threatened use of force. Physical contact includes any restraint on Jorge Torres's movement. If you find that Sarah Boone, who, because of prior threats or difficulties with Jorge Torres Jr., had reasonable grounds to believe that she was in danger of imminent use of unlawful force at the hands of Jorge Torres Jr., you may consider this fact in determining whether the actions of Sarah Boone were those of a reasonable person. If you find that at the time of the alleged second-degree murder and/or culpable negligence, Sarah Boone knew that Jorge Torres Jr. had committed an act or acts of violence.
Are you serious, Kirsten?
You may consider that fact in determining whether Sarah Boone reasonably believed it was necessary for her to use non-deadly force. In considering the issue of self-defense, you may take into account the relative physical abilities and capacities of Sarah Boone and Jorge Torres. Special instruction on battered spouse syndrome. You have heard evidence that Sarah Boone suffers from battered spouse syndrome. If you find the evidence that Sarah Boone suffers from battered spouse syndrome credible, you may consider this evidence to assist you in determining whether a person in Sarah Boone's circumstances would reasonably believe that such force was necessary to defend herself against the imminent use of unlawful force by Jorge Torres. Like other witnesses, you may believe or disbelieve all or any part of the testimony regarding battered spouse syndrome. 3.7, plea of not guilty, reasonable doubt, and burden of proof.
You can't
The
be.
defendant has entered a
I don't
plea
think
of
you
not
can
guilty.
be, Kirsten.
This means you must presume or believe the defendant is innocent.
That's not possible.
The presumption stays with the
I'm
defendant as
sorry.
to each material allegation in the information through each stage of the trial, unless it has been overcome by the evidence to the exclusion of and beyond
That's a
reasonable
very
doubt.
slippery slope.
To overcome
either
the defendant's
side.
presumption of innocence, the state
I
has
mean,
the
you
burden
saw
of proving
me
the crime
during this
with
whole
which
trial.
the defendant is charged was committed.
It
and
is
the
a
defendant
very
is the
slippery
person
slope.
who committed the crime. Whenever the words reasonable doubt are used, you must consider the following. Proof beyond a reasonable doubt does not mean
You can
proof
try
beyond all
really
doubt.
hard to be
A reasonable
neutral.
doubt is not a mere possible doubt, a speculative, imaginary,
It
or
is
forced
not
doubt.
safe
Such a doubt must not influence you to return a verdict of
for
not guilty
her mental
if you have an
ability
abiding conviction
to
of
sit
guilt.
through this.
On the other hand,
That's
if after
not
carefully
safe.
considering, comparing, and weighing all the evidence, there
It's
is
just not good
an
for
abiding
her to sit
conviction of
through this
guilt,
type of
or
trial.
if having a conviction, it is one which is not stable, but one
So
which
she
wavers
can think
and
she can be
vacillates,
neutral.
then the
When you
charge
sit
is
through this
not
type
proved
of
beyond every
information,
reasonable doubt,
that's
and you must
I
find the
can't do
defendant
this kind of
not
trial
guilty
again for a
because the
while.
doubt is
This
reasonable.
is not going to be.
It is to the evidence
not
introduced in
good.
this trial and to it alone that you are to look for that proof. A reasonable doubt as to the guilt of the defendant may arise from the evidence.
I mean, I'm going to have to
conflict
go
in
watch
the
buildings
evidence,
burn down
or
or
the lack of
bridges
evidence.
fall with tons of cars
If you
on
have
it
a
or something, or
reasonable
train
doubt,
wrecks
you should find the
for a
defendant
while.
not guilty. If you have no reasonable doubt, you should find the defendant
Yeah,
guilty.
I mean, she could look at it the
3.9,
way I'm looking at
weighing
it
the
now,
evidence.
as
It is up to
putting
you
herself
to
in
decide
Jorge's
what
shoes.
evidence is reliable. You should use your common
that's
sense in
still not-
deciding which is the best evidence
still not
and
good.
which evidence should not be relied upon in
Because
considering
it
your
still
verdict.
makes you lean one way or the
You
other.
may find some of the evidence not reliable or less reliable than other evidence. You should consider how the witnesses acted as well as what they said. Some things you should consider are: 1, did the witness seem to have an opportunity to see and know the things about which the witness testified? 2, did the witness seem to have an accurate memory? 3, was the witness honest and straightforward in answering the attorney's questions? 4, did the witness have some interest in how the case should be decided? 5, does the witness's testimony agree with the other testimony and other evidence in the case? 6, did the witness at some other time make a statement that is inconsistent with the testimony he or she gave in court? Whether the state met its burden of proof does not depend upon the number of witnesses it has called or upon the number of exhibits it has offered, but instead upon the nature and quality of the evidence presented. The fact that a witness is employed in law enforcement does not mean that his or her testimony deserves more or less consideration than that of any other witness.
No, it does
Expert
not.
witnesses are like other witnesses, with one exception. The law permits an expert witness to give his or her opinion. However, an expert opinion is reliable only when given on a subject about which you believe him or her to be an expert. Like other witnesses, you may believe or disbelieve all or any part of an expert's testimony. The defendant in this case has become a witness. You should apply the same rules to consideration of her testimony that you apply to the testimony of the other witnesses. It is entirely proper for a lawyer to talk to a witness about what testimony the witness would give if called to the courtroom. The witness should not be discredited by talking to a lawyer about his or her testimony. You may rely upon your own conclusion about the credibility of any witness. A juror may believe or disbelieve all or any part of the evidence or the testimony of any witness. 3.9 Bravo. Defendant statements. A statement claimed to have been made by the defendant outside of court has been placed before you. Such a statement should always be considered with caution and be weighed with great care to make certain it was freely and voluntarily made. Therefore, you must determine from the evidence that the defendant's alleged statement was knowingly, voluntarily, and freely made. In making this determination, you should consider the total circumstances, including, but not limited to, 1, whether, when the defendant made the statement, she had been threatened in order to get her to make it, and 2, whether anyone had promised her anything in order to get her to make it. Law enforcement is not legally required to ask a suspect whether he or she wants to talk to law enforcement after Miranda warnings are read to a suspect. This is, however, one of the factors you may consider whether the defendant's statements were voluntarily made. If you conclude the defendant's out-of-court statement was not freely and voluntarily made, you should disregard it. 3.10, Rules for Deliberation. These are some general rules that apply to your discussion. You must follow these rules in order to return a lawful verdict. 1, you must follow the law as it is set out in these instructions. If you fail to follow the law, your verdict will be a miscarriage of justice. There is no reason for failing to follow the law in this matter. All of us are depending upon you to make a wise and legal decision in this matter. 2, this case must be decided only upon the evidence that you have heard from the testimony of the witnesses and have seen in the form of exhibits and evidence in these instructions. 3, this case must not be decided for or against anyone because you feel sorry for anyone or are angry at anyone. 4, remember, the lawyers are not on trial. Your feelings about them should not influence your decision in this case. 5, your duty is to determine if the defendant has been proven guilty or not in accord with the law. It is the judge's job to determine a proper sentence if the defendant is found guilty. 6, whatever verdict you render must be unanimous. That is, each juror must agree to the same verdict. 7, your verdict should not be influenced by feelings of prejudice, bias, or sympathy. Your verdict must be based on the evidence and on the law contained in these instructions. 3.11, cautionary instruction. Deciding a verdict is exclusively your job. I cannot participate in that decision in any way. Please disregard anything I may have said or done that made you think I preferred one verdict over another. 2.7, closing argument. Both the state and the defendant have now rested their case. The attorneys now will present their final arguments. Please remember that what the attorneys say is not evidence or your instruction on the law. However, do listen closely to their arguments. They are intended to aid you in understanding the case. Each side will have equal time, but the state is entitled to divide this time between an opening argument and a rebuttal argument after the defense has given its closing argument. With that, state, you may proceed.
Okay, y'all, here we go. Yeah, but it's our justice system. Whoa. Okay, let's bring out the big guns. Wow, he just.
This is a box. This is the box where Jorge Torres was killed. It's a small box, 28 by 20 by 8 7/8 inches. Jorge Torres was zipped up in this box. Jorge Torres took his last panicked breaths in this box. The medical examiner explained to us that with each breath Jorge Torres took in, there was less oxygen in this box. Jorge Torres was murdered in this box. Ladies and gentlemen, on behalf of myself, my trial partner, we thank you for your time and attention in this most important of trials. We now have the law from the judge in this case. This is what our duty is to follow. And let's have a discussion regarding that law we've just been read and given. The first section of note we're going to come to is called Introduction to Homicide. But this being a legal document written by a bunch of lawyers who you've seen for the last 2 weeks arguing with each other, pay careful attention to ands and ors. Remember, if an and is somewhere, we're going to need both things or all the things, and if an or is there, then only one of those things we're going to need. So as we start out here on Introduction to Homicide, we come to the first section on justifiable homicide. And it reads, the killing of a human being is justifiable homicide and lawful if necessarily done while resisting an attempt to murder or commit a felony upon the defendant, or to commit a felony in any dwelling house in which the defendant was at the time. Ladies and gentlemen, this section is completely inapplicable. It's inapplicable because Jorge Torres was zipped up in that suitcase. He couldn't commit or attempt to commit a murder on anybody. He couldn't even scratch his own head while he was in that suitcase. Next, we turn to excusable homicide. Here we have several paragraphs, and it reads, the killing of a human being is excusable and therefore lawful under any one of the following three circumstances. When the killing is committed by accident and in misfortune, doing any lawful act by lawful means, usual, ordinary caution, and without any unlawful intent. Well, problem in this circumstance for the defendant is that she took the law into her own hands. Her testimony was that when Jorge Torres was in here, he was laughing and giggling and they were joking. And then he started to complain that he couldn't breathe. And that's when she said that she wanted him to stay in there so he could feel uncomfortable. So he could feel her grievances. Ladies and gentlemen, that is not lawful. That is not the use of ordinary caution. And that is not applicable in this circumstance. Second, when the killing occurs by accident or misfortune in the heat of passion upon any sudden and sufficient provocation. Jorge Torres couldn't provoke anything from his circumstance. Jorge Torres was confined to this box. Next, when the killing is committed by accident and misfortune resulting from a sudden combat, a dangerous weapon is not used, the killing is not done in a cruel and unusual manner. This fails on 2 counts. There was no sudden combat. In her words, this was laughing and joking and we're all having fun when she decides that it's going to get a little extra real for Jorge Torres. And it fails on the 2nd count because Jorge Torres was killed in a cruel and unusual manner. Next, we turn to our main charge of 2nd-degree murder. The law informs us that to prove the crime of 2nd-degree murder, the state must prove the following 3 elements beyond a reasonable doubt. I think it's important to stop right here. This sentence right here is telling us what has to be proven in order for the crime of 2nd-degree murder to be for the defendant to be found guilty in this case. We've been hearing all kinds of facts for almost 2 weeks now of trial, but these are the 3 facts that had to have been met by the reasonable doubt standard in order to be found guilty. Ladies and gentlemen, I submit to you that the state has proven 2nd-degree murder beyond all doubt. And the proof of that guilt is overwhelming. But I will cite for each element just one fact that conclusively proves each of those elements beyond all doubt. As to the first fact, that Jorge Torres is dead, well, we have stipulation, amongst other things, that agrees to that. As to the second fact, the death was caused by Sarah Boone. Sarah Boone, in her own words, from the time that this case began on February 23rd, 2020, to when she took the witness stand a few days ago, was consistent about one statement. She zipped him up. She didn't zip him out. She zipped him up in the suitcase, and she refused to zip him out. 3, there was an unlawful killing of Jorge Torres by an act imminently dangerous to another and demonstrating a depraved mind without regard for human life. The law goes on to define for us what a depraved mind is, and also what an act is. And it's going to tell us that an act includes any series of related actions arising from and performed pursuant to a single design or purpose. An act is imminently dangerous to another in demonstrating a depraved mind if it is an act or a series of acts that one, a person of ordinary judgment would know is reasonably certain to kill or do serious bodily harm to another, and is done from ill will, hatred, spite, or an evil intent, and is of such a nature that the act itself displays an indifference to human life. Ladies and gentlemen, her conduct fits every one of those things. And if there was a scintilla of doubt that this was not the actions of a depraved mind, I point to you. ING 1062, states 17. Mr. J, may you publish states 17?
So October happens to be Domestic Violence Awareness Month, you guys.
Hello.
For everything you've done to me.
Hello.
For everything you've done to me.
Hello.
Fuck you.
Hello.
Fuck you.
Hello.
Stupid.
Hello.
That's my name. Don't wear it down.
I
Yeah.
can't fucking breathe, babe. Seriously.
Yeah, that's when you do and choke me.
Hello.
What happened? What? What did I miss? Sorry, I was working on a thumbnail. Oh, gosh. I mean, they are probably like, they can't, this video they keep having to watch is just got to be awful.
You may continue.
Sarah.
His mom had to leave, Kirsten.
Sarah. Sarah, I can't breathe it. That's on you. Sarah, I can't breathe. It's on you. Sarah. Real ransom. Now you want to give video for it extra. Because I got it. Sarah. Real ransom. Sarah, I can't breathe it. Oh. That's what I meant like when you drink on me. Sarah. Fuck you. Please, Sarah. Yeah. You should probably shut the fuck up.
Ladies and gentlemen, that exhibit removes any scintilla of doubt about the depravity of the defendant's actions. But we know from the evidence that this was not the first time she had considered killing Jorge Torres. We know from the evidence that on January 13th, 2020, approximately 1 month prior to Jorge Torres' murder, the defendant had a text message conversation. Please do something with yourself, Sarah. God bless you. Bless you and all of you too. I'll get rid of him, then I'll be better. Torres. But ladies and gentlemen, in this case, the law actually specifically tells us that the intent to cause death is not necessary. In order to convict of second-degree murder, it is not necessary for the state to prove the defendant had an intent to cause death. Next, we turn. I'm going to bypass the lesser included offenses because though she is guilty of those offenses as well, the law instructs us that she is to be convicted of for the highest offense in which the evidence supports, which is second-degree murder in this case. So turning our attention towards voluntary intoxication. If there was any question about the fact that Sarah imbibed alcohol on the night that Jorge Torres was murdered, and that maybe somehow that would excuse the conduct or be some type of defense for the conduct. Well, this tells us that that's not the case. Voluntary intoxication resulting from the use of alcohol is not a defense to a crime. Evidence of a defendant's voluntary intoxication may not be taken into consideration to show that she lacked the specific intent to commit any crime. A person is voluntarily intoxicated if he or she knowingly consumed a substance that he or she knew or should have known could cause intoxication. Voluntary intoxication is not a defense to second-degree murder, manslaughter, or culpable negligence. Ladies and gentlemen, there's ample evidence of the defendant's intoxication from watching her on the public surveillance, buying the bottles of wine with Jorge Torres,
I don't know, but she's always writing.
her admissions to drinking, to her voice that we heard on the video while she was torturing Jorge Torres. Next, we come to defenses. First, we come to the justifiable use of deadly force. It tells us it is a defense to the crimes of second-degree murder, manslaughter, and culpable negligence if the actions of Sarah Boone were justifiable use or threatened use of deadly force.
Prayers answered.
Sarah Boone does not have the burden of proving that she was justified in using deadly force. Instead, for you to find Sarah Boone guilty, the state must prove beyond a reasonable doubt Sarah Boone was
That's
not
one down.
justified in using deadly force. The law on the justifiable use of deadly force is as follows. Sarah Boone was justified in using deadly force if she reasonably believed that such force or threat of force was necessary to prevent the imminent death or great bodily harm to herself. Sarah Boone had no duty to retreat. Ladies and gentlemen, in a few moments, Mr. Owens will rise. And he is going to show you this.
Oh, look at the prosecution jumping ahead.
And this. And this. And he's going to talk in this as well about the list of grievances that Sarah Boone had for Jorge Torres. He's going to talk to you about curtain rods.
That's why they didn't object to any of that, because A was already in evidence.
Talk to you about black eyes. He's going to talk to you about what an awful, awful boyfriend Jorge Torres was. And ladies and gentlemen, at the end of all of that, it still will not change the fact that the defendant is not entitled to the justifiable use of deadly force. Because as we continue to read this instruction, it tells us in deciding whether Sarah Boone was justified in using the use of deadly force, you must consider the circumstances at the time the the force or the threat of force was used. Danger need not have been actual. However, to justify the use of deadly force, the appearance of imminent danger must have been so real that Sarah Boone actually believed that deadly force was necessary. Moreover, to justify the use of deadly force, and this is important, a reasonably cautious and prudent person under the same circumstances would have believed the use of deadly force was necessary. Ladies and gentlemen, no reasonably prudent and cautious person would believe that a man who could barely fit into this box, who was incapable of movement, who was begging for his life, who was slowly asphyxiating, suffocating with each breath, would have needed to use deadly force against him. The justifiable use of deadly force utterly fails, utterly crashes like a house of cards. But there's more. However, the use of deadly force is not justified if you find that Sarah Boone used force to initially provoke threatened use of force against herself. Let's stop there before we consider the next two paragraphs. Some of the most critical testimony in this trial is her testimony on the stand. It was a great day. We were doing puzzles and artwork, dancing with the dogs, listening to music. Tag, you're it, hide and go seek time. George gets into the suitcase. She comes and zips him up. But we're still laughing about it. We're still laughing after he's zipped up in the suitcase. And then that's when George had the temerity to ask, Jorge Torres had the temerity to ask to be unzipped from the suitcase. And that's when Sarah Boone decided he needed to suffer. She was the initial aggressor, ladies and gentlemen. She provoked the use of force in this case. In her own words, we were laughing and playing right before he wanted to be let out because he couldn't breathe. Paragraph 1. The threat of force asserted toward the defendant was so great that she reasonably believed that she was in imminent danger of death or great bodily harm and had exhausted every reasonable means to escape the danger other than using deadly force on Jorge Torres. He couldn't exert anything, ladies and gentlemen. Jorge Torres couldn't even exert his arm out of the suitcase. How on earth could he have exerted a force so great to justify his... Judge, I object.
Approach.
All right, so Leilani was found guilty. That's good news. Justice for Quentin. I was not aware, but this whole month of October has been Domestic Violence Awareness Month. So It is fitting that this trial is happening right now for Jorge. So let's pray that Jorge gets justice. I'm going to pray that that juror that is on the jury is not actually on the jury. Juror number 13, I hope gets taken off, just because I just don't think it's healthy. And I really don't think it's good for either side to have someone who has been a victim, survivor.
Objection overruled.
Of DV to be on
This
kind of case.
No help to the defendant. Second paragraph. In good faith, Sarah Boone withdrew from physical contact with George Torres and clearly indicated to George Torres that she wanted to withdraw and stop the use of deadly force. But George Torres continued or resumed threatened use of deadly force. Ladies and gentlemen, George Torres never got a chance to do anything. George Torres never was able to mount any aggression towards the defendant. Therefore, this paragraph is inapplicable. And the law tells us as well that physical contact in this case includes any restraint on George Torres's movements. The law also tells us again, you find that Sarah Boone, because of prior threats or difficulties with George Torres, had reasonable
It's a
grounds
catch-22, Kirsten. I don't know.
danger of great bodily harm, of death or great bodily harm at the hands of George Torres. You may consider this fact in determining whether the actions of Sarah Boone were reasonable. Now we're going to get to battered spouse syndrome in a moment.
You don't want the defense to have any reason to come back and say this wasn't a fair trial.
Defense to air grievances in regards to George Torres. But again, those grievances will not change the law, and they will not change the fact that the justifiable use of deadly force fails as a defense for the defendant. If you find that at the time of the alleged second-degree murder, manslaughter, culpable negligence, Sarah Boone knew that George Torres had committed an act or acts of violence, you may consider that fact in determining whether Sarah Boone reasonably believed it was necessary for her to use deadly force. Considering the issue of deadly force, you may take into account the relative physical abilities and capacities of Sarah Boone
So did the prosecution.
and George Torres. Now we come to the the special instruction on battered spouse.
And I would say it'd be very hard not to find someone that hasn't been a victim of something.
You have heard evidence that Sarah Boone suffers from battered spouse syndrome. If you find Sarah Boone suffered from battered spouse syndrome credible, you may consider this evidence to assist you in determining whether, in Sarah Boone's circumstances, would reasonably believe that such force was necessary to defend herself against the imminent use of unlawful force by George Torres. Like other witnesses, you may believe or disbelieve all or any part of the testimony in regards to battered spouse. Ladies and gentlemen, we heard from 3 experts in the areas of battered spouse in this case. I think at the outset, it's important to note what battered spouse is and isn't and what the law instructs us here. Battered spouse is not some carte blanche. Battered spouse is not a license to kill. The fact that Jorge Torres at points mistreated Sarah Boone, did things that were worthy enough to get him arrested, to get restraining orders placed upon him, doesn't mean that she walks around with an ace in her pocket when it comes to Jorge Torres. It doesn't mean that because he did these awful bad things, that now through the rest of time, she's a battered spouse and she just has the right to kill him or to make him suffer or to punish him or to make him feel uncomfortable or decide that he needs to be confined to a box. No. What the battered spouse syndrome instruction does, it talks about the imminency of fear. And when we heard about that testimony, we heard about it from Dr. Harper, and we heard about it from Dr. Brannon for the defense. And some of the testimony was a little difficult to understand at points, but there was one point in Dr. Brannon's testimony that was very critical. Dr. Brannon talked about rule-outs. He talked about the fact that when emotions and emotional reactions are involved, like trauma and trauma-based disorders, other possibilities have to be ruled out before we can even ascribe those actions to battered spouse syndrome. Other possibilities, according to Dr. Brannon, include alcohol abuse. Dr. Harper should have listened to Dr. Brannon's testimony because Dr. Brannon completely undercut Dr. Harper's testimony.
Wait,
Dr. Harper,
your expert didn't listen.
Heavily on the words of the defendant, who was abusing alcohol at the time of these events. And then you heard from the expert for the state, Tanya Warner. In her opinion, was much more straightforward. Remember, Dr. Brannon did not render an opinion as to whether or not she suffered from battered spouse. Dr. Warner said affirmatively, yes, I believe she did suffer from battered spouse syndrome. But she also applied what Dr. Brannon was talking about. Other possibilities have to be ruled out as the trigger for a behavior, for an event. So, in Dr. Warner's estimation, the fact that at the time of this incident, they were laughing and joking and carrying on meant that the trigger was not domestic violence or some threat, In the defendant's own words, the trigger was him wanting to get out and her being reminded of the bad things that he had done to her. That's not imminence of fear. That's reminder of bad things a person has done.
No, it was the art, Brandy. His art sucked.
Even if you were to believe that she was battered spouse triggered at the time of this event, it still does not save the day. Because all the battered spouse trigger
He drew a picture of Crystal.
law tells us is that it goes to that imminency requirement. It doesn't say there's no imminency requirement. It doesn't say that, look, if you're suffering from battered spouse and you're triggered by battered spouse, then, hey, there's no more imminency requirement, do as you wish. It just gives the ladies and gentlemen of the jury another thing to consider in determining whether or not that threat was imminent. And we know from the evidence, we know from the videos, there was absolutely no threat. And we know there was no threat because Jorge Torres never got out of that box. He was never got out of that box until sometime on the early afternoon of February 24th. Mr. J, can you please publish from stage 21?
You know what's even sadder is Jorge probably never imagined that he was not getting out of that suitcase. Oh my gosh.
I'm gonna go to court and I'm gonna tell the judge, listen, my fiance has nothing to do with it. It's all my fault. We were both drinking and got out of hand. It's an isolated situation. It has never happened before. I love my fiance. She's a good woman. Her being in trouble in her life, she has a 7-year-old son that she loves and cherishes.
A blind Boston Terrier.
She has 2 dogs. One is blind, one is deaf. She goes around and she's driving and sees an animal that's injured. She'll stop in the middle of the street, no matter what kind of traffic it is, just to make sure that that animal doesn't get injured any more than what it already has. We both love each other. We both live together. Yes, every relationship has their arguments, but we are not the type of people that you guys are portraying us to be.
She especially.
Especially her. So please, if you can,
Dismiss.
dismiss this case.
Closed.
Drop it. She is not the type of person.
Good person.
Great person.
Angel.
I know she'd be an angel. She's close to it.
Best thing that has ever happened to you.
Yes, ma'am. And I love you to death. And I hate that we're going through this right now.
Sonnet.
What?
And it could.
Good, I love you. Whatever you want me to say. God will prevail and He will take us out of this situation. Love you.
Clearly, George Torres is dominating the defendant. Clearly, George Torres is the one telling the defendant what to do. Clearly, George Torres is the one calling the shots at 4748 France Lane. Ladies and gentlemen, are we so sure that George Torres wasn't the person suffering from battered spouse syndrome? Next, we're going to come to the justifiable use of non-deadly force. The language and the arguments are pretty close to what we've already heard in the deadly force instruction, including the key language that it requires a reasonably cautious and prudent person under the same circumstances would have believed that the use of non-deadly force was necessary. Ladies and gentlemen, I submit to you that this was not a case of non-deadly force. George Torres lost his life as a result of these actions. We have heard the testimony of Dr. Sarah Zadovich, who described his cause and manner of death, who described the mechanism of death, how that oxygen dissipated in that suitcase. And when we also look at the imminency, we heard in opening statements by Mr. Owens that, the big threat in this case, the awful threat, was in the magic 9 minutes between the video at 11:12 that she took, torturing George Torres, to her follow-up video at 11:23, after she had moved the suitcase. Mr. J, that you published from States 17, IMG 1063. It was a short video. Well, what's one of the things that we notice by this point? You can hear how loud George's voice is on the 11:12 video. But now, roughly 11 minutes later from the time that started, You see that the makeshift coffin that he's in has been moved. And his voice now is softer. The life is draining from Jorge Torres, and it's evident in that video. And that, ladies and gentlemen, is evidence that there was no threat in the magic 9 minutes that was not recorded. There was only Jorge Torres in this box, slowly being killed. Next, we come to weighing the evidence. This instruction tells us it is up to you to decide what evidence is reliable. You should use your common sense in deciding which is the best evidence.
I mean, he could have used what little oxygen he had to threaten her, but instead he was using the oxygen he had to ask her to get out.
You may find some of the evidence not reliable or less reliable than other evidence.
Telling her he couldn't breathe.
You should consider how the witness acted as well as what they said. Some things you should consider. Did the witness have an opportunity to see and know the things about which the witness testified? In focusing on the defendant, absolutely. Two people walked through the front door on the evening of February 23rd, 2020 at 4748 France Court. Jorge Torres and Sarah Boone. But only Sarah Boone ever walked out that front door alive. Did the witness seem to have an accurate memory? This is an emphatic no. And the litany of her intoxication in versions of events is evidence of that. Was the witness honest and straightforward in answering the attorney's questions? I would submit to you she wasn't. 4, did the witness have some interest in how the case should be decided? Clearly. Does the witness's testimony agree with the other testimony and other evidence in the case? And I would say largely no. Because on the issue of whether or not Jorge Torres could have threatened her the way she says that he did, the answer is clearly no, and we know that from the forensic data. We know that from the items itself. Did the witness at some other time make a statement that is inconsistent with the testimony he or she gave in court? In regards to the defendant, it's almost more appropriate to ask about the time she did make a consistent statement. You listen to her version of events on the 911 call, on the body cameras, on her first interviews with law enforcement. And then you hear her in her next interview the next day with Detective Copsell and Detective Lowen. And more details come out. Things change. First, she was never intoxicated. Then she was intoxicated. Then there's just the whole fact of she omits the fact of, oh yeah, he was actually trying to attack me. Oh yeah, I was in fear for my life. When she said at every turn, no, it was just a great day. We were having fun. Oh my God, I can't believe this. We were doing good. The only stress we had was about jobs. And now, 4.5 years after the fact, it's time to come up with a new story. But ladies and gentlemen, I submit to you that the truth does not change. The facts do not change. The videos do not change. And on any version of events that the defendant has given, they all add up to the fact that there is absolutely no doubt that she is guilty of murder. I ask you, ladies and gentlemen,
Yeah, it was heartbreaking.
do you have any doubt about the defendant's guilt when she described using that baseball bat to hit Jorge Torres's fingers back in the suitcase when he attempted to save his life? Do you have any doubt when she is given how many versions of events in this case? Do you have any doubt after hearing the testimony of her neighbors about the loud crash and the arguing that night? Do you have any doubt after hearing the testimony of Dr. Sarah Zadovich? Do you have any doubt after watching the videos of Jorge Torres being murdered and her laughing about it and talking about the fact that he cheated on her? Do you have any doubt?
No, I'm fine. I
after
can't keep sitting.
reading the text messages
Thanks, Kirsten.
from her phone? After seeing the videos
It's going to be a long night.
of how she controlled and manipulated Jorge Torres? And if you say, Mr. Cacciatore, I still have a doubt. Well, then the law asks you, is that doubt to an element? And is that doubt a mere possible doubt, a speculative, an imaginary, or a forced doubt? I submit to you the idea that she had to do this because she was a battered spouse is an imaginary doubt. It's a doubt
Yes, we're
born
going to wait for the
from
verdict.
the imagination of Sarah Boone. It is not a reasonable doubt.
Last time I didn't wait for a verdict, they came
But
back.
if you find yourself back in that deliberation room and you are just trying to think of some way in which the defendant is not guilty, just searching, struggling for that way, that also is not a reasonable doubt, ladies and gentlemen. That is a forced doubt. Ladies and gentlemen, I'm confident that when you read the entirety of those jury instructions,
Oh, dang, Kirsten.
apply the law
That's right.
to the facts that came out in this case, that you are going to come back with the only lawful verdict, which is guilty as charged, second-degree murder. Thank you.
Okay, you got to do better, though, in the rebuttal.
Members of the jury, it is 4:04. As I
Gonna
promised,
take a
we were going
break?
to take that afternoon break before the defense proceeds with their closing argument. You can
The
leave
defense
everything
is gonna
behind.
go on like a
Similar
blowhard,
instruction that I've
so
given you
take a
before.
breather.
Please don't conduct any independent investigation, research as to the person, places, thing, or charge involved in this case. Do not have any discussions among yourselves or anyone else. We'll bring it back in about 15
Oh, they're gonna
minutes. Thank you very
take-
much.
The defense plans on dragging this out. He already said it. Look, the defense already said, they're going to try to keep the jury until like 10 or 11. And the defense is already talking about going on for a very long time with their closing. And then the prosecution has to get up and do their rebuttal. So the defense is trying to you've already seen how long they've been.
Okay, may proceed.
Every single freaking time.
Sarah Boone's entitled to a fair trial. I think that right's been compromised here today. I don't know who's scheduled to put the two detectives on the front row with the Torres family, the family of the victim. But they had to have known to tell them that the Suitcase video, which has been around for 4.5 years, was going to be played during opening statement. And the state attorney's office or the sheriff's department had to advise them, or the victim's advocate had to advise them, that if they couldn't take it in front of a jury that's trying to decide the case, they needed to get out of the courtroom. Now, what happened here today should not ever happen. There should be safeguards in place. There's no room for this after 2 weeks of murder trial for something like that to happen. One of the Torres members of the family audibly, during the 2-minute Suitcase video, expressed some kind of emotional reaction. I look back, he or she were bent over in agony, physical pain. The physical pain followed the audible announcement. You can't unring that bell. That's their responsibility to ensure that kind of thing doesn't happen, especially when they know they're going to show a video and the family of the victim is on the front row. I've never heard of such. I asked for a mistrial.
Response.
I've never heard of such a request. The victim's family has the right to be here. They were advised as to what will be used during closing arguments. I cannot make a decision for the victim's family and the homicide survivors as to whether or not they believe they can handle it. She clearly, or he, I don't know, couldn't, and I believe the appropriate thing was done. They left the court. But again, to say this is intentional sabotage and all the accusations that continuously get made are unsubstantiated. And it does not warrant a mistrial. People get warned, and sometimes they misjudge their own emotions. I don't understand what test we are expected to run on homicide survivors. So the motion should be denied.
Motion's denied.
Huh.
Jury's going to be back in about 13 minutes, counsel. So we'll reconvene at that point in time.
No, still no rebuttal yet. This is now the
Yeah, can we clean the well from the state's materials, please? Thank you.
Oh, what a jerk. No, China, the defense is about to do their closing. The prosecution just did theirs, and now the defense is about to do theirs. The defense just once again tried to call for a mistrial. I'm telling you, the defense is throwing everything at the wall to see if it will stick. This is the most aggravating trial. This trial could have been over by like Tuesday or Wednesday. We are on Friday. The way he is like pointing at the family like it's their fault. Dude, they've lost someone. It's been 4.5 years of this that she has put off and put off and put off. And now she has this team of lawyers who has done nothing but prolong this trial and do everything they can to keep it from getting into the jury's hands, and still doing it up until the 11th hour, trying to keep it from going to the jury's hands. And I just can't believe how he can sit there and so heartlessly say, if they can't handle it, they don't need to be in the courtroom. That is like, what can you do? Like, that is horrible. So I'm sure a victim advocate told them that there was going to be some things in the closing arguments that they would not probably be able to handle. And I don't think they realized that. Man, I cannot believe. I cannot believe he said that. I mean, I understand. I get it. I get it as a defense attorney. You're right. You can't unring that bell. The jury saw it. It is strategic. I get it, strategy-wise. But to just sit there and berate the family even more like that, that is heartless, Kirsten. Because, I mean, they literally just watched. I guess they have not seen that video, as much as it has been literally all over social media, and we have seen that video. And you know what's sad is I think that we are numb to that video because we've seen it so many times that we're probably numb to that video. And if this is the first time that his family has seen that video, then I couldn't imagine. I could not imagine how that must have been for them. Because I bet probably it was his mom or somebody that they have not seen the video. Yeah, it definitely hits us, but not the way it hit them. For sure. So, yeah, China, I think strategically, though, the prosecution should have ended. The way they opened their argument was great with the suitcase, but I think they should have ended with that video of him saying God will prevail and he will take us out of this. Little did Jorge know how God was going to take him out of this. So I think it's just absolutely, I know it's their job, but also I think it's terrible that they continue to. This is what's so hard about these kind of trials, is when there's someone who is passed, the person who has passed away cannot defend themselves. And that's the person who gets dragged through the mud. They're the person that gets their entire life, their entire past, everything gets brought out, and it doesn't need to be that way. You know, much like with Samantha, her whole, her family, a lot of stuff came out about her that they did not know. You know, they didn't know she was seeing several different men. They didn't know that she was seeing married men. Those are things that you don't want to come out about your life. I mean, it's like politicians, like there's things that come out that you don't want coming out when you step into the limelight of something. And little do you know that your death, your red rum is going to be coming out, drudging up things out of your past, out of your life, out of everything. And it's going to be on for the world to display, to see. And poor Jorge's little life, No, I don't know what that is, China. Is that on YouTube? What is that? That is just, it's just so sad. I feel terrible. But that's not the first time I've ever seen oh, I don't know who that is. Oh, it is the name of his channel? Okay. That's sad. See, that's sad. I'm making a video that will post after I'm gone. I know it sounds gross. Sounds sickening, but it's going to be set to post like after, this is my video after I'm gone to say goodbye to y'all. Yeah, I hope we get a verdict tonight, but like I said, the defense is trying to put off. They're going to have a very long closing. He's already warned the judge. It's going to be very long. He's doing everything in his power to keep this from getting in the jury's hands. Also, China, I think you missed, I was informed earlier by Kirsten, and I think Gwen said that one of the jurors is a victim of DV. She actually has a case against her husband for DV. So it's juror number 13. I don't know if she's an alternate or an actual juror or what, but she actually has a standing case right now against her husband for DV. Oh, see, they just told me that earlier. So I'm kind of hoping actually that she doesn't get a spot on the jury. So I don't think she should have been chosen. Actually, I think it's not good for her mentally. She shouldn't have been listening to any of this actually and be on the jury. I think that's not a good thing. Yeah, they said they asked her if she would be able to be neutral, and she said yes. And I just find that to be risky. I think that you can say that, but if you have a current case, then that's pretty fresh. I mean, my stuff is almost 20 years old, and I can tell you that there's no way. Yeah, there's no way that I could. I mean, just sitting through this trial was tough. And I'm literally going to have to go watch train wrecks and plane crashes now. Just to clear my head. So I don't know how I couldn't sit on a jury. And I wouldn't think that, honestly, China, like, I don't think if they were asking me on a jury, I don't know you people. Like, if you ask me in front of strange people, I don't know, like, have you ever been the victim of this or that? Or so, like, I don't know you, dude. Like, I'm not telling you jack. I don't know you. Like, I don't know you like that. Like, what are you all up in my personal business for? So, yeah, I mean, like, yeah, that's my business. That's not your business. But I think she probably had to answer honestly because she has a current legal case. It's not like they wouldn't be able to find out. Yeah, but don't ask me about my personal business because I'll be like, that's none of your beeswax. Yeah, I played some more of your video, China, during lunch. And it could have finished because they took another dang hour after lunch to come back. I was like, good gravy. Could have finished your Letitia Stalk video, but I came back and stopped it thinking they were actually going to come back on time. No, that did not happen. And then I screwed up and hit the wrong button and logged out of my own live. I'm getting smarter every day. I'm telling you. Yeah, I was on the fence. I thought at first, the defense team was doing pretty decent with this whole battered spouse thing. I thought, wow, he was a really bad guy. Like they had a very bad relationship and all this, and I was like, oh, because it was bringing back some trauma. But now I can see it was Jorge who is the battered spouse, and it still brings back some trauma, but it puts the shoe on the other foot. So it is she definitely did ask for it, China. Of course he's trying to get a mistrial, Kirsten. This is what he's been trying to do this entire time. I mean, this whole time. He's been looking for a way out. Okay, Brandy. Yeah, he's been looking for a way out this entire trial. And I mean, everything he can do to prolong it from getting in the jurors' hands. And Florida is a unanimous decision, right? I mean, it's only 6 dang jurors, for God's sake. So surely to goodness, they have to have all 6 agree. And we are waiting for a verdict tonight until they let them go. So hopefully they will come back with a verdict tonight because I need them to. They need to come back. Okay, I will be right back before the defense starts their closing. I'll be right back. And we're back. Where are you going, Gwen? Oh, I was like, I thought you were going somewhere. I was like, where are you going? No, he said Monday. Wait, maybe we're the ones saying Monday.
We are back on the record, 2020 CF 2603, State of Florida versus Sarah Boone. State appearances for the record.
Dave Ketchner on behalf of the state.
State of Florida, State of Florida.
I'm gonna have to look it up.
James Owens for Sarah Boone.
Kevin Beck on behalf of Sarah Boone. Tony Henderson, Sarah Boone.
Ms. Boone is still seated at council's table wearing the same clothing from this morning. Are we ready to bring in our jury for the defense closing at this time? State. Defense.
Judge, I would like you to give the audience an instruction, and then if you would instruct the state attorney to instruct whatever family members or friends of George Torres may not be in here and may not be able to hear the instruction, but may come in during the trial, so that we can try to get some order.
Are there any other members of Mr. Torres's family that may be outside that may be joining us? Okay, all right, so she's left, she's no longer here? Okay, that's what I just asked. Is there anyone outside? Okay.
No, not on the weekends,
All right.
Gwen.
So, members of our gallery, good afternoon. I'm going to please ask you to please contain yourself and not to have any emotional outbursts. We had a minor one, and the person, whoever it was, had a small outburst, then hid next to another family member, and then excused herself during the last during the closing. It seemed to be minor in nature. However, I'm advising everyone that at this time, if you believe that you cannot control yourself or your emotional responses during the defense's closing argument or any rebuttal by the state, I'm going to politely ask you to excuse yourselves at this time. All right, thank you very much. Mr. Owens, anything else, sir?
No, sir.
All right, state.
We're ready.
All right, let's bring back in our panel.
Boy, the judge just downplayed that. He said it was minor in nature, small outburst.
They're making their selection.
Okay, thank you. All can be seated. They're making their dinner selections. We'll just give them a couple minutes to do that. Thank you.
Man. When this trial is over, y'all just meet Mr. Owens out in the parking lot. Gosh, he looks just like his brother. Just a little more meat on his bones. Yeah, I don't know what he's getting in return for this. And are they partners, all of these attorneys? I don't even know if they all know each other, like work in the same office, or I'm actually trying to remember how long it takes for your eye to get that color, like hers was when she called, when they took her picture, where she took her picture or whatever of her black eye. Because one of the times when that happened to me, I went to work the same day. And I remember I know it happens quickly because I I remember putting a flamingo Band-Aid over my eye. It was so stupid. So stupid. I thought that was gonna hide it like a dummy. But my eye was swelled shut, and I had it cracked my the bone in my eye. But the next day was much worse. Yeah. It was worse than the next day. It wasn't as bad immediately, but I couldn't even see out of it that when it happened. So I remember, so hers, I'm just trying to remember the stages of a black eye. And hers was like hers was super dark. I don't know. I don't know. Owens is going to have a lot to say, though. I know that. Yeah, but the judges ask her every time, are you satisfied? Are you happy with your defense? Are you okay with what they've done, the work they've done, blah, blah, blah. And she's been very definitely, she's answered every time with it. She's been very, very happy with them. Which I don't think she had any other choice, but she has no other choice but to answer that way because this is her last attempt with any attorneys. She doesn't have any other shot at attorneys. And look at how many she's got right now. She went from 0 to 5? Oh, goodness, people, decide what you want for dinner so we can get on with this poop show. Well, now the jury's making them wait. Serves them right. Serves you right, defense. And making them sit back there for hours on end. I wonder if these little bodyguard people are going to sit there all night too. Or if they have to leave by 5. All right. This is enjoyable. I wonder what they're getting to order for dinner. What is he pointing at? He is like a big old baby, just like her. Well, this is like when a football team calls timeout just before the team that is about to snap the ball throws them off. And they're like, "Dang it, we almost had it." The defense team right now, their whole like game, they're all cattywampus right now because they were getting ready to do those closing arguments. Now the jury's like, wait a minute, we got to order dinner. So now his head is all just, hopefully it's playing tricks on him. Oh, and to your question earlier, Gwen, no, I have a cushion. I have a butt cushion that's not helped. I have a very fancy chair. I have all the things. I even have a ball that I sit on. I'm supposed to have that other procedure done on my back. I need to call the doctor next week about it, actually. I feel like I need one of those walking desks. I think I'd get tired of walking though, but maybe if I did have a walking desk.
Okay.
I was just, I don't know if that is allowed by the court or.
Anything?
Been allowed since I started practicing in 1997.
If you want to split up your closing between the two of y'all, that's fine by me.
Well, I
See,
intended on doing the closing, but when I finish, Mr. Henderson wants to say something. I may ask you to.
I've never seen it done that way. I've understood the sandwich can be broken. I've never, ever seen a single closing argument split by another attorney.
If it's a discretionary issue, I'll leave it up to you, sir, on what you want to do and how you want to present your closing.
oh my God. They just constantly, this is never ending with this these people. I just. Who's doing the closing arguments? Rock, paper, scissors, go. Rock, paper, scissors, shoot.
Reasonable. Who would be objecting during rebuttal?
Mr. Owens.
Okay, there you go.
Oh my gosh. Do you want to split up the closings? Mr. J, I have never seen that done. What are you talking about? Is it going to be that long? She can't scream it's not intentional anymore, Gwen, because it was clearly now intentional. If they have to have two attorneys give closing arguments for the defense team, they must have like a 4-hour closing. Look at him. 1, 2, 3. We're going to have 3-hour closing. They just don't know it yet. What in the shenanigans? All right, jury, pick your food. It's jury food, not freaking. Finally, it's happening. Oh. Mm.
Henry.
Mikey's. You know what? Okay. All right.
State, you recognize our jury.
Yes, Your Honor.
Defense, do you recognize our jury? Thank you. Y'all may be seated. Members, jury, for one of the last times, if you could, please raise your hands to confirm that you complied with the court's instructions. All hands have been raised. Members of the jury, at this time, the defense is going to proceed with their closing argument, similar to the state's closing argument. These are not evidence. These are just arguments, and I ask you to pay attention to them. Thank you. Mr. Owens, you may proceed, sir. Yes, sir. Thank you.
Ladies and gentlemen, good afternoon. Y'all know me, I'm James Owens, along with Tony Henderson and the girls, we're all from Milton. I think y'all figured that out, that we were from out of town. Santa Rosa County, it's northwest Florida, close to Pensacola. And my buddy Kevin Beck, he's a longtime friend, he's from New Mexico. The team, the defense team, is here, and we're here to represent with Sarah Boone. And we feel confident that we're going to be able to show you why she's not guilty. Okay? And I'm going to take my time. I've got some notes. I'm not the most organized person in the world. I've got some exhibits that we're going to show you. And then we got a couple of videos at the end. Okay? And we're going to try our best to help you make the right decision. Okay? But yeah, Milton's a small town.
Objection. Problems.
Overruled.
See how small it is. 7 miles away is another small town called Pace. In between that is a Walmart. Very small town. We didn't know what to expect coming down here to Orlando.
Relevance.
Judge, I'm allowed to.
I'll give you a little bit more for intro, but then we need to get into it.
Yeah, see what I mean?
I'm going to get into it, but I wanted to say, it's a small town, good people. We've been down here 3 weeks. We didn't know what to expect. We've been surprised. From
Objection. Improper argument.
Mr. Owens, approach.
I mean, see, he's trying. Look what he's doing. No one gives a rat's patootie who you are. Nobody cares what town you come from. Nobody cares. Get on with it. This is supposed to be a compilation of the evidence, a summary of the case that you presented, fighting for your client's innocence.
Objection's overruled.
all I wanted to say is just, since we've been here, we've been treated with respect and hospitality, and just like we've been at home. We appreciate that. Now, I'm going to do some reading, and then I'm going to do some talking. But ultimately, this is about
Jorge.
Justifiable use of force. That is a legal defense in Florida. We as citizens, the law is designed to protect us from defending ourselves, to protect us from potential attack. And you are the only ones, in this case, because Sarah Boone was arrested, that's going to be able to look at it critically and objectively. Objectively. Not like the state attorney.
Objection. Improper argument.
Overruled.
Objectively. And the law in Florida gives y'all the power and authority to do that. The state attorney can't make the decision. They can't make the decision. They can try to influence you. And we're going to talk about some of the things they did here in this trial and some of the things they said.
Objection. Objection. Motion.
Yes.
This is awesome. Look here, Blondie. You can't possibly be sitting there and thinking that anything that comes out of her mouth is her hair always looked like a rat's nest. Oh my goodness.
You may proceed. Objections overruled.
Thank you, Judge. They've got their side, their position, we've got our side. So we're gonna talk about that. But, and we're gonna talk about justifiable use of deadly force and non-deadly force.
He's totally
Either
thrown
way,
off.
However you rule, it still justifies her behavior. And the result is not good. Now, I don't believe there's anybody.
Proper argument.
Overruled.
He's totally discombobulated. Look at him. He is like, Lord help me. Yeah. He doesn't know what to do. He came back from that and was like, blah, 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 justifiable, blah, blah. He comes from a small town. He was born in a he was raised in a middle class house. Home. It's what he gets.
I think you will find from considering the evidence in this case that there is no doubt that Sarah Boone is a victim. That Sarah Boone has been traumatized. That Sarah Boone is still traumatized. And the reason for the trauma is Jorge Torres. The reason for the trauma is Jorge Torres. From the positive things about the man that we've seen on video, to the positive things Sarah Boone has testified about, to the violent monster he becomes. And I mean monster, because it was repeatedly. And what happens the next day? Man, I don't remember. I was drunk. I don't remember. That's the gaslighting. That this young woman, vulnerable woman with nobody, just starving for love, starving for attention, and seeing the good in the man. And it was good. But every day was on the balance. She measured every day, depending on how it started and then how it ended. And that's the way she had to live her life, day in and day out, day in and day out. Dr. Harper and Dr. Brandon talked about trauma. Dr. Harper spoke of the veterans that she had treated for post-traumatic stress disorder. I don't know if you remember her testimony, but she spoke about some of the veterans that had been in the war in Iraq, you know, and people in war a lot of times get post-traumatic stress. It used to be called shell shock and other things. But people in wartime, or police officers, police officers will get post-traumatic stress. And a lot of them come in, the males come in with this bravado, I'm all right. I'm all right. And so that's why Dr. Harper was talking about the veterans. That's what they'll do. But you got to spend time with them. It just can't be one session. And you've got to run post-traumatic stress testing, which tells whether they really have post-traumatic stress. And we all probably have experienced some trauma. All of us have lost some loved ones. And it's awful. You're in shock. You can't believe it. It's disbelief. You don't sleep for days. And eventually, you have to go back to work. You take a week off. Life has to go on. Life has to go on. You go back to work. Kids are in school. You get a little time, right? Time heals, right?
No.
These veterans that come back from a deployment, they get back, they get some semblance of normalcy. They may or may not get some treatment, but time helps. Time heals. Everybody, it helps. Just time. Overcoming a divorce, overcoming a death, whatever trauma. Sarah Boone had no break.
Tons of breaks. Tons.
No break. Learned helplessness. Just giving up. Just giving up. I can't get out of this situation.
What?
They broke up. She'd go about 2 days. Go about 2 days. Texting, calling. Just learned helplessness. And it's, in the manual. Battered spouse syndrome is not, but what did you hear Dr. Harper say? She suffers from post-traumatic stress. That is a mental disorder. You are actually undergoing the psychological effects of post-traumatic stress. You're not in your right mind.
It's not how it works. You don't chase.
It's repeating itself again and again, day in and day out.
You just go back. It's not how it works.
And when you look at this law, that's what you have to apply. Someone in Sarah Boone's shoes, when you're deciding whether her conduct was reasonable.
Clearly, you've never been abused, so you don't know what you're talking about.
Got a bunch of notes.
But I'll tell you, you don't call the person and beg them to come back to you, ever. You just hope and pray they're going to change and never hurt you again, and they call you and they beg you, and you go back, thinking this time it'll be different, like a dummy. The very definition of insanity. So annoying to have people literally who don't know what the hell they're talking about.
Exposure to abuse created a state of learned helplessness and diminished her capacity to assess risk, especially in moments of heightened stress. The cyclical nature of this violence, the tension building, the battering, the contrition phases, caused Sarah to be trapped psychologically in that relationship. Due to this clear abuse, Sarah Boone had a reasonable belief of imminent harm under her state of mind. Jorge Torres had a history of violence against Sarah, and as a result, Sarah Boone's actions were the result of fear conditioned by abuse she endured over time. The cumulative effects of long-term abuse, as we saw her behavior on the 2-minute Suitcase video, is a trauma response. Sarah Boone acted out of a sense of preservation. While tragic, it was not driven by malice, but a mind ravaged by abuse.
No, it's not.
And I'm going to ask you to try to understand. Try to understand. Sarah Boone being emotionally and psychologically broken, whose actions may have been misguided attempts at survival but not murder. Imminent danger, her response reacted to that belief. It's somebody suffering from the long-term psychological effects of domestic violence. Who spent a lot of time? Dr. Brandon, you remember him. He was the first expert on trauma. Took some notes. Kevin Beck, you remember, did the direct examination of Dr. Brandon. He was from down in Miami, I think. He talked about the trauma that you cannot escape from the abuse, so you develop coping skills to protect yourself, knowing that the bad things will happen to me. It changes your behavior, not only your behavior, but your thinking, your subjective thinking about fear and what to do. And if you remember, Dr. Brandon said it's all about that person's perception, okay? A lot of times they will self-medicate with alcohol or drugs. A lot of times they suffer from anxiety. Basically, he said the trauma ends up being terror because you do not know what to expect. You do not know what is going to happen that night. It may be a great night. You may drink, and both of you have a great time. He falls asleep, passes out, you fall asleep, passes. But it may turn by, depending on his mood. I don't know if you can tell, she would try to placate him. Dr. Brandon said, you know, when you're trying to evaluate somebody, it takes time to get them to trust you. And the ultimate goal, he said, is to be a behavioral detective. If you're a forensic psychologist, is to be a behavioral detective. And the ultimate goal is to put yourself in the abused person's eyes so you can better understand their world. But ultimately, it's their perception of danger. Their perception of danger is what you have to look at. What a reasonable person would do under their perception of danger. Now,
So it makes sense now. He's from a tiny town. He wanted to make a name for himself. Nobody's ever heard of this guy. So
trauma experts explain how victims' reactions in moments of stress are the product of the damaged psyche. Her actions, although tragic, and it was a tragedy, Jorge Torres lost his life in that suitcase. It's a reactionary response to sustained trauma. It's as if Sarah was acting out of a deeply ingrained fear and helplessness developed over the years. So it's a desperate need for survival, but battered women do things to keep the peace from time to time. And when they feel like they have a small portion of momentary power, they may enjoy that by vocalizing their position to the abuser. Sarah Boone's not perfect. Sarah Boone would argue with him, talk down to him. Some would say was somewhat abusive to him.
somewhat.
Sarah's not charged with that. Sarah Boone is not charged with that. And I want to read you something on that subject.
So
essentially,
Just FYI, if you talk to your abuser the way she talked to Jorge, you get your teeth knocked out. Just saying.
Okay, I don't know where it's at.
Or you get another black eye.
I have to come back to it.
Lots of things happen.
Essentially what it said was,
But you don't talk like
is
that.
eventually,
Okay.
it's been a 2-week trial. I got a bunch of notes. I'm trying to get this right. I know it's important.
No, you're not. You're trying to prolong this as long as you can.
What I wanted to say was someone can be mean and angry and hateful, intoxicated, and still be abused.
You can, yes.
They're not mutually exclusive. And mutual abuse exists where one is abusive towards another. And eventually the victim, Sarah Boone, trying to fight back against the abuse, became verbally abusive. While the victim has committed verbal abuse, it is important to remember that they, Sarah Boone, are the victim and have been pulled into an extremely vicious cycle where they are trying to survive. Sarah Boone intentionally left Jorge Torres in the suitcase. What's the act of a battered spouse syndrome woman? She went up to her room, she fell asleep and passed out. These actions are disconnected. Ultimately, she didn't let him out because of her fear that she knew if he got out in that moment, what he would do. That's real fear, that's real trauma that she was experiencing at that time. Now, I talked to you about force being used. And I think I talked to you about blocking an attack using a physical restraint like the suitcase to block somebody's attack. And the example I give, I got a couple of examples that may or may not apply. Let's say you're in a bar and you got your buddies and the other guy's got their buddies and they're drinking and it ends up being an argument between two of them. And you realize that these two are fixing to get in it. Well, one of your buddies comes around on the other side and grabs the guy before he's able to strike him, right? So you're committing an offense on this guy, but it's a restraint. It's a restraint where you grab him by the neck and try to get him out the bar. So yeah, you're committing an act, but it's designed to defend another, which is legal. Or let's say you have a situation where you have a police officer and he's on patrol. You know, he's in uniform, he's wearing a firearm, and of course he's got the bulletproof vest. And he goes to a call where there's a suspect that may be armed. A suspect that may be armed. And so he gets there, he gets out of the squad car, he's walking around. Of course, he's taking out his gun because he realizes he may be armed. And eventually he sees the suspect, and the suspect reaches for his waist. Now, in that moment in time, that officer has to make a decision. Am I going home with my family tonight? And I asked Dr. Werner about this Vaseline thing, it's called fear response or fight or flight. You know, those decisions are made, it's instinctive based on your set of circumstances. She instinctively reacted to her unique set of circumstances to save her life or save herself from another one of these. I'm 63. I can't imagine that. I can't imagine that. father's not around.
She's in her 40s.
I need to talk about the case a little bit. And if you'll remember, I'll get back here. If you'll remember, lost my place here.
He is all over the place. Even the judge is like, what is happening?
Let's start with the witnesses, and then I'll talk about Sarah. But the first witness out of the box for the state, if you remember, was Juan Torres, the brother. Remember that? It was some time ago. I know it's been a while. Y'all taking notes. You may have to go back. Their first witness was a good witness for us. Their first witness in their prosecution of Sarah Boone for murder was a good witness for us. Remember Tony Henderson did the cross-examine of Juan Torres. Asked him, what did you hear Sarah Boone say? Juan Torres, she was yelling, he's been choking me. He's been choking me.
Okay.
Mr. Henderson said, did that surprise you? Juan Torres said no. That family knew what was going on. The police knew what was going on. The neighbors knew what was going on. Pearl Walker came in here, 80-something years old.
Yeah, y'all brought her in there.
Kevin Beck called her up. She saw it. Is there any doubt? Is there any doubt? I tell you why there's no doubt. In cross-examination, I got Dr. Warner to even admit. Did you hear it? Yes? Okay, Mr. Owens. She suffers from battered spouse syndrome.
Yes, there's no doubt it's a toxic
If
relationship.
it on direct, well, maybe I don't really know. I hadn't had enough time to really see her. You hadn't seen the pictures? You hadn't seen the 2-minute video? You've seen her one time earlier this month. One time. And she's going to start testifying about stuff she's never said before until she showed up in court. About, well, based on what she told me, I don't think she was in imminent fear. Come on. This is a courtroom. This is a courtroom. Good thing y'all are here. Well, thank you. But it gets even worse than that. It gets even worse than that here in this courtroom.
Yeah, you.
The state attorney referred to these pictures. That I was going to rise up and
Overruled.
show these pictures to you.
Overruled. You may proceed.
That I was going to rise up and show these pictures to you. Well, yeah, I'm going to do that. They put her on trial for murder. But what did they say? And I got to turn to this. Make sure I get this exactly like they said it. I took a bunch of notes. Let me make sure I got this quote.
You took a bunch of notes. I'm pretty sure Sarah took all those notes. Look at all those notes.
It was something to the effect, maybe Jorge Torres is the battered spouse. Can you believe it?
Yes.
Can you believe that? Now you know why we're here. Now you know why we're here. Little boys learn early on that girls are different.
Oh.
You do not put your hands on a girl.
What?
You can't wrestle with them. You can't punch them. You can't kick them.
That's not true.
Treat women that way.
It's 2024. You can do all those things
When
now.
you become adults, I don't care what she does to you. I don't care what she says to you. If she gets in your face, whatever she does, you do not have a right to hit a woman.
You tell that to.
No, sir.
You tell that to the Democrats. Because they want it all the ways.
What has the state attorney tried to do?
Protection, proper argument.
What have they done?
Protection.
What evidence have they tried to put on?
Overruled.
What evidence have they tried to paint Sarah as? What evidence? Controlled and manipulated were the words they used. You know, this ain't the 1900s. This is 2024.
You're right. Keep on, buddy. Dig yourself in deeper.
What's all these text messages? Why is that relevant? What are they trying to claim? She provoked his violence? She provoked his violence. Isn't that what they've done here?
He never got violent. He never responded with violence.
Let me get back on this. Abraham Marino. I don't know if you remember him. Abraham Marino changed his statement. They took a statement from Abraham Marino in which Sarah stated, I don't know if you remember, but it was when the police were all there. I think they got the tape out and some neighbors were coming around and there were 2 or 3 neighbors sitting around. He said, Sarah came out and stated it was an accident. Okay. Well, then it was an accident. And this, Abraham Marino knew Jorge Torres from Philly. Okay. They were friends. They would talk either at the complex or if Marino went to Hall's Ace Hardware or Ace Hardware, what it's called. The state attorney notifies.
Judge, I'm going to object to reading from things that are not in evidence.
Approach.
Oh my gosh. This is awesome. But I mean, this is so discombobulated and disorganized and just unorganized. I don't remember these witnesses anymore at this point. Honestly, all of the witnesses are drowned out by the videos and the text messages and just the crazy crap that she did. It's honestly, all the witnesses are overshadowed by everything that the last stuff, the rebuttal stuff that the prosecution showed. It has really drowned out any witnesses prior to the rebuttal from the prosecution. I hope the judge is telling him, look, dude, you need to speed this up. Like, figure out what your strategy is and get with it. Yeah, those, I mean, you can't say she was in fear. I mean, literally, the prosecution can bullet point and get their point across. She said they were having an amazing weekend, amazing day. Everything was great. They were playing, having fun, puzzles, crafts, arts and crafts. They were drinking, but she wasn't drinking. She wasn't intoxicated. Everything. She was perfect. She's an outstanding mother. I mean, my God, just play her interview. She was amazing. She's perfect. Best thing that ever happened to him. She did everything for him. She's wonderful. Perfect. Nothing's wrong with her. She's great. They were having a perfect day. Amazing day. They hadn't argued in weeks. Literally the only thing they were having issues with was finding jobs. That was it. No, nothing. It was a complete accident. Everything was an accident. She fell asleep. He was in the suitcase. Done. And now she's claiming this self-defense, afraid for her life, battered spouse shenanigans. But all the evidence leads to her being the instigator and the abuser. When he's literally the one that's like, yes, ma'am. No, ma'am. The total submissive one. And I know that we saw that the interview with his ex-wife and kids in Philly, but there's a reason that the prosecution didn't call his family up there.
You may proceed.
And have them
So for
testify.
4.5 years, Marino says, all I heard Sarah say that afternoon was it was an accident. And then he came in here today, or this week, and said, no, she said I was teaching him a lesson, things got out of hand, and then I fell asleep. 4.5 years later, we know he's friends with Torres. We heard it here. Now, I want to talk to you about the two boys that live right next door. You remember Vincent Battaglia and Brandon Motes. Remember those guys? And you remember it came out in the testimony, you know, this event happened on February 23rd of 2020. But it came out in the testimony that Sarah had said, Jorge Torres, the night before, February 22nd of 2020, grabbed me by my hair and pulled me down the stairs in my apartment from top to bottom, which is consistent with what they were saying happened, remember? But they got their dates wrong. And remember, Mr. Henderson called Deputy Copsel or Detective Copsel up in our case, and she had to say, yeah, I didn't take their two statements until the 27th, February the 27th, remember? So they're remembering back, and they both had similar stories. Of course, they had time to talk by then, the 27th. I think the only recorded interviews they got that the night of this event, February 23rd, was from Sarah Boone and her ex-husband, Brian Boone, right? So they came back following up on the 27th. That's when they got a statement from Brandon Motes and Vincent Battaglia. And at that time, they said, yeah, we heard that sound. You remember Sarah testifying? No, that was the night before. I complained about that, and I think one of them had testified. Yes, she had said something about being drugged down the night before. It may have been, can't remember now who it was, one of them. And, you know, it looked like that there may be some implication that Sarah got him in the suitcase and pushed him down the stairs. But I think we didn't hear anything more of that. Remember? And then this photograph, which we introduced, which shows the bottom of the stairs. As you can see, there's Lucas's bookshelf right here. This is where Sarah Boone stored Lucas's stuff. You can see it's not disturbed at all. Anyway, I want to get back to Sarah. I want to talk a little bit about that, but let me talk a little bit about the law on justifiable use of force. Is legal and lawful if you reasonably believe. I think we all probably all.
Oh no, China.
You reasonably believe it was necessary to prevent imminent threat to harm. The law is crucial, ensuring that individuals can safeguard themselves in potentially dangerous situations.
That
By
sucks.
acknowledging you have a right to defend yourself when you have a reasonable
Hope you
belief
feel
that
better.
force is necessary to prevent an attack. Okay. What did Mr. Henderson say in jury selection? You don't have to wait. You do not have to wait. If you're facing in your mind a reasonable imminent threat, you don't have to wait. Let's talk about Sarah Boone.
Oh, I know that. That sucks.
And this unconventional form of physical restraint.
I think my boyfriend's getting that right now. It's gnarly.
What did she say? Salt tape. Now, you got to think about that. You got to think about what was going on. You got to think about the trauma she was undergoing. You got to think about they both.
I hope they gave you some
and you got to think about
a Z-Pack and steroid shot.
For a while. And I think the biggest thing to know is that Jorge Torres chose to get in the suitcase. He's a grown man. That was his choice. She didn't force him in at gunpoint to get into that suitcase. He voluntarily got into that suitcase because they were drunk and being silly and stupid and playing hide and seek. Which I guess when you get so drunk, that seemed like a good thing. Zipped him up, they're laughing, carrying on. And as you know, Sarah likes to videotape a lot. And I know you've seen some of these videos and you're wondering why, but I think the evidence shows that when George is being videotaped, he's not going to do anything. If you think about that, when George is being videotaped, that's like her power. You know, Dr. Harper said that Sarah's words are her power. Sarah's words are her power. Physically, she's no match for him. Physically, she's no better. But that's her power, is her words. When she gets a chance, to have some control, that's what she does. And she videotapes, because she knows when she's videotaping, she can tell it like it is. I can tell him what I want to tell him. A couple of these videos you've seen, she's telling him like it is. But she's got that video camera on, and George knows he's being videoed. We've got one that we're going to show you in a little bit, where he loses it just a little bit, right at the end. And of course, we got the TV. But they're kidding around.
Hey, Silencing Whispers. Long time no see.
This is my chance to say something to him.
Welcome back.
So she sits down, she turns on the phone. And
Have you been keeping up with the Sarah Boone trial?
You've seen the tape. For everything you've done to me, are the first words out of Sarah's mouth when the video begins. There's a lot packed into those words. Think about that. For everything you've done to me. This is how it feels when you choke me. Now that's in direct response.
We're in it for the long haul today.
And the result of the abuse that she has suffered.
We're not leaving till they leave
She wants
or come back with a verdict.
for that moment to feel how she feels. She wants for that moment to feel, for him to feel how she feels. How uncomfortable, lack of control that she feels when George is violent with her. Just for a moment, she wanted to be with him. And if you can imagine,
Oh my goodness. His entire closing argument has been interrupted like so many
I think
times.
from the evidence, you can determine she was crazy. She was crazy about that. And I don't know if, of course, it's a syndrome, but she felt like she couldn't do without it. And let's say she videotapes him, and then it's turned off. And there's a 9-minute gap, 11-minute gap, whatever it is. I said 11, they're saying 9, but I think if you count 2 of the others, that's not. But there's 9 minutes that we don't have video. But what did Sarah say? Now, if you remember when you listen on that video, George is talking in a normal voice. He's not stressed. Of course, if you're talking, you can breathe. She had said she had some air.
Oh, yes.
And of course, she doesn't realize the situation, that it's going to end the way it ends. So she has no appreciation of that. It's a canvas. All she knows is an old canvas suitcase that she's got some, the 2 zippers removed or spread out a little bit so he can. So she thinks he's not being serious. But eventually he gets angry. She gets angry, he gets angry. He says words to her, and then his hand starts to come out of the suitcase.
2 fingers.
She also said his tone changed. And I know everybody's got a cadence with their spouse or boyfriend, girlfriend, but you know what I'm talking about. We've got a way of talking to people. We've got a way, your wife, your husband, you know each other. You know when they come in from work, what kind of mood they're in. Just by a couple of things, the way you can just sense it, right? Well, especially somebody as hypervigilant as Sarah. And as
Not a
hypervigilant
word,
as the
Silencing
family
Whispers.
spouse
It's been,
woman.
she's.
That he can flip the switch at any time. When I get out of here, I'm going to end you. And he realizes he's getting out. He got his hand out.
Not a thing. He doesn't know anything. He's really irritating.
At that moment in time, in Sarah's mind, that's an imminent threat. So she's got a justifiable right to use force. What did she do? She went over there and grabbed it. She lifted it up. She tried to get his hand back in, remember? She tried to get his hand to go back in. Wouldn't go back in, so her son's back was 3 feet away.
Try to go back in with a
When the
baseball
police
bat.
found it the next morning, same spot. No attempts to hide. No attempts to delete phone. No attempts to tamper with evidence. Nothing. In the same spot as it was. She picks up the bat. She pokes. She pokes him hard, trying to get him to stop trying to get out. And eventually he does. And you've seen the blunt force injuries. And you saw some of the circular injuries where you can tell there's a poking. I think it's right around here.
You are
She
not
poked him
helping.
several times. You remember the pathologist said, I think maybe 5, 6, or 7 times. She pokes him. And he's got some scratches. I don't know if they'll let you look at it, but on the back of that suitcase, it's got some bars, some metal bars that are inside the lining. There's some lining, and it's for support when you.
You're not helping. That's not helping. Keep going.
She testified. You heard what she said, that she was justified. That's uncontroverted testimony. Now, let's talk about the jury instructions just for a minute.
Yeah, she did say that. She said a lot of things. She said it was an accident. She wasn't drunk. She's the best thing. She's an outstanding mother. Best thing that ever happened to him. Did nothing but help him, work on him, like he was a project.
Let me find it. If y'all are all looking,
Yeah, she's.
I think it's on page 15 of 22. And we're going to talk about reasonable doubt in a minute, but if you look at those bottom 3 short paragraphs, it is the evidence introduced in this trial and it alone that you are to look for the evidence or look for that proof. A reasonable doubt as to the guilt of the defendant may arise from the evidence itself, a conflict in the evidence, or lack of evidence. But here's the main thing. And, obviously, I represent her, and I'm trying my best to show you honestly and fairly the doubt in this case. And 5 reasonable doubts, 17 reasonable doubts, 25 reasonable doubts. You have to have 1 reasonable doubt. I'm trying to show you throughout the evidence that each one of you can have a different reasonable doubt. Difference, but 1 reasonable doubt about the state's case, and your verdict is not guilty, according to them. Proof beyond a reasonable doubt does not mean proof beyond all doubt. A reasonable doubt is not a mere possible doubt, speculative doubt, or imaginary or forced doubt. Such a doubt must not influence you to return a verdict of not guilty if you have an abiding conviction of
Oh, I know it's driving me crazy.
held belief. Reasonable doubt is the highest standard we recognize in litigation. Car wreck or something like that is preponderance of the evidence.
He's been pushing this and pushing this, trying to keep it out of the jury's hands.
That's a deeply held.
He does not want them to get this case
Thinking about something.
because he already
That's a
knows.
firm belief. That's a level of certainty that you would have. That's what you got to have as a jury. I've got to be certain of her guilt. If, on the other hand, if after carefully considering, comparing, and weighing all the evidence, which we want you to do, there is not an abiding conviction of guilt, so I'm not certain. I'm not certain of her guilt. Or if you have a conviction, I think there's some evidence of guilt, but it is one that is not stable, one which wavers and vacillates. One which wavers and vacillates. Then the charge is not proved beyond a reasonable doubt, and you should find the defendant not guilty because the doubt is reasonable.
No,
Understand that?
there's no doubt.
You've got to be certain of guilt. That's the high standard we recognize. If you've got some evidence of guilt, so okay, there's some evidence for conviction, but it's not it's not stable. It wavers and vacillates. Then under our system, you've got a reasonable doubt. And you've got the power and authority and the obligation under the law, if that's the way you feel, to vote that way.
So here's a thought. Even though he willingly got into the suitcase, he didn't willingly get into it and say, I'm going to get in here and never come back out.
And which evidence should not be relied upon in considering your verdict. You may find some of the evidence not reliable or less reliable than other evidence. You may rely on your own conclusion about the credibility of a witness. That is totally the province of the jurors to decide. The juror may believe or disbelieve any or all the part of the evidence of the testimony of any witness.
Because that's literally the only hiccup any like normal, reasonable person would have is, well, he did get in there. He is a grown man. He did get in there on his own. Yes, but he didn't get in there and say, I ain't never coming out.
This is their expert again.
I'm in here.
He testified that Sarah Boone suffers from battered style syndrome. Battered women's experiences affect her perception of imminent danger. Those past experiences with Jorge Torres.
Yeah, we only know her side of the story. We don't know what actually happened. She says he got in there on his own. We don't know that. I mean, well, obviously he got in there on his own. But we don't know if, you know.
Victims of repeat violence may fear death in situations others would not. The reason Sarah experiences all this, the reason she was feeling the way she was feeling, that imminent threat of danger from Jorge was because of Jorge Torres.
Oh my God. I couldn't get my abuser to get into a suitcase to save my life. There's no way.
Because the
literally
way
to save my life.
Treated her. She reacted to his attempts to get out because of the way he treated her and the way she knows what is he going to do if he gets out of the suitcase? She knows. The second video is played. She's flipped it back upside right. You hear him, it's 22 seconds. He says, Sarah, she's not going to open that suitcase. She's not going to open that suitcase. He's already threatened her.
How do you know?
She used the bat to get him to stop trying to get out of it. Why would she do that?
Because she's a meanie.
Why would she do that?
A big old giant
I know what
meanie.
he's going to do. I know what he's going to do to me. I know him like I know more. I know him more than he knows himself. I know what he's going to do to me. You don't have to wait. That was justifiable. Now, you got to understand this. She intentionally used the bat to defend herself.
From what?
She intentionally
a suitcase?
Didn't unzip him to defend herself. Both of those are lawful.
Right? Silencing whispers, there's no way. And I would never talk to my abuser the way she talked to him. There's no way. You would you'd lose teeth. You would lose an eyeball. There's no way.
She testified, or somebody in court said she would often flee to her ex-husband's house sometimes. I believe that testimony came out from either Sarah or somebody. That sometimes she would flee, or sometimes she would flee to upstairs. One of those two. But the dogs were up there. She made a phone
If
call.
you ever got brave
At some
enough to
point, she
talk
fell
that much
asleep,
smack
passed out,
to the
fell
person
asleep.
that you know is
We don't
probably
know.
going
They
to
had
take you out, you better be
2 beer
prepared for the
bottles of
hit.
wine.
That's all I know. Just be
Right.
ready.
That was unintentional. That was unintentional. His death was unintentional. You remember when she was in the interrogation
Oh, heck
room?
no. I wouldn't call the cop. Are you
Remember that?
crazy? Hell no.
Now,
You don't call Popo.
I don't know if we did a good job of this, but it came out
Exactly.
that she got arrested. You remember the one time when she got the black eye? She got arrested for strangulation. And you remember that? It was, they ended up over there by the dryer, and he was banging her back of her head on the floor that had very little carpet on it. And she ended up getting her arms out, and then she grabbed his neck. And she eventually got him off of her. And that's when he got up and stomped her in the eye. Remember? Well, the police came for that event, and they took statement, and Sarah was honest with the officers about what all, and they arrested her. You remember?
Sometimes they can't tell if they
Remember
have to
that?
take
They
both of
arrested
you or
her.
one of you or none of you.
And she said, why? I was fighting back. You remember that? Why? I was fighting back. So from that point on, she didn't trust law enforcement. The video that they showed a while ago about George, that was about dropping the case, where she was defending herself and fighting back. I want to talk about this investigation by law enforcement. Now, she didn't know the law. She's not a lawyer.
Obviously.
She gets up the next morning.
Ignorance of
Brian's
the law is not an
Sarah's got to
excuse.
pick up Lucas at 3. Brian's calling. Eventually she walks down. She's looking for George. Where's George? He's quiet down there. And she looks in the bathroom. She looks out. He's smoking a cigarette. He's on the computer. She sees the suitcase. And you can imagine.
Objection, golden rule.
Sustained.
She sees him in the suitcase. She panics. What does she do? What does she do? She
You
tries
call
to get
911.
her fiancé out of the suitcase. They're engaged to be married. She's not trying to kill him.
What? You
They're
just
engaged
said
to be
she
married.
intentionally
Gets
left him in the
out. She
suitcase.
tries to do, he's purple. She tries her best to do CPR. She doesn't, you heard her. I didn't know what to do. I didn't know, call Brian. That's her safety valve. That's all she's got. Brian eventually says, she's come over. She calls again in 2 minutes. I'm on the way. He gets there. You got to call.
I don't know about you
911.
silencing whispers, but I've already said a million times
She
after
calls
this
911.
trial, I'm going to have to watch train wrecks and plane crashes because this has been very traumatizing for me.
Is she busy trying to hide evidence? She busy trying to hide evidence? She busy trying to hide the back? No, she's trying to save his life. If she can. So the police get there. She knows. if she told them
So
to
much,
fall back, she's gonna
so
be arrested.
much.
That's
Like
what
I
happened
can't
before.
stop. It's just been on replay
What happened before? Like
in my
George said on
mind.
the video, she'd never been arrested before. Before that time, she was charged with that with George.
Like I'm sitting here going, mine's been like almost 20 years and it's just still like it was yesterday.
She lies. She's scared. She's scared. She doesn't know what to do. So she lies. She makes a decision to lie. Don't trust law enforcement. She doesn't know the law. She doesn't call a lawyer.
Same to you, because I'm telling you, this is like,
We talked to Officer Rodriguez was the first
and I just feel for Jorge because he's literally like telling the cops, like, would you call if you were me? If it were you, would you call?
there where she
Like,
doesn't tell the whole story. She lies. And then the detectives eventually get there and get her in the squad car. You hear the audio. I think it was played. She lies again. Then the next day, she goes down to the sheriff's department. Now, if they would have told her, hey, man, we're going to arrest you. And she gets a lawyer to go down there to make a statement. And the lawyer would advise her.
Objection.
they're not going to tell you we're going to arrest you.
Move to strike.
Stricken. The jury will pay no mention or give any weight to that statement.
She's not a lawyer. She didn't have a lawyer present when she made this statement.
No one does.
Know the law. She didn't know she was justified in defending herself the way she did in this dysfunctional, toxic, abusive relationship.
No, you know what's sad? Silencing Whispers is like as many times I've replayed my situation, I've literally like thought about like what is it? Like how long does it take for a black eye to develop? I can't remember. Like when does it get to that stage? So stupid. Like I'm like,
I don't know if you remember, it was a 2-hour video, but there were some things
oh geez.
she said, it was not intentional. And eventually, she wanted the detective, it was Detective Lowen, the male detective. And she said, I swear to you on my son's life, it was not intentional. What she was talking about was that.
I know, yeah, because it takes, it looks worse than like the next day, not immediately. I mean, immediately you'll get some swelling and stuff, but the next day is when you see like the real deal.
We've learned from their history, when Sarah gets drunk, she calls for help. When George gets drunk, he beats Sarah. That's their pattern. How many times do we see Sarah call the law? That's their pattern. Sarah told him, I didn't know, I think she said, I didn't know something like this could happen. I've never done it before. And Detective Lowen said, well, what did you expect that was going to happen?
It's because they sucked and they didn't get the confession. The law enforcement sucked. I'm gonna give you that one.
She got a grandmother's hand-me-down pickup truck. It was an older truck, but she didn't have it long, and she was gassing it up, but she didn't put any oil in it. Eventually, it burnt them up. And you don't know what you don't know. I hadn't done a good job of explaining, hey, you got to put oil in it too. Sarah Boone didn't know that he could die in there. It's an old beat up canvas suitcase that she left a gap in. And as naive as that sounds, she didn't appreciate the danger. I mean, is that the way you want to kill somebody? Is that the way you're going to do it? She had Lucas to take care of it. Am I going to go to prison doing it like this? No attempt to hide the crime. I think the evidence is clear. That's how this happened.
Now you're going with an accident? Which one is it? Hey, Brandy. Hold on. Now we're going back to the accident theory. Is it battered spouse syndrome? Was she in danger or was it an accident?
Sarah Boone got stabbed.
Did he stab her or did she stab herself? Now I'm even questioning the stab.
Stabbed with a steak knife in the leg. And she stayed with him.
I would have shaved my legs. This is how terrible I am. I would have shaved my legs before I went to the hospital.
Between the eyes, with a cookie rod.
I mean, that looks like a nick. I wouldn't even like.
Stalked in the eye.
I mean, I've been there.
What was that?
Been there. Been there. Oh gosh. What movie did I watch? Oh, The Favor.
The law empowers an
With Blake
individual to
Lively.
defend their life and safety when faced with a threat and to prevent an attack. That's what Sarah Boone did.
She did that to herself in that movie.
That's what Sarah Boone did.
If y'all never seen The Favor, that's a really good movie. Yeah, he never argued. He never fought it. He never said no. He just always said, just arrest me, just take me. It'll be my fault anyway.
I think it's important to understand Sarah had to be the parent a lot of times. It was her place. She had that $1,000 a month from the divorce settlement coming in. She had the car. She had the phone. She had the keys. She had to be the parent in a lot of ways.
Now, all those yellow notes are from Sarah. You see all those yellow sticky notes? Those are all Sarah.
I want to talk a little bit about Dr. Harper. If you remember, Dr. Harper is from Okaloosa County, which is up in the Panhandle, close to where we're from. And she's the doctor that treated Sarah from early on. Remember, this happened in 2020. I think she first saw Sarah Boone shortly thereafter. And over the 4.5 years, saw her 9 times and did all the testing for post-traumatic stress. Of course, she has the experience from the veterans, and she's testified that she's now just traveling around the state, testifying as a forensic psychologist. But she talked about how important it was to develop trust with the patient over a course of time. It's just going to take time when you have somebody suffering that kind of trauma and that kind of damaged psyche. It's going to take some time to get them where they can trust you and really tell you and talk to you and tell you what's going on with them. She talked about that Sarah uses her words for power. I think her testimony, I think the evidence supports that her testimony was credible.
Objection.
The evidence supports that her testimony was
Objection
credible.
is sustained.
I can't get it. The evidence supports that her testimony was credible because of the time that she spent, because of the number of tests that she did, that she diagnosed with post-traumatic stress disorder, alcohol use disorder, I think anxiety disorder, and battered spouse syndrome. Dr. Warner confirmed that. And, Dr. Michael Brannon, the first witness, he was brought in as a subject matter expert. So he hadn't treated Sarah. He was just testifying about the condition. He's been doing it a long time. He was an expert at it. And that's to advise you to try to understand what's going on. And as crazy as it sounds, in this syndrome, they try to protect the abuser. They're in love with them. They try to protect them. I don't know if you remember that there was a time where Sarah Boone had a conversation with one of the neighbors, and they were talking about something. She said, "Did you hear anything yet last night?" Remember, she said, "Shh, it's okay." Both George and Sarah lied to the police. They lied to medical people. I don't know if it's shame, but it just comes with the syndrome that you stay trapped in it. I think another big, if you'll think about this, when Sarah gets beaten by George, she calls the police. When Sarah gets beaten by George, she calls the police. And a lot of times she just wants him out. Just get him out. Get him to leave. She doesn't want him to get in trouble. She just wants him out. There never was a report of George calling the police on Sarah. She wasn't physically abusing him. The state is trying to present evidence. Did she emotionally abuse it?
Sustained. Stricken. Members of the jury will pay no attention to that comment. Give it no weight whatsoever.
I believe the evidence that's been presented by the state is an attempt to show that Sarah mentally or emotionally abused George Torres. Again, she's not charged with that. She's not perfect. Some of that was her trauma.
Well, what did he
In
say?
Sarah's situation, you do become numb and hardened, I think, over time. That's a coping mechanism. It's a day-to-day thing, some good days, some,
Did he say to strike?
But the homicide detectives, I know if you saw that 2-hour video, at some point during the 2-hour video, they started talking about some of the violence. And they go, we know. They had already checked with neighbors or whoever. They knew. The neighbors knew. Police officers knew who responded. Torres' family knew. They all knew about the abuse. Dr. Harper testified that abused women act differently when they perceive a threat.
Anyone
Sarah
abused
was
acts
loyal to her
differently.
fault to George, even through all the abuse. Judge, I want to make a comment about a couple of things that were said by the prosecutor in opening statement.
You may proceed.
Okay. The prosecutor in opening statement, when he was talking about George Torres passing away, and started talking about Sarah Boone, and his quote was, because I wrote it down, George, in Sarah Boone's mind, George Torres deserved it. George Torres deserved it. That's the position they're taking. He deserved to die.
Who said that?
She loved the man. She wasn't trying to kill him. He also commented about.
Yes.
Who said that? Who is saying that he deserved it? Who said that? I'm so confused. Why would he say that? How long is this going on? Oh, he's claiming the. Well, she kind of. I mean, when she said that she wanted him to suffer. I mean, and how he's flip flopping now. He's saying that she didn't mean for him. That it was basically. He said it was an accident. You can't. Excuse me. You can't flip flop from an accident to. She was afraid for her life. Now he's doing it. He's doing what she said. Oh, this makes zero sense. He's like, how was she supposed to know he was going to go away in the suitcase that she thought was breathable and partially unzipped? What the shnikes? That doesn't even make any sense. And then at the same time, though, she didn't want him to get out of the suitcase because she was afraid for her life. What did she think was going to happen? That he was just going to be in the suitcase all night and come out? I mean, what the? Even if he would have survived in the suitcase, did she think he was going to be less pissed off 12 hours later? Or what? I'm sorry. Not sorry. But if you're, if you have me trapped somewhere, oh, bless him. Is he wearing Jorge's t-shirt? He loved that t-shirt. I don't know why he liked that t-shirt so much, but he did. He liked that Ace t-shirt. But do you think your abuser is going to be less angry if you have them zipped up or confined in a small space by the time you let them out? That's not how it works. That is definitely not how it works. And if you think it is, you better move your butt to a whole nother planet. What the heck? Año. She's okay. Note to everyone, that's not how it works. You would never in a million years lock your abuser up and think you can go back to the abuser and they're not going to be extra super duper angry. And if they come out not super duper extra angry, you better run for the hills because they're faking. That means they're even more extra super duper duper angry. And you're dead meat. Just saying. And anyone who's been in that situation knows that. Oh my gosh. He cannot have it all the ways. What the heck?
The prosecutor said in opening about the violence, the violent episodes. It's a bunch of violent nonsense, was his statement to you in opening statement. All this here, photographs, is a bunch of violent nonsense. You'll have to make your mind up whether that's that. There were a couple of exhibits that I introduced late, and they were no contact provisions, where there had been a court order from a judge, not only a verbal order, but it was reduced to writing. So there was a court order for Jorge Torres not to have any contact with Sarah Boone. Okay. Court system got involved. They're to have no contact with Jorge Torres. Now, I need to talk a little bit about that. And they talked about coercion, coercive control, power and control, power and control. We know about his abuse. We know he destroyed the home, the TV. We know about his jealousy. some of the things he said to her. We know about how he treated her dogs nicely when he was sober, but at times abused the dogs or threatened to do so. If you think about power and control, when you're controlling a person, and I think she testified that he kind of smothered her, was always around her. Part of his fear was her realizing that she'd had enough and to leave him for good. That she would get the strength over time if she had enough time away from him where she wasn't in control of it and he wasn't in control of it. Enough time away, she would come to her senses and realize she could do better. Judge has been giving court orders all week. I didn't stop George Torres. George Torres knew he was going to lose control if she had a bunch of time away from him. She might move on. He was willing to violate a court order to maintain control. That's George Torres. I want to show a couple of videos. And I want to say something to you. Shelby Andrews is going to help me. If we could dim the light.
Yes.
She was texting other people to get him to contact her. He wasn't responding to her. She was doing everything she could to get him to contact her after the court orders. Thomas, are you okay, dude?
Do you understand? As of this moment, and until I can get you out, get the fuck out of here. You're a roommate. I dare you.
Did you see him?
Yep, look at him. Wait, get away from me. Get away from me. Get away from me. I'm gonna scream bloody murder. I'm gonna scream bloody murder.
Did you see him flip the switch? In that instance where he lost it, even though the video was going. Show the next one.
I don't know what that TV's connected to, but I can't believe it hasn't fallen off. She ain't saying a word.
Thank you. Thank you, Judge. You turn it off. Can you turn it off? Ladies and gentlemen, I'm going to finish up right here. And Sarah Boone, I've gotten to know.
Objection. Proper argument.
Sustained.
Sarah Boone is like any other citizen.
Yeah, that's a good point, Silencing Whispers.
Equal justice.
He could have been using that bat against Sarah.
To be treated like any other citizen.
It's a very good point.
Fairly and impartially. Based on the circumstances she was facing at the time of this tragedy. Based on the battered spouse instruction, which is a special instruction that's given when women have a heightened sense of fear and trauma, that you're utilized in applying her subjective standard to the reasonable standard of what a reasonable person would do under her circumstances, and using the force that she used to defend herself. I hope I hadn't missed anything.
No.
I tried my best. Sarah Boone fought back and survived. We ask that you do justice in this case and find her not guilty because the doubt is reasonable. I've tried to show you where the doubt was. I trust your judgment. We spent a long time picking the jury, 4 days. We trust you. We appreciate your service and your obligation to do your duty.
Yes, thank you for your service. Now
You have
let's
the
sit
power and
down.
authority to right this wrong. That's what we're asking you to do. And give Sarah Boone some hope for a better life.
Give Jorge Torres' family justice.
Thank you, sir. Any rebuttal? You may proceed.
Mr. J's about to hand you your butt. He's like, you want to take that? Get that thing out of my way. Get that thing out of my way, too. Get all this shenanigans out of my way. Let's go, Mr. J. Oh, here we go. Bring it on out. Let's go. Bam.
Ladies and gentlemen, Jorge Torres is dead because the defendant believed he deserved to be zipped shut in a suitcase so that she could make him feel how she felt when he cheated on her, when he choked her, and to hold him there as a captive audience, according to her testimony. Now he has to listen to me. Well, right out of the gate, there are credibility issues. Cheating to me means viewing pornography. Well, we saw cheating really means women. And the heated conversation on June 14th about these women in Facebook. And that is what leads to the arrest on June 15th. He's out whoring, Candy Crush, all the bizarre things that you see in her phone. She uses the legal system as a weapon at times. There's no denying that they are engaging in violent behavior. And it is over nonsense. It is smashing TVs. They call the police and then they're standing there looking bewildered about what to do and who to say and laughing and joking. Ladies and gentlemen, the courtroom is the place for justice, not a suitcase. The reason we have a jury system originally started with the idea that the king, the crown in England, shouldn't be able to go and incarcerate citizens on his whim. So it developed into a system where citizens would have to say, yes, you can take our fellow citizen. But the opposite is also true. A citizen cannot take another citizen's life because he or she feels like it. That likewise requires a jury to decide that it was objectively reasonable for a person of ordinary prudence and caution. Like Mr. Cacciatore argued earlier, battered spouse syndrome is not a license to kill. Past grievances, even being stabbed in the leg, so on and so forth, do not give her the license to kill. There are still laws in place about when and how this can be done in a justifiable manner. I want to talk about the most important jury instruction in this case that has not been discussed very well or thoroughly. Excuse me.
Gosh, I haven't seen one of those since I was in
However, the use of deadly force is
high
not
school, I think.
justified if you find that Sarah Boone used force to initially provoke the threatened use of force against herself. And we'll stop at that comment. The facts of the case that came from her own mouth, if she is to be believed, and we will explore thoroughly why you should disregard every bit of her testimony, from court to the detectives, to the 911 operator, to the doctors. Her testimony, if it is to be believed, the most favorable light that she has presented of herself, is that at the end of a Sunday fun day, where we are drinking, we're outside by the dartboard, we're doing puzzles, we're doing arts and crafts, and there finally comes a point in time where we're gonna play hide and seek.
Sunday fun day.
And he says, tag, you're it. Even though she's it, she goes upstairs, hides in the shower, eventually gets tired of being there, it's cold, so on and so forth, and she comes back downstairs. And as she comes back downstairs, she can see Mr. Torres fiddling to place himself inside the suitcase to try and hide for this game. And the lid is not closed, it's flapping. And out of jest, out of levity, undisputed according to her testimony, she comes over there and zips it shut. Whether it's 100% or enough for 2 fingers to get out, that is something that you decide as the jury. But there came a point in time.
Yep.
Where
It
the
was a
fun
manic
games
Monday.
was over. And Mr. Torres told her that. Babe, I can't breathe. Sarah, babe, let me out. This is all on video. We don't have to imagine this. This is all on video. 1062. At that point in time, she is using force against him that is not justified. She is the initial provocateur. She is the aggressor under the law. And what level of force is it? I can't breathe. Not let go of my hand, not get your hands off me. I can't breathe. This is no different than 2 people, maybe they're buddies at the bar, similar to an example that was given by Mr. Ohm, who are wrestling, and one has another one in a headlock. And there comes a point in time where the person on the receiving end of the headlock says, that's enough, I'm tapping. Jorge Torres was tapping, and she ignored it. And she was kind enough to tell you why. Out of anger, which translates to hatred, ill will, spite, just like that in jury instruction for second-degree murder. She told you exactly why. She got angry. Him saying, I can't breathe, babe, was what triggered her. Not a fear of imminent harm. Those are her own words. That is the law. These are the 2 paragraphs that solve this equation without getting up on a big whiteboard in college that's 30 feet long, 15 feet high, and a ladder, and somebody's scribbling Latin words and Greek letters for months and months to solve this huge, complicated equation. The equation is solved in 2 paragraphs. She is the initial aggressor. He is saying, I can't breathe. It is no different than a naked chokehold that she does not let go of. And she told you it's because I want him to listen to me. This is my bully pulpit. This is how he made me feel in the past. She doesn't describe it as teaching him a lesson, but that's exactly what she says. I want him to feel like I felt in the past. I want to tell him things. Ladies and gentlemen, we can play semantical games, but that is teaching him a lesson. Therefore, we have to look at the other 2 paragraphs. Because right now, plain as day, the use of deadly force is not justified if you find that Sarah Boone used force to initially provoke the threatened use of force against herself. And what force are we talking about? Well, the threat of force that she tells you she was facing was him fighting for survival, him sticking his fingers out of the suitcase, him sticking his hand out. That is the threat of force coupled with, I'm going to end you. Well, ladies and gentlemen, she is the initial provocateur. She is the one using deadly force against him. If I have somebody in a rear naked chokehold, they are entitled to use deadly force against me to break that chokehold, at least until we're separated. He had every right to say what he said. He had every right to exist and stick his hand out and try and survive to breathe another day. However, the use of force is not justified if you find that Sarah Boone used the force to initially provoke the threatened use of force against herself, unless she does one of two things. And she did neither. Not even close. The threat of force asserted towards the defendant was so great that she reasonably believed that she was in imminent danger of death or great bodily harm. All right, let's give her absolutely every benefit of the doubt, which you should. This is a criminal prosecution. The state of Florida has alleged she committed murder. You need to do everything you can to look for reasonable doubt. But a reasonable doubt is not an imaginary doubt, a forced doubt, speculative doubt. So accepting that all of their past history, accepting the doctor's testimony and the limitations on what they reviewed.
Yeah, you would think she would want to record that.
We did a much more thorough review of the relationship than any of the doctors did in this case. So let's give her that first clause. Because of their past relationship, with George now fighting for his right to exist and saying that he will end her if he gets out, we'll give her that. But just like Mr. Cacciatore mentioned earlier, lawyers' words mean things to us, and they mean things to everybody, but really to us. Or an and. There's an and. Had exhausted every reasonable means to escape the danger other than using deadly force on George Torres. She did not use every reasonable means to escape the danger that now, after provoking him, that he was presenting to her, according to her. She didn't pick up her cell phone and start walking, call 911. She didn't do anything other than, if you believe that is why she called Brian Boone, made a phone call to Brian Boone, and unfortunately, because of past history, he just ignored her drunken phone call. She did not exhaust every reasonable means to escape this danger that she created. She started it. She created this. Other than using the deadly force on George Torres. Now, this is a weird situation. This is not a rear naked chokehold. This is a suitcase. Or as Mr. Cacciatore said, a box, or actually more aptly described it as a coffin. And when you secure somebody into a box or a coffin, you can still exert that deadly force on them from a distance. I'll give you a quick example from a couple of movies that I love. In 1977 in May, a movie came out called Star Wars. They eventually called it Episode 4. In the first scene, there is this large, imposing figure that wears black armor. He is a government agent, and he is looking for some stolen classified documents. He picks a man up who he believes is responsible for this treachery and breaks his neck and chokes him to death when he doesn't tell him where the plans are. We all understand that. That is direct force we all understand. But what we need to understand is the force she's exerting from the couch. And then when she goes up to bed, she is still exerting that force on him. She set these implementations into motion and did not stop. So later in this movie that came out in 1977, another co-employee of this dark, imposing figure, Vader, insults his religion. He does not go to HR. He takes matters into his own hands and chokes this person from a distance. Ironically, while we're talking about force, it's the force. And then in the subsequent movie, he's like doing it from his office. He's killing his incompetent employees on different ships. Force, deadly force can be exerted from a distance in this situation. So whether she's on the couch or whether she turns in for bed, she is still using that deadly force on him. She has not exhausted every reasonable means to escape this danger. Do something. You started this. You put him in the position where he cannot breathe. She's required by the law to do something about it. Not something, everything. There was no efforts in this case. None. Or, in good faith, Sarah Boone withdrew from physical contact with Jorge Torres and clearly indicated to Jorge Torres that she wanted to withdraw and stop the use of deadly force. But Jorge Torres continued or resumed the threatened use of force. That did not happen. She never withdrew from physical contact. She is still, like Vader, choking him from the couch, choking him from bed. She never withdrew that force. Physical contact includes any restraint on Jorge Torres' movements. She never indicated that she wanted to withdraw. Sarah, babe, I can't breathe. All right, if I let you out, are you going to come out peacefully?
Hey, Kirsten, welcome back.
I'm the one that made you not be able to breathe. That didn't happen. So, ladies and gentlemen, this entire analysis about deadly force starts and ends there. She was the provocateur.
It was a train wreck.
These are her obligations when she starts it. She put him in fear of death. He is literally telling her, I cannot breathe. A couple other things about the law. Second-degree murder does not require a proof of intent to kill. Argument was made repeatedly that she didn't intend to kill him. That has never been the state's suggestion. Because why would we suggest we prove something that we don't have to? It's not her subjective belief. Well, Sarah Boone doesn't believe that this suitcase can kill him, even though he's repeatedly said, I can't breathe. It's a person of ordinary judgment who would know, is reasonably certain to kill or do serious bodily injury to another. A person of ordinary judgment who hears, I can't breathe, babe, Sarah, and his voice gets weaker 9 minutes later. You're on notice. This is statutory notice. Done from ill will, hatred, spite, or evil intent.
He was very discombobulated, totally thrown off.
This was not out of fear. This was out of hatred.
He didn't do a good job.
Anger. Born out of all those horrible things that has been done to her and done to him. Understand it. We're not going to belabor the past. Is of such nature that the act itself indicates a difference in human life. I don't care.
He wanted it to last longer than it did, but he was so thrown off.
Don't wear it out. Fuck you. It's second-degree murder. We do not have to prove the intent to kill. We have to. She intended the act. She intended the act of zipping him shut. She continued to intend that act when he said, I can't breathe. That act resulted in his death. That's a manslaughter, but then when you add in the hatred, ill will, spite, and the depraved mind, that's what makes it second-degree murder. And that 2-minute video is the textbook definition of depraved mind as we define it here in Florida. Voluntary intoxication is not a defense. You cannot feel sorry for her because they had 2 1.5-liter bottles of wine and then some from the leftovers from the day before. And quite frankly, she's blackout drunk. She's blackout drunk.
She's white girl wasted.
She doesn't remember making the videos. She turns her phone over right to the deputy the next day because she doesn't know what's on it. She doesn't remember doing it. Another thing that we just haven't talked about much.
That's true, Kirsten.
Her story. She can't be up in the shower hiding and taking a picture at 11:03 p.m., 9 minutes before the video. That portion of her story just doesn't add up. And what it shows is it's more like 20 minutes instead of 11 or 12 minutes that we know he's trapped in what turns out to be his coffin. Let's talk about her testimony at trial. And we'll talk about all the problems. A lot of her issues predated her relationship with Mr. Torres. So it's not attributable to the trauma from Mr. Torres with all the luggage she brought into the relationship. And listen to the way she talks. It's not splitting the bills. It's helping without argument. It's not cleaning up and doing Sunday chores. It's cleaning up so we can relax. It's a reward. She talks about him like he's a child. I need to lead him to the next activity from one to the other. And then you saw the videos, and I'm not going to belabor it, that we showed in rebuttal, but the relationship and the power dynamics speak for itself.
Speak it.
He was treated like the third dog. And it might very well have been a dog that bit and was violent, but he was treated like a dog.
Don't even
Why are you
compare it
leaning
to a
against
dog.
my
My
door?
dogs are treated way better.
Get out of here. Go downstairs. You're worthless. You're garbage.
My
They
dogs don't
showed
get talked to like
the part
that.
of the video where he slaps the phone, but that's after 5 or 6 minutes of being berated and dehumanized in a way that nobody should be treated. He just wanted to get in bed and lay down next to his fiance. Instead, get
That's
away
right,
from the side of
silencing
my door,
whispers.
you useless
Don't treat my dog like that. Stop comparing him to
I
a
thought it might be a
dog.
good point in time to listen to the music. You know, when does Mr. Torres get to decide what to do? I mean, she paints this picture that he goes off and does all these things on his own, goes and buys wine when he's not supposed to, does all these things when he's not supposed to, but when does he get to do what he wants? Suitcase downstairs for a week so they can donate it. What was in their lives that was preventing them from getting that suitcase to the Goodwill or whatever? Neither one of them worked.
Dude, do you know how much
What's going on?
crap sat in
Lucas
the
is
trunk of
over
my
there on
car
Mondays
that I
and
needed to
Tuesdays.
donate? That I said I'm going to donate it, and
The
it's
story
in the
about
trunk
the
of my
suitcase
car
having
for
already
like a
been down
year.
there is quite suspect, and we will get into that more. But
No.
again, it's not we went on a trip
Again,
together,
don't go
we had a great
there.
time. It's I quote unquote I recently took him on a trip.
If it made it to my car, it was lucky.
Then it comes down to the moment of truth, which we've already gone over. And it's just quite frankly inconsistent because she doesn't, there's no explanation for the picture. Her explanation at trial when I brought it up to her was, I just don't remember. I don't remember this period in time from the picture at 11:03 to when I was supposed to be coming down the stairs. There's a major glitch in her matrix.
Glitch in the matrix.
She
We're all in the
shakes
matrix.
the suitcase. Please stop doing this to me. And then his hand gets out. Now she's the point in time when she gets angry and doesn't do what the law requires after basically choking him with his coffin. Beats him into submission with the bat and turns it back over. For the first time ever at trial, she says, "I'm going to fucking end you," is what he said. She never told that to even her doctors. We've heard the arguments why she didn't tell the truth to the police and all that. And there's a lot of truth into the argument that was made. There's a lot of truth. When the argument is made that she didn't understand self-defense, what that means, what it comes across as, she makes this story change as she learns about it. When we apply the jury instructions to her statement, all 6 of them apply against her. Won't belabor this since it was discussed earlier, but did the witness have an opportunity to see and know the things about which the witness testified? Even at trial, she admitted that she was intoxicated for the first time. She went back and forth with the police about whether or not she was intoxicated and her standard of drunkenness and whatnot, but she was so intoxicated that she still felt the effects of it at 1 PM the following day.
She was drinking the following day.
The medical examiner told you that alcohol dissipates in the average person. Everybody's different, tolerance, all sorts of things come into play. But on average, 0.015 grams per deciliter will dissipate every hour. So you can do the math. 0.015 times 14 puts her at 2.5 times the legal limit. For those reasons alone, you should not believe anything she told you. You should not believe anything she told the police. You should not believe anything she told the doctors. She was at 2.5 times the legal limit. She has a gap in her memory that's unexplained when I brought up the photograph at 11:03. You can't have it both ways. I don't remember 11:03 to 11:12, but I was upstairs in the shower hiding. Does the witness seem to have an accurate memory? Well, this ties into what we're talking about. But again, there's a glitch in the matrix, 11:03 to 11:12. Her memory is not accurate. By her own admission, I don't remember. She tells the police when they show her the video, I don't remember that happening. Was the witness honest and straightforward in answering the attorney's questions? I submit when we got off script, and by we, I mean with both attorneys, she wasn't as honest and straightforward as when it was a very directed and smooth examination. I came out of the gate with something that was off script. Tell me about Pamela Erickson. Tell me about Christine. Tell me about Crystal. Because she's the one that said cheating to her meant pornography. Well, ladies and gentlemen, you know, she knew exactly who those people were and that she believed that he was cheating on them with her. And apparently she is too with some guy named Ben. That when I describe this as a violent, nonsensical relationship, that's exactly what it is. It's not to downplay the violence. She got stabbed. She had minor surgery. It got infected. Those injuries are real. But they just don't apply in this case. They just don't apply when you use that self-defense instruction when she's the aggressor, if it's to be believed.
Judge, I object.
Approach.
Well, he's going to say the battered spouse syndrome, they do apply. Or are you looking at all their options they got there, honey? Man, I hope. What time is it? Come on, Mr. J. Let's get this. Let's get this ended so we can let them take it back. Oh yeah, Silencing Whispers. If you've been watching it, then man, she was worse than Amber Heard. And yeah, she gets to laugh. She gets to move around and joke around with Blondie back there. Yeah, you know the funny thing about actors and actresses though is like when it comes to actually having to fake it, they're really bad. Like they can do it you can turn it on for a film or TV or whatever, but when it comes to like really acting in your own defense, it's really, really bad. It's amazing how all those skills just go out the window. If you've never been through it, I mean, like for your own personal self, like it's definitely different. Amber Heard could not do it.
May proceed. Objections overruled.
Let me say it loud and clear. Battered spouse syndrome does not have any effect on this case. It has no relationship to this case because she is the aggressor. She zipped him shut in the suitcase.
I hope so.
After
We have to.
he said
I have a hair
he
appointment on
agreed, she
Monday.
wouldn't let him out. Therefore, all of the instructions above that paragraph of however do not apply. They do not apply. Now, turning back to what I was saying, did the witness have some interest in how the case would be decided?
There's only
Well, of
6 of
course.
them. Remember, in Florida, there's only 6.
3 out of
jurors,
4 panels that y'all
not
came
12.
from
So
indicated
fingers
to the
crossed.
judge fear of
There's
punishment
less
was
people to
more important
convince.
than the fear of public speaking. It speaks for itself. She has an interest in the outcome of the case. Now let's talk about, does her testimony agree with the other evidence in the case? You do not have to accept this story.
Also, I think there's
Let's
only one
pretend,
charge
as you should,
for
because
her.
all
I don't
6
think they have a
of
whole
these
bunch
things
of charges
even
like the
got
Leilani case when there's like, what, 19 charges for Leilani?
Let's pretend
So
her testimony doesn't exist, and you just have to look at the circumstances.
I know. I put my hair appointment off this week already because freaking Sarah testified on Tuesday.
From the defendant is
Yeah, so
George
this is
Torres'
only, I think,
head
one charge. Oh,
here.
dang, Mr. J.
He's been sitting a long time too. His head is here. His butt is kind of down here. His feet are here. And his hands and his knees are up here. He's in the fetal position, if we remember right.
That's not possible.
The hematoma on his head is on the left side. The bruises, the deep bruises on his back.
No, that's not possible.
Or on his
Your butt
left
can't
side.
be the same place where your head is at.
That's, you hear that? That's solid. You don't have to accept that she put those marks on him when he was in there. The evidence doesn't support it. You can conclude she used this bat when he was outside the suitcase. You don't have to believe her when she said they were playing hide and seek. You don't have to believe her because she doesn't know the rules. She came downstairs, saw what she had done, and had all the opportunity in the world to clean up whatever mess may have been at the bottom of the stairs. But ladies and gentlemen, physics doesn't lie. She can't expect you to believe her testimony about the loud boom being the day before compared to her 2 neighbors who weren't drinking, who have no interest in the outcome of the case, who suffer from none of the infirmities of her testimony. She suffers from all 6 infirmities. When her neighbors say there was a loud boom that night, there was a loud boom that night. Did it shake the wall they shared in common? It shook the wall that they shared in common. Did she have any injuries consistent with being dragged up and down the stairs the night before? No.
I'm pretty
You saw
sure
the
your butt and
pictures
your
to
head
CSI.
can't be in the same.
You don't have to accept her story about hide and seek.
I don't think so.
Something
Not unless
made
your
that loud boom.
head's
It
between
takes
your legs.
energy to make a loud boom. Energy that could very well be in the form of somebody going down some of the stairs, all the stairs, in the suitcase, out of the suitcase. But that's what the evidence supports, is there was a loud boom that shook the walls and interrupted a FaceTime conversation that was so loud that the girlfriend on the other end heard it. Something loud happened. And then there was silence, according to the witnesses. And they can argue that Juan Torres' testimony was great for them. It's great for the state. She was screaming at him already at 7:30 p.m. She was already on her bully pulpit. And we know she doesn't need to put him into the coffin to get on her bully pulpit. There's video after video of her on her bully pulpit telling him how it's going to be, how you're going to live your life. Go take a walk. Do this.
Oh, yeah.
Do that.
I forgot about that one.
You don't have to accept anything she said. It's inconsistent that he received the hematoma to his head, his bloody mouth. How is his mouth getting bloodied inside the suitcase? That's protected from her and her bat. But that suitcase, a 100-pound drunk woman is not beating through the wood of that suitcase or whatever it is that's making that noise when it's thumped. Ladies and gentlemen, those injuries happened outside of the suitcase. Ladies and gentlemen, somebody or something went down those stairs. She has no injuries consistent with going down the stairs. He does. He has blunt force trauma all over him. You don't have to buy her story, and you shouldn't.
Oh.
The inconsistencies, I'm not going to belabor it. Your dinner is waiting him back. Let's just briefly talk about the experts, and we'll move on to the end. Dr. Brandon was absolutely fantastic. He explained everything
He
that
was.
you all needed to know about.
And he was a
battered
defense
spouse syndrome.
witness.
And this isn't about whether one of them or both of them had battered spouse, because at the end of the day, she's the initial aggressor, and she had the duty to do the things that the law requires. But it does call into question the credibility of the past power dynamics of their relationship.
List them.
Those videos speak for themselves. The officer in the last video asks him, dude, you're a guy. Why don't you do something about this woman, your wifey, who you don't want to rat on for beating you? He's like, man, I'm not a beefcake. I'm not going to rat her out. There's countless examples, if you apply Dr. Brandon's testimony to Juan Torres, that really shows you the power dynamics of the relationship. He was her violent pet. Dr. Harper, I don't find much quarrel with what she says about battered spouse syndrome, and nobody should. I mean, she's the expert. But she's not Ms. Boone's treating physician. She's not her treating psychologist. The way it was described in argument, and I believe from Dr. Brandon's testimony, was she's supposed to be a forensic detective. Get to the bottom of this. She's going to come in here at trial and tell you her opinion you should rely upon. With 9 visits, she never asked the defendant what it is the victim said that put you in imminent fear of death or great bodily harm. That's the crux of the matter, Doc. You're never going to ask her what it is he said or did for this grand jury instruction about threat of force or use of force? It's remarkable. And, you know, she didn't review everything that was presented to you. At the end of the day, it's your opinion that matters about this relationship. And again, we agree with Dr. Werner. It doesn't matter. She had the duty to retreat. She had the duty to take the chokehold off. And if it was too dangerous for her to directly take the chokehold off, she had the duty to do something else, everything in her power to stop him from dying, because she started it. She set it in motion. She used the force grip on him from a distance, the couch and from bed. It was her obligation to stop. She didn't. But Dr. Werner, she was called by the state of Florida after having evaluated and listened to the defendant give a similar story and concluded battered spouse doesn't apply. So she was never asked to delve any deeper into it. Given the information that she did have, the limited information, she agrees, yes, Ms. Boone has battered spouse syndrome, but it doesn't apply to the case because she was the aggressor and she did not fulfill her obligations. And really just your gut common sense. Go back to jury selection. In jury selection, there was examples about bullies day after day doing something to somebody. And somebody raised their hand and said, don't they have to do something that day? Don't they have to do something that day? And he didn't.
Yeah, that tie is very distracting, Gwen.
After he was put in fear of death and told her he can't breathe, the imminent threat of great bodily harm and death she is describing to you is him fighting for his life to escape. She did not fulfill her obligations. There's details that matter. And again, it's not to belabor it. I mean, the evidence in the body-worn camera and the 911 calls, it's not offered to prove the truth of the matter of as who stated what. Who knows what happened between these two? You see them with the police. Can't believe anything they're saying. It's not offered to prove that she's a bad person. It's not offered to prove that Mr. Torres is a bad person. It's simply offered to call in question the reliability and credibility of what she said about the past. That's all that it's there for. But there are some nuggets and some Easter eggs. There was an argument made during closings that Mr. Torres knows not to do anything when being videotaped. Bizarrely, shortly thereafter, they showed a very
Thanks,
edited
Gwen. Now
clip
I'm like,
of
oh,
him
great.
attacking her and slapping the phone out of her hand. He knows he was being videotaped, and there was another video like it too. So to make the argument that he doesn't do anything, he's a good boy when he's being videotaped, it's belied by their own argument. They showed one of the videos.
2 of them.
Learned helplessness. She seemed to control everything. I mean, his birth certificate, it gets torn up when he doesn't comply with her wishes.
Mm-hmm.
You'll see the rest of the text messages if you choose to delve into them. But I would suggest you don't have to, given the jury instruction about aggressor. Ladies and gentlemen, this has been a long 2 weeks, and you are making a very, very important decision for Ms. Boone, and a very, very important decision for Mr. Torres and the state of Florida and his family. He's dead. She killed him. She's admitting she killed him to have this affirmative defense if I was justified. It was not justified under our law. She does not get to decide that she has a license to kill because of her past grievances. The law requires her to stop using the force that she started applying to him. And she didn't. She didn't withdraw. She didn't tell him he was withdrawing. She didn't use every means available to try and stop this from happening. She didn't. And you know what was in her heart. She tells you it's hatred, ill will, spite, and venom. This is not a self-defense case under the law. Go back and follow the law. You cannot feel sorry for her. You cannot feel sorry for him. You cannot feel angry at her. You cannot feel angry at him. It's maddening to see their relationship. It is maddening. Nobody would want this life for yourselves or your children. It is violent nonsense, but it does not affect what she did and what her duties were under the law that night. She wanted to punish him. She did, and then she left him there. And she had an obligation, if you even believe her story about the imminent threat for him fighting for his life, she had an obligation to do something about it and not just go upstairs and let him suffocate. Thank you.
Go, Mr. J.
Thank you both. Members of the jury, I have some additional instructions to read to you. You would be so kind to turn to page 21 of 22. Instruction 3.12, verdict. You may find the defendant guilty as charged or guilty of such lesser included crime as the evidence may justify or not guilty. If you return a verdict of guilty, it should be for the highest offense on the verdict form that has been proven, beyond a reasonable doubt. If you find that no offense has been proven beyond a reasonable doubt, then, of course, your verdict must be not guilty. The verdict must be unanimous. That is, all of you must agree to the same verdict. Only one verdict may be returned
I
as to
know.
the crime charged.
We're
The verdict must be in
definitely
writing.
praying
And for your convenience, the
Jorge's
necessary
family.
verdict form has been prepared for you. It is as follows. If you're looking for it, you don't have it. I do. That's why we only have one. The verdict form reads, in the Circuit Court of the 9th Judicial Circuit in and for Orange County, Florida, case number 48-2020-CF-002603-0, State of Florida plaintiff versus Sarah Boone defendant. Verdict. We, the jury, find the defendant guilty of murder in the second degree as charged in the information. We, the jury, find the defendant guilty of the lesser included offense of manslaughter. We, the jury, find the defendant guilty of the lesser included offense of culpable negligence. We, the jury, find the defendant not guilty. So say we all, dated at Orlando, Orange County, Florida, on this blank day of blank, 2024, signed the foreperson. Final instruction, members of the jury, page 22. Instruction 3.13, submitting case to jury. In just a few moments, you will be taken to the jury room by the court deputy. The first thing you should do is choose a foreperson who will preside over your deliberations. The foreperson should see to it that your discussions are carried on in an organized way and that everyone has a fair chance to be heard. It is also the foreperson's job to sign and date the verdict form when all of you have agreed on a verdict, and to bring the verdict form back to the courtroom when you return. During deliberations, jurors must communicate about the case only with one another and only when all jurors are present in the jury room. If a juror goes to the restroom, the deliberations should stop until the juror returns. You are not to communicate with any person outside the jury about this case. Until you have reached a verdict, you must not talk about this case in person or through the telephone, writing, or electronic communication, such as an email or any other means. Do not contact anyone to assist you during deliberations. These communications rules apply until I discharge you at the end of the case. If you become aware of any violation of these instructions or any other instruction I have given in this case, you must tell me by giving a note to the court deputy. Many of you may have cell phones, tablets, laptops, or other electronic devices here in the courtroom. The rules do not allow you to bring your phones or any of those types of electronic devices into the jury room. Kindly leave those devices on your seats where they will be guarded by the court deputy while you deliberate. If you need to communicate with me, send a note through the court deputy. If you have voted, do not disclose the actual vote in the note. If you have a question, I will talk with the attorneys before I answer, so it may take some time. You may continue your deliberations while you wait for my answer. I will answer any questions, if I can, in writing or orally here in open court. During the trial, items were received into evidence as exhibits. You may examine whatever exhibits you think will help you in your deliberations. All exhibits, with the exception of Exhibit 10, which purports to be a wooden baseball bat, will be sent into the jury room with you when you begin to deliberate. If you wish to see Exhibit 10, which purports to be a wooden baseball bat, please request that in writing. In closing, let me remind you that it is important that you follow the law spelled out in these instructions in deciding your verdict.
They don't want anybody having that.
There are no other laws that apply in this case. Even if you do not like the laws that must be applied, you must use them.
I said guilty.
For more than 2 centuries, we have lived by the Constitution and the law. No juror has the right to violate the rules we all share. The parties approach.
Oh yeah, which jurors do you want gone? Because they have 8 alternates. 6 regular, 8 alternates. And silencing whispers, I don't know if you knew, but the judge does. I looked that up. So the judge.
Members of our jury, I want to take a moment and thank you for your time, your service, and your participation in this very important process. As I said to you last week, be it Monday or Tuesday, maybe even on Wednesday, without your sacrifice and your service, the wheels of justice would simply come to a screeching halt. And on behalf of myself, the state, the defense, and Ms. Boone, we thank you for that sacrifice. With that, jurors wearing badge 295, 9, 569, 515, 130, 249, and 448, and 110, who successfully served as our alternate jurors in this trial. I wish I could give you more than my thanks and a hot meal that's waiting for you, but I do thank you for your service and your sacrifice. Courtroom deputy is going to take you out at this time so you can collect your meal.
Take
and
you
I'll meet
out.
you back there momentarily to give you your jury certificates. Thank you for your service. The rest of y'all, if I didn't call your badge, you need to hang out.
I wonder who those were. What was number 13? I hope. I don't know. I'm
Thank you. All may be seated. For you 6, you are that will be deliberating in this case. I thank you again for your time and your service.
8
The
people?
exhibits will be brought back to you momentarily, and a meal is waiting for you. We will work till approximately 10 o'clock tonight if you do not render a verdict before then. And I thank you again for your time and your service. I'm going to ask the courtroom deputy to go ahead and take you back now to the deliberation room.
So they have 3 hours to come back with a verdict. We are officially on verdict watch. Okay, so how many of y'all
You can bring your
think
phone with you. There's a basket that the deputy will take and collect for you. Thank you.
Most juries do this. If you've been on a jury, I've not been on a jury, but I know that every time they talk to jurors after a case, they're always like, we went in and we took a vote first. Do y'all think that that's okay that they do a vote? I've heard yays and nays on that. Like some people are always like, I hate when they do a vote. I don't think that's proper.
Y'all can be seated. Thank you very much.
Did you intend for the jurors to take the notes into the deliberation rooms?
Yes.
Okay, I would object to that on the grounds that it allows one juror to potentially assert that their notes are better than others as opposed to just relying on.
See, here we go with
Any
the notes.
response, State?
That's not the law.
There's a verdict form that there's an instruction that I read specifically on that, sir, that no one juror's notes should trump another juror's notes or their memory. So your objections are overruled. Mr. J and or Mr. Cacciatore, do you have the clean laptop for the review by the defense? While we're putting that together, can both the state and the defense review all exhibits that were entered into evidence and confirm they are what they purport to be, so that all exhibits that were entered, with the exception of Exhibit 10, the bat, would be sent back to our jury?
But see, so there's a catch.
Yes, please.
The catch to that, Gwen, is if they do the vote when they first go back into the jury room, right? Like, I don't remember all the witnesses that were on the stand. I don't remember everything that they said.
I'm going to go speak to the alternates and I'll return momentarily. Thank you.
Like literally the last thing that I remember is pretty much the rebuttal from the prosecution side. That's pretty ingrained in my brain. So if you go back and you listen to you everybody vote, I mean, wouldn't everybody's first vote be guilty? Because if you had to, well, yeah, I'm sure they do, but like, they're not supposed to talk about it the entire time, right? During the trial, they're not supposed to communicate with each other at all. But you know, how hard is that? Like, how difficult would that be to not talk to each other the entire time? You're not allowed. What are you talking about? You're not going to be friends after this. You're not, I mean, we're not hanging out and having dinner later. Our kids aren't going to practice. Like, we're not going to freaking baseball games or anything together. I mean, what else are you going to talk about? That's what they did in the OJ case. They all voted like as soon as they got back there. That was a 9-month trial. And they went back there and voted, and it was 10-2 for acquittal. 10-2. And then OJ got off because they were ready to go home. And actually, they actually decided that day, the same day, but they just didn't come back with the verdict till the next day because Judge Ito didn't want it to look bad. So they decided to come back the next day. Which, I mean, I don't think it looked much better. So I'm surprised they're letting her just sit there, but all right, it is official. Verdict watch. Okay, so Leilani came back guilty on all 19 counts. We're waiting for justice for Jorge. I have updated y'all. Also, the Dodgers are playing the Yankees in game 1 of the World Series. My Dodgers got to win the World Series. And again, anybody who is not in the chat but is at least watching, don't forget it is early voting season. Please vote. We are in a crisis. This is very, very important. Sweet. Silencing Whispers voted already. Brandy's voting tomorrow. I'm voting on Monday when I go get my hair did. I was going to vote Tuesday when I got my hair did, but dang Sarah decided to testify. Whew, did y'all hear that? That was my... All right, that's all of Court TV's chat. So they're all in agreement. Justice for Jorge. Yeah, her testimony was really bad. It's actually kind of nice to see people on the side of a guy who's been... Oh, I've been good. Thank you. I'm supposed to have another procedure done from... That's why I can't sit. My back is killing me. But this sitting, I'm thinking about getting one of those walking treadmill desk thingies. But then that would mean I'd have to like move. Like Thank you. I'm glad to see you back. I was telling everybody, I was like, man, I had such a we had such a good core chat of folks, and then everybody just kind of fell off. Oh, what's he talking about right now? Oh, that's the jury instruction. The laptop for the evidence, just to make sure it's good. So the jury's back there wolfing down some food. Oh, he wants to make sure she's satisfied with her defense.
Previously this morning, you've been present throughout the entire trial, starting last week through today. You've been seated next to your lawyers at counsel's table.
What have you been doing, silencing whispers?
The opening statements,
what's been
direct
going on?
examination and cross-examination of all the state's witnesses, the direct examination and cross-examination of all the defense witnesses, and the opening or the closing statements as well that were presented by both sides. You've also had the opportunity to observe all of the exhibits that were presented as evidence in this case. Are you satisfied with your lawyers up and until this point?
Absolutely.
And are you in agreement with the strategy utilized in your
Holy
defense?
moly.
The last issue that I need to address is the state's request for in-camera hearing regarding
I
financial
know, Buzz.
arrangements
Did you hear
between
that?
defendant and defense
She
team.
said
State,
a
what
bunch of
is
stuff
your
to-
concern?
2
It's a very expensive
knee
defense,
replacements
which
at the
is
same
needed,
time?
and there are bar rules that limit the ways that things can be done. I don't know what's going on. It's none of my business unless it's raised in a 3850. So if there's an in-camera proceeding, I would ask to be sealed, and there won't be any need to get into it unless there's a 3850 claim that there's a conflict of interest.
Is there anything other than concern or speculation that you have?
Just things in passing that have been said and observed. It's a very expensive defense. That's my concern. I don't want her to be able to raise any arguments that, well, I would have pled if I had a conflict-free lawyer who did not want it to go to trial for his or her own reasons.
Okay.
Oh,
Mr. Owens, is there anything of concern that I need to be aware of in camera?
No, sir.
Mr. Henderson, same question to you, sir. Is there anything of concern that I need to be aware of in camera or otherwise?
No, sir.
Mr. Beck, same question for you. Is there anything of concern that I need to be aware of, be it here or in camera?
No, Your Honor.
Okay, all right.
Judge, and if you need to inquire from my client about whether or not she wanted to enter a plea or whether she wanted to go to trial, but, you know, we made it clear that it was her decision, not my decision to go to trial because I'm trying to gain some publicity or money or.
Oh, golly. I know someone who had two knees done at the same time.
Conversations we had about what was on the table. And Ms. Boone, as she has a right to, wanted to try.
Mr. Henderson and Mr. Beck, would you agree with Mr. Owens' recitation as to none of the financial issues being book deals or anything on the table at this point in time?
Judge, yes, because I definitely don't know about it.
Okay. Mr. Beck, anything to add, sir?
Only, Your Honor, that I believe this is attorney-client privilege information, but there are no concerns about it.
I colloquied Mr. Owens, your client, before we picked a jury as to the offer in this case and whether or not she was ready and wanted to proceed to trial. And she had affirmed at that point in time that's what she wanted to do. So I see no reason to inquire of that further. State, is there anything else we need to address? Defense, anything else?
Yes.
All right, please give your cell phone numbers to Madam Clerk. We will be on verdict watch. And I thank you all for your hard work in this case. We're off the record.
Off to jail you go, Sarah. Okay. Oh my gosh, Silencing Whispers. How are you walking around? Because they make you start walking around like as soon as you have that done. Dang, aren't we all a group of, we're just a motley crew in here. Yeah, they make you get up because I work with the old folks, so they get they have their knees replaced. They're like champs, man. They come right on back and they're walking around. I'm like, what the heck? Yeah. I went for a little nerve block and I was like, knock me out. I had an old man sitting next to me. He was like 80 something years old and he went in, no anesthetic. I was like, whatever, dude, I'm getting the anesthesia. Well, I don't know how those old people do it, but they go in there, they get those needles and they're good to go. They come walking right on out, just like whatever. I actually had the doctor was like, the nurse comes in, she's like, the doctor likes to do this without anesthesia. That's his preference. I'm like, well, he's not the one getting stuck with the giant needle. I am. So give me the anesthesia. Hi, Bubba's. Come here. But the old people I work with, man, they're like, that's no big deal. But I mean, I guess if you live with like arthritis and hip cracking and you fall, I mean, they just bounce back. I don't know. Everything. You got to draw blood, knock me out. God bless Silencing. I'm glad you're feeling better. I hope you're feeling better. Come back and see us. Boo boo. All right, we need justice today. All right, let's see what else is. I don't want to leave I think it's going to be quick, you guys. Oh man, I can't stand getting my blood drawn. Sorry. I just want to see the score. I don't see it. Oh, dang it. What the heck is that? Why did that just happen? Yeah, I can't stand shots, needles, anything. Boo boo, what are you doing? Are you trying to hold me up? What are you doing? Mike's going to get home and be like, you're still in here? I can't leave. We're on verdict watch. Oh my gosh. Well, dang, y'all. Trump's in Michigan. He's in Traverse City. Where is that? How far is that from you guys? Oh, did you tell me that, Brandy? Oh, 5 minutes away. Oh, hours from you? Yeah, she didn't leave smiling today, Kirsten. She did not leave smiling. So you said Leilani was crying? Oh. Oh, Trump is in Michigan. I was asking Kirsten and them how far away he was because they're in Michigan. Yes, I'm definitely we are praying for a verdict today. I'm afraid to leave the screen because they might ask a question. They might come back. I mean, hopefully when this election is over, we'll get more people in here. Right now, everything's taken up by the election. There's always something going on. I know my dogs are like staring at me like I owe them money. I haven't seen LaDonna in here. I haven't seen a bunch of people, but I know Trial Junkie said that she can't get in the chat for some reason, and she tried all that stuff you said, Gwen, and she still can't get in here. She even went on X and she tried to type into the chat and she couldn't get in. But she said that she wasn't the only one having issues getting into the chat. I don't know what the dealio is. Which one, Kirsten? Who is it, Kirsten? I don't know which one you're talking about, Kirsten. Oh yeah, we saw finally. Yeah, she got. I don't know what took so long, but I guess it was because it was 19 charges. China that they were out for what, a day? Not even. I guess it wasn't even a whole day technically if you think about yesterday and part of today. It just seems long because it was overnight. You were at the doctor's office. I thought you knew. We thought you knew. Y'all hear stuff before I do. Gwen was watching it. Sorry, we dropped the ball. I hadn't been watching that trial, but today, ow. Oh, she put the cable that she put in there. Also, I don't know what he was talking about earlier about the money. What was the prosecutor talking about paying the defense attorneys? Because he was talking about her plea deal and the trial. I don't know what that was about. Were they talking about they were worried that she didn't take the plea deal and instead she took the trial, that was gonna affect something somehow? Some way. God, y'all can see. Oh my God, I have dog hair all over me. I don't like this view. What did the prosecutor bring up about the plea deal and I can go back and watch it. We'll go back and look at it because I want to see. He said, I don't know why I'm sitting here asking questions.
To be, so that all exhibits that were entered, with the exception of Exhibit 10, the bat, would be sent back to our jury. Yes, please. I'm going to go speak to the alternates and I'll return momentarily. Thank you.
Okay, he was talking about money, so I wanted to. Well, we'll just watch it because I want to. So, are they working pro bono? Is that they're not getting paid? All right, well, we'll just rewatch it because I just want to see what they were talking about because I don't know if they're working pro bono or what. Dog, dang, man. You ever been stalked by your dog? Oh, she's never paying him back. She's going to prison. She's going to pay you back with peace and quiet. Yeah, from her commissary. Why is Owens doing all the work? Nope, nope.
Thank you. All right, we're back on the record, 2020 CF 2603, State of Florida versus Sarah Boone. State, appearances for the record. Defense.
James Owens for Miss Boone.
I have the parties had the opportunity to review and inspect all the evidence to be sent back with the jury.
The defense has as best as I could.
Okay.
Yeah, I didn't keep a tally, so I trust the clerks.
Madam Clerk is the best, so I have no doubts that everything is included. State, had the opportunity to review it?
Mr. Cacciatore was first.
Okay, all right. And with regard to the laptop, has it been inspected?
Yes, yes.
All right. Okay, so we'll send the exhibits back with the exception of Exhibit 10, the bat, and the clean laptop to our jury. Ms. Boone, I've got a couple of questions to go over with you again, ma'am, if I could. Ma'am, you were sworn previously this morning. You've been present throughout the entire trial, starting last week through today. You've been seated next to your lawyers at counsel's table. You've had the opportunity to observe the opening statements, the direct examination and cross-examination of all the state's witnesses, the direct examination and cross-examination of all the defense witnesses, and the opening or the closing statements as well that were presented by both sides. You've also had the opportunity to observe all of the exhibits that were presented as evidence in this case. Are you satisfied with your lawyers up and until this point?
Absolutely.
And are you in agreement with the strategy utilized in your defense?
Yes.
The last issue that I need to address is the state's request for in-camera hearing regarding financial arrangements between defendant and defense team. State, what is your concern?
It's a very expensive defense, and she's indigent, and there are bar rules that limit ways that things can be done. I don't know what's going on. It's none of my business unless it's raised in the 3850. So if there's an in-camera proceeding, I would ask to be sealed, and there won't be any need to get into it unless there's a 3850 claim that there's a conflict of interest.
Is there anything other than concern or speculation that you have?
Just things in passing that have been said and observed. It's a very expensive defense, was my concern. I don't want her to be able to raise any arguments that, well, I would have pled if I had a conflict-free lawyer who did not want it to go to trial for his or her own reasons.
Okay. Mr. Owens, is there anything of concern that I need to be aware of in camera?
No, sir.
Mr. Henderson, same question to you, sir. Is there anything of concern that I need to be aware of in camera or otherwise?
No, sir.
Mr. Beck, same question for you. Is there anything of concern that I need to be aware of, be it here or in camera?
No, Your Honor.
Okay, all right.
Judge, and if you need to inquire from my client about whether or not she wanted to enter a plea or whether she wanted to go to trial, but, you know, we made it clear that it was her decision, not my decision to go to trial because I'm trying to gain some publicity or money or book deal or whatever. But that was her decision. There was some strong conversations we had about what was on the table. And Ms. Boone, she has a right to, wanted to try.
Mr. Henderson and Mr. Beck, would you agree with Mr. Owens' recitation as to none of the financial issues being book deals or anything on the table at this point in time?
Judge? Yes, because I definitely don't know about it.
Mr. Beck, anything to add, sir?
Only, Your Honor, that I believe this is attorney-client privilege information, but there are no concerns about it.
I colloquied Mr. Owens, your client, before we picked a jury as to the offer in this case and whether or not she was ready and wanted to proceed to trial. And she had affirmed at that point in time that's what she wanted to do. So I see no reason to inquire of that further. State, is there anything else we need to address? Defense, anything else?
Yes.
All right, please give your cell phone numbers to Madam Clerk. We will be on verdict watch.
Okay. So they're saying, so the prosecution is concerned about the money. How is Sarah Boone going to pay for this defense team? One of those lawyers is from New Mexico. I don't know where those two chicks are from. I think they're from the same firm as Mr. Owens, but they've been traveling from that small town they came from in Florida, which is, let me look, it's near Pace, Florida. And they've been traveling. They came down from Pace, Florida to Orlando, up in that area anyway. Okay, I can't tell where Pace is at as opposed to, oh gosh, it's up in the Panhandle. So they're far. Florida is a big, weird state. It's like Texas. It takes forever to get through it. So that's a good piece. Yeah, for them to go from where they're at to Orlando. So if that one guy's from New Mexico, they've been staying there. Oh, y'all don't have toll roads? Oh my gosh. We don't have toll roads in Alabama. Dang it. No, I gotta get my prescription filled. I don't know what my dogs did. They've done something. Well, we have toll roads. We already paid to build the roads that we have, and then they put toll roads in, so we pay for those roads too. Again. So we double pay for the roads. That nobody seems to know how to drive on. Well, dang, somebody won money from Elon Musk. Is that legal? Oh my goodness. I mean, they are going to take him to court for that. No, you didn't win. I'm sorry, Brandy. I'm sorry to tell you, you didn't win. Some guy in Holland man wins. I don't know where Holland is. Ooh, that is dangerous. He signed a petition. Oh, wow. I don't think that's... I don't know if that's legal. I mean, he's a private entity, so he doesn't work for any campaign necessarily. He's not bound by any party or campaign, what you call it? You know what I'm trying to say. Dang it. So I don't know. I don't know. I guess they're trying to find a way that it's probably not. I don't know. I don't know what the rules are. Yeah, I don't, as long as it's not a, he's not a, and he's technically not, I would think so. And he's not a, I don't know. Well, he's giving away money. I know he's matching dollar for dollar every donation that you gave to Trump. I don't know if that part was legal, but as far as him giving away money, he can do what he wants with his own money, as far as that's concerned. And I guess the donating part, I don't really know what the rules are. I just know that they have to report whatever they donate. And you can only accept so much from the same person, which is why he's allowed to donate. Yeah, he's allowed to donate through each entity that he has. He can donate up to, I think it's 500,000 is the cutoff. So I think, no, it can't be just 500,000 because, I mean, also Kamala Harris has raised like millions from several different, she's outraised money from Trump, like by a ton. I have to look up how much money she's raised compared to Trump. She's raised way more money than Trump. Yeah, voting, bribing, same difference. I mean, I call it money laundering. You can call it donating, whatever you want to call it. I mean, which, speaking of the Samantha Wall, I finally, once Michael is free, the ball will be rolling to clear his name. So just can't make any moves until he's free, unfortunately. So have to keep everything just supporting him and keeping him in our prayers and keeping Samantha's family in our prayers and hope that they will eventually, want justice, the real justice that there is, for her sake. But that's why the election is so super important. And I've said that like so many times, like there's so many things. It's so important. It's not just for, I mean, there's so many things that it's important for. Yeah. It's not just important for America, but it's like individually, like for me, it's important for what I'm working on, helping people like Michael, looking at things like South Korea, what's happening there, them stepping into Ukraine. It's very disturbing. Okay, Gwen, I thought you said that this woman was in the woman that got the 10-year-old through the robo blocks. I started watching that. Did you say she was in prison when she did that? But the title says Florida mom. Like she was just a mom that just like. I know. Oh, she'd been arrested. Okay. I know, Kirsten. It hasn't even been an hour yet. Well, there's a lot of people watching. There's a lot of verdict watches going on. We're all eagerly waiting. So it's only been 37 minutes. It feels like it's been forever. So you want to come on camera, China? With your, do you feel, if you've been punched, you've... You're in your PJs? Oh, Gmail. Check your email, China. No, I use StreamYard. Okay, we're waiting on China to join. Oh. Okay, so where's Kirsten? I know she doesn't like Owen, but if she didn't see the closings. Yeah, I saw that. I just saw it. Did you check your email? Oh, I can't believe she's still trying to get that. It just makes no sense that she's still going for that. And you know, the Baldwin brothers, let me just tell you, they're so close, but couldn't be more different. Like, it is insanity. What do we got here?
Hello.
Hey, hey. What's up? What's up? Oh, wait. How do I make this work? How do I add you to the screen? Oh, my word.
It says everyone can see and hear you.
I can see you. I can hear you. Oh, my gosh. Well, I can see you. I can hear you. Why can't I see you?
Can you see my avatar?
I see your little avatar.
That's
Yes.
all you go see, girl. That's all
Why
you go
not?
see.
Yeah, you're not trying to let me see you?
No, girl, my face is swollen. No.
Oh, yeah, you feel like you've been punched in the face.
Yeah, I feel like I've been punched in the face.
Yeah, China's got a sinus infection. Bless her heart. So, you saw the Menendez brothers thing.
Yes, I dropped a video on them last night. That announcement came right in the middle of me doing my video.
Oh, what the heck? Oh, I don't know what just happened there. Let's not do that. So you think they're gonna get out?
I hope so.
You hope so? Really?
Yeah, I hope so. But I just feel like considering what they've been through, what they went through, I feel like, yeah, I feel like they should be free. I feel like they've served their time for the crime that they committed.
Do you think they really went through all that?
Oh yeah.
Oh.
Oh yeah.
Interesting.
Yeah. If you ever watch like the trials, there is no way that if you watch them on the stand telling, about the abuse, they couldn't have, those tears and the way they acted was not fake.
I went back through. I watched some of it, some of the trials again, because I remember all of it when I was a kid. Because I'm the same age as Eric, I think. Was he 50?
Eric is 51.
Yeah, we're about the same because we went to the same school, but but I kind of feel like Eric more than Lyle, which is weird. I can definitely sense something from him, but I don't know about Lyle. Lyle is kind of weird.
Lyle to me is a lot like his dad when it comes to his mannerism and stuff. It's just the way he was taught. You know what I mean?
Oh, there you are. Yeah.
I'm sorry. I just
Yeah,
feel
I
like
don't.
they need
Yeah,
to
that's
be.
why I don't know if I believe Lyle, but I think it's just probably because he's just kind of locked in, like he's just kind of a shell, like he's more just the way he acts. So I think
Let
because
my
he's not as
brothers go.
like his dad, what you call it, just was so rough around the edges, I guess. But I watched that thing on Netflix. Did you watch that?
Yeah.
Are you there?
I don't know.
Oh.
I don't know. Dad was, I mean,
I think that was much more embellished.
I know they wasn't happy with it. They wasn't happy with the Netflix.
I don't know
the
if their dad
monster.
was that. I don't know.
Yeah, he was a bitch. I mean,
Who
you on
says they hate their
YouTube.
children?
Well, I think he kind of looked down on them too because they wasn't successful like he wanted
Like,
them
do you
to
think
be.
Kitty was that mean?
Yeah, Kitty hated them. Maybe not as they, but as they got older and stuff, and she found out exactly what was going on, she hated them because they was even getting more attention from him than her. She resented that.
Yeah, you just never know what's going on behind closed doors. It's so weird. You just never ever know. Maybe I can't share this and what is the deal? I'm having issues. I can't put you on the screen, China. It's really irritating me right now.
Oh, it looks like y'all. Hey, Kirsten. No, I feel that way too. I feel like they need to be set free. I mean, and it'd be something different too. I mean, since they've been in there, they have been extremely well behaved. They've accomplished so much. They've helped so many people while they've been in there. I just feel like that they would be good. I mean, they wouldn't be it wouldn't be like a mistake to release them. I feel like they served the time. I don't agree with them murdering their parents,
Yeah.
Don't get me wrong. I don't agree with that at all. But, people react to things differently. And people, I guess they felt like that was their only way out.
Yeah.
I mean, it's sad that they had to take it that far, But, yeah, it was crazy. Man, I
Well,
remember that like it happened yesterday.
I felt like I did too until I started watching all the stuff over again. And then I was like, man, I don't remember it like I thought I did. But,
Yeah, I mean, I remember like I didn't really watch the trial and stuff, back then, but since it's all done came back up, I have really got into it. And yeah, I solely believe, even like the guy that came forward and admitted that their father had molested him, that was in the band.
Oh yeah, Menudo. Oh my gosh, I used to love Menudo.
And then the letter, that they found that he had wrote his cousin. And the cousin's mom found it after the cousin died.
Oh, the cousin is gone?
Yeah, he died.
Oh.
The cousin died. See, that's how it came about, because the cousin had it put away.
Oh, I didn't know he was gone. I didn't know that.
Yeah, I think it was 2000 and it's either 2003 and 2000 or 2013. Their cousin Andy that he sent that letter to died.
Oh. Oh, dang. Well, you feel the same way about the minute. I mean, I don't really. It doesn't bother me either way if they're in or out. So I don't care. I mean, but
Of course, we don't want them to come out and be,
I don't think they would be. I don't want them to be like another Gypsy Rose. Oh my gosh, that girl. I think she should still be in prison.
Yeah, I think they would kind of be a little bit on the down low.
I would hope they would be, because that girl, something is definitely wrong with her. And I know it's partially because of what she's been through, but also I think that I don't know. I think she probably should have gone through some type of therapy and not just prison, but she clearly did not learn anything, and she hasn't done anything good with herself since she's been out. Like, she hasn't done anything to help anyone else.
Yeah, Gypsy used that guy to get free.
Right. And then she went on to move on to the next.
Mm-hmm.
Yeah. And then she's not done anything to help others, because I even reached out to her knowing that hoping that she would probably maybe help with Michael's case. And she's never responded. And she has not helped anyone else who's ever reached out to her either. She's not done anything good for anyone.
That's because she's about herself.
Yeah, she's all about herself. So
is she really pregnant though?
I don't know. Toddy One Skip harasses the ever living mess out of Gypsy Rose. So I don't know. I don't know if she is or not. I haven't seen. She's been posting. I stopped looking at Gypsy Rose because I don't want to give her the time of day, but she keeps saying she's not really pregnant. So I honestly don't know. But who else is out there that is? I'd like to see Betty get released because she's no longer a threat.
Betty's a crazy something.
Well, I
know that's your girl.
She is.
She wasn't nothing to mess with, boy. She was really scorned. That was a really scorned woman.
She is. And but
have you really talked to her like face to face?
No, not face to face. We used to write each other. Yeah.
Oh, okay. Yeah. But she's in there until she died, right?
Betty? No, she's still in there.
But she got life though, is what I probably.
Oh, she got 30 to life. So, but she's been denied parole every time that she's been up for it. She's been denied because she shows no remorse. She's not sorry. We've written each other and she's not sorry. She completely believes that, Toddy is obsessed with Gypsy Rose, Kirsten. Betty is not sorry. And she truly believes that Dan still has connections. That's why she's not been paroled. She thinks that there's some sort of mafia type of thing going on there, that he has still power and control over, that his family still has control. And she is very, very bitter. I have letters from her. She is very bitter. She hates Dan.
I first learned about Betty on Lifetime. And then after I watched it, I went to actually looked up her and looked into her case. But there's another one that Denise Williams, where she tricked the guy she was messing with, to kill her husband.
I don't remember that one. When was that one? Was that? Oh.
Is that her name?
Denise Williams, sentenced to life for her husband, Jerry Michael Williams.
Yeah. Yeah, I want to look into that one because I watched it on Lifetime too, I think.
Oh. This one's in Florida?
Uh-huh.
Oh, yeah. Oh, man, girl, this is the one. They were married.
Yeah.
Yeah. This is the one where he took her. They were best friends.
Yep.
Yeah. I know this one. They were best friends. Then she started having an affair with her husband's best friend. And then
he took him out on the boat.
Yeah, took him out on the boat like they were fishing or something. And then the waiters is what caught him. Because he ended up taking him out with the fishing pole out there on the boat. And they got away with it for years. They ended up marrying each
long
other.
years. And I think his conscience got a hold of him.
It did, because they ended up splitting up. That's what happened. They ended up splitting up. And it turned out, obviously, it didn't turn out well. So they ended up going against each other. And he couldn't take it anymore. So yeah, but that was a affair gone wrong.
I think how I come across that case again is, I want to say it was the Wade Wilson. I think Wade Wilson tried to get, Wade Wilson, during all that was going on, he tried to get, Wade Wilson offered to do it for them. That's how I came across that again.
Do what for them?
He offered to kill the husband for them.
When? That was years ago.
This was before Wade even got arrested, because when Wade got arrested, this guy testified that, Wade, tried to even get him to commit the crime for them. Like, he wanted to do it for them.
Oh my gosh.
Have you watched my Wade Wilson? When you get a chance, watch my Wade Wilson story. It's in there.
I hadn't watched Wade Wilson. I hadn't watched anything on him since he was sentenced, because I was like trying not to give him any more.
Yeah, he getting on my nerves. Because
Yeah.
there's a guy that still keeps playing his phone calls from prison.
Yes.
And I'm like, let it go.
Yes. Like, my whole YouTube feed was nothing but his phone call. I was like, dude, stop. I can't look at his face anymore. Stop it already. So I just stopped. I just was like, I had to get, I don't know why he kept popping up on my YouTube feed. I guess because we did watch his trial, but I was like, dude, this got to stop. So no, I haven't watched anything on Wade Wilson in a hot minute, but I'll check that video out. But yeah, where do you go for all your research and stuff?
Oh, I just dig everywhere, girl. I'm telling you, I be digging. I get so much emails and stuff where I get stuff and research stuff from, and I just dig. I'm a Googling person.
That's where I got all the information for the synagogue and stuff. I just went online. I mean, I got information that the attorneys didn't even have.
Yep. Now I don't, I like how some of these people are able to get like body cam footage and stuff. Now I haven't figured out how to do that yet.
Oh, that's just a FOIA. You have to file a FOIA request for that kind of stuff, and you have to pay for that information. It's a Freedom of Information Act, but yeah, she is. But like, I requested a FOIA from Wayne County, but they will charge you whatever it is, but you write them, you go to their website, and you just request what you need. I have a letter, a template, and you can just request what you need, and they'll tell you how much it'll cost and how long. They have to reply to you within 5 days of how long it'll take them to get it to you and how much it'll cost, and if they'll even give it to you. But some of these YouTubers get it like super fast. I'm like, how the heck did you get it so fast? But usually it's public knowledge, public information. But some of these YouTubers get it really, really fast. So
it'd be like the day of, it seemed like it.
So sometimes I just I'll just let another YouTuber get it because they get it and I don't have to pay for it. And then you can just scrub out their you can reuse the content. Just let someone else do the work, and you just get it.
Yeah, I'm sure that's what a lot of people do.
Oh yeah, it's because it's okay to reuse content. You just have to take off you have to make it your own. So it's okay to do that stuff as long as you make it your own and take off their logos or whatever. That's why a lot of YouTubers now have figured out how to embed their logo into their that stuff so that you can't take it and use it. But if you're an amateur like I am, then you don't know how to do that yet. So, but some people like Rottweiler Investigations, like they have theirs embedded in there. And then Circus Crimes, like his pops up every now and then throughout his videos, so you can't really like take his content and use it.
Yeah, or they'll put it like in the middle so you can't hide it or
Oh,
whatever.
watermark. Yeah, Brandy, that's it. That's what it's called. Yeah.
Watermark,
so you can't, yeah. So you can't, and I have gone through the trouble of removing watermarks out of people's content so that I can use an entire video. Like Jen Soto's interview. But you have to pay for that software to remove watermarks, remove all that kind of shenanigans. It's kind of a pain. So you got to really want it.
Well, I guess it just depends. You know, some people, that's their kind of like their livelihood is their YouTube, you know.
It is, yeah. So if you take something, but some people like you can put on your YouTube channel if you want it to be reused or not, because you can make money off of it too if they reuse your content. So it just depends, but I usually just like to if I can get something good, I can use it, but like Wayne County won't give me anything. But I've never really done, that's the only time I've ever done a FOIA request is for Michael's case. I've never done a FOIA request for anything else. I've just gotten content off of like Court TV or something like that. Because I'm not made of money. I can't afford to pay for stuff from people to put on my channel. I'm not there yet. Like some of these other YouTubers are.
Yeah, big.
Yeah. They're making money. I am not. So if
They gotta have a lot of time, because just a little time I have to do what I do. I and it takes time. I couldn't imagine, you know, they pop videos every day, all day.
Every day.
I just don't know how they do it. Sometimes 2 and 3 a day. I don't know how they do it.
Yeah, they're doing lives and they're making videos. And I'm like, do you know how long it takes to edit a video?
Yeah, it takes me a minute.
I mean, it's forever to edit a video. So that's why I like StreamYard, because I can do my reaction videos, which I like doing those because it's easy, simple. There's hardly any. Yeah, they do have help, Brandy. The bigger YouTube channels have teams of people. And I have zero patience for editing. But I use Canva and I use
Wondershare.
I had Wondershare. I was going to ask you what it is you use.
I use Canva for some stuff. I've never really done no editing in it. But I have used it for some stuff. But
Clipchamp. I use Clipchamp.
That's good too. I haven't used it. My daughter uses that. She does a lot of videos, how-to videos and stuff.
Yeah.
You know, like makeup videos and stuff that you know what I'm talking about. Teens got time for, young adults got time for.
Oh yeah.
And,
Get ready with me. Get ready with me.
Yeah, like something like that. And she uses that, and it's really it has a lot of features.
Yeah, I
just never played with it myself.
I did use Wondershare for a while, but I'm not technical.
Give yourself some credit, girl.
No, I see your videos. I'm like, how the hell did she do that? What is she doing? Okay, never mind. Just forget it. I just watch her videos. Nope.
Well, you know, Susan Smith is coming up for parole next month, so we got to get on that soon.
Yes. Oh my gosh. Yes. Did you see her husband's interview? Or ex-husband, sorry. Yes, they interviewed him. Bless his heart. She actually reached out to him for help to get paroled. And he
lying.
Yeah, and he Susan Smith, Brandy. Do you remember her? Are you old enough to remember Susan Smith? I remember that case. Now that case I remember very, very well.
I think it was in 95, 94.
She was in 91. 90. Susan Smith, she's been in prison for 30 years now.
Was it that early?
Yeah, because
no, girl, July 10th, 1995.
Was it 95? Who am I thinking was in 91? I'm thinking the Menendez brothers.
No, they was in 89. Let me make sure I'm looking at this right.
She was in 94.
94.
Yeah. So, yeah.
Her and David got married in 91.
91. Yeah, that's when they got married. Okay, so she, you were 10. Brandy was 10. Thanks, Brandy.
I was 2 years out of what 90. What year was it?
I was 2 years out of high school.
I was 1 year out.
I graduated in 92. Dang it, Neo.
Somebody just turned themselves in for killing Tupac. Y'all seen that not too long ago?
Yeah, that was one of the rappers, some kind of rapper or some kind of gang member or something in California. Right?
Should.
Yeah.
Should something.
You know Diddy had something to do with that.
Oh yeah.
But no, she reached out to her ex-husband to help her get out for parole. And he went on TV because he's going to go before the parole board and try to keep her in. Did Suge Knight actually say he did it finally? Because he's been in prison a long time.
Suge Knight did it first. I think they arrested him for it, but somebody just recently, it was somebody else that they got just arrested for it. Let me look it up.
Because I thought some random gangbanger did it. That because he was a part of the group they got into a fight with Tupac in the casino.
It's Dwayne Keith Davis.
Yeah, that guy.
They called him Keith D. But you know, it's funny, since he got arrested, all this stuff is coming out with Puff
Daddy, P. Diddy.
I call him Puff Daddy, and my kids make fun of me. But that's what I know him. But they's like, Mom, his name is P. Diddy. I'm like, it's Puff Daddy.
It was Puff Daddy when we were younger. First of all, why does everybody change their name? Why did he change it to P. Diddy? What's the difference between Puff Daddy and P. Diddy? Why does he want to be Puff Daddy?
Girl, your guess is about as good as mine. I'm not a fan of his type of music, so.
I mean, he wasn't even cool. I never really liked his stuff. I mean, when he did the remake of Every Breath You Take, that was kind of cool, but I mean, other than that, I never really listened to his stuff. I don't even know what all he was involved in, actually. Never paid much attention to him. I like Tupac now. Don't mess with my Tupac. That's my...
Yeah, Tupac ain't dead.
I did like Tupac, but I can't say that I knew enough about Tupac to be like, ooh, I know that song. I know Californication.
That used to be the song right there.
I know, right? I know that one. Okay, there we go. There's not Tupac. Oh, Gwen's like the diddler. The P diddler.
Yeah, it used to be Sean Combs too.
Yeah.
Puff Daddy Sean Combs, I think is what they used to call him.
Yeah, he had that was his brand, right? Sean Combs.
His
Or what?
clothing brand.
Yeah. Wasn't that his clothing brand? Now he's the Cali knows how to party. I don't know, man. I'm from the South, the ATL. You can't mess with the ATL. That's what all got this mess started, okay? The West Side and then the South Side. I mean, was it the South
That's
Side
where
or
the
the East?
problems come in when you start dividing people.
See? That's what messed it all up.
Yep.
In the first place. Had to throw hands and stuff. That's what messed it up.
If they let her out, they gotta let the boys out.
Man. Dougie Collado. Dougie Collado? Who's Dougie Collado?
Dougie. Oh, he is somebody. Let's see.
Dougie,
Oh, he has a YouTube channel.
Dougie Collado.
He has a YouTube channel.
Dougie G's Lounge. Is that it? No. Okay, I'm not spelling it right. Dougie
They went to a cult party. Is that the one you're talking about? Where you went to the cult party?
It's
Gwen?
called In-Wish. Hi, Silencing Whispers. Welcome back. Oh, did you see someone said a verdict was in? I'm watching. I got it on here. Nuh-uh. Already? We're going to have a verdict? Sweet.
Refresh, girl.
Oh, verdict. Dang. Yes.
What's the verdict? I don't see it. I'm nervous.
Oh my gosh. Yes. Verdict. Here we go, y'all. Justice for Jorge. Oh, this is quick. Oh, dang.
He wasn't playing about that 9 o'clock, was he?
Ooh. This is good. This is good, y'all. This is good. Ow. Shoot.
So, Tracy, my husband comes back in town on Monday. You want to get together before then or after?
It'll probably be after, 'cause I work on the weekends is the only time I work. But we could talk. It would be late though, after my old people go to sleep on the weekends.
Your old people.
Yeah, my old people.
Hey, my daughter works at a nursing home, and I told her, she comes in there every day telling me stuff. It'd be having me in tears talking. I'd be like, you better leave them people alone. And then I watched this movie called Old People. Have you watched it?
Yes.
It is hilarious.
Yep. Yes, Kirsten, there's a verdict. Yes, them old people are crazy, man. They're funny as hell. And I got one of my boyfriend works with somebody, his girlfriend, this guy he works with, his girlfriend works at an old people place, and she's got stories. Oh my gosh. Her stories are nutty. Those old people are, you talk about ditty parties. Y'all. Nuh-uh. Diddy
They
ain't got
need to get
nothing on
somewhere and
these.
sit down.
Y'all, Diddy ain't got nothing on these old folks. At least
I
I
guess
don't
they
have to
say
deal with that.
they ain't dead. I guess they say, well, I ain't dead.
That's right. That's right. Yes, it's a good sign, Kirsten, that it's fast. Well, I say that, but you know what? OJ's was fast too, and they came back acquitted. So I don't know. Let's not.
There was a video that came out where his daughter said he did it.
You know he did it.
I knew he was guilty from the beginning. I was like, that man guilty as sin. I remember when that happened too. I'm like, OJ just as guilty as he want to be riding around in that Bronco. I remember that just like it was yesterday.
Yep. Silencing Whispers, you ain't that old. You got 2 brand new knees and no gallbladder. You're doing great. And those old people are hoots. You know that. You used to work with them.
That's the same thing happened with my mom. Silencing Whisper. She worked at a nursing home for years, and it just, she got older. It just broke her down too.
Yep. I don't work at a nursing home. I work at independent living, but I think my boyfriend's friend, coworker, his girlfriend works, I think, at a nursing home. So those they get crazy.
Oh yeah, the stuff my daughter tell me has me in tears, boy.
I'm glad I don't like work in that kind of place, because I couldn't imagine the stuff I would see. There's no way. I see enough stuff as it is. So yeah. I had one of the guys that he works in our dining area. He's one of our cooks. And he was like, oh, I'm going to go be a caregiver at assisted living. And I was like, you don't want to be a caregiver? He goes, why not? And I go, because you don't want to wipe butts. And I go, how much are you going to make doing that? He was like, $2 less an hour. I go, you're going to go up the hill. We call it up the hill. You're going to go up the hill and wipe old people's butts for $2 less an hour than you are going to cook in the kitchen. No, you ain't going to do that. He went and did it for like a trial for like 2 days. He could not wait to get back in the kitchen. I said, I told you. I told you. I was like, you do not want to do that for a living. That is the last thing you want to. He's like, how did you know? I was like, because you're lazy. Number one, you're lazy. Number two, you're like 20 years old. That is not what you want to do with your life.
And it's not for everybody.
No, God, no. I mean, no. Who wants to do that? You have to really, really want it. Okay. You got to really want it. You got to really care. It takes special people to do that job.
Yeah. And then, like with her, she done got attached to patients and they done died on her. And, So,
girl,
yeah,
I know.
It's not for everybody.
No, every weekend I go to work, I have to find out somebody and I used to work there full time. And that's why I left, because I quit actually, because people they were dying left and right. I think I lost 5 people in 1 week and I couldn't handle it anymore. And I couldn't handle it. So I quit. And then they were like, can you just fill in? Can you just come in and work, when we need somebody to fill in? And then I just started working all the time. And then they were like, well, how about if you just worked on the weekends? So now I just work weekends. So now there's so many people that have moved in, and I've also lost so many people that I don't know the majority of the people that live there anymore. And I'm totally fine with that. But I do have like a handful that I'm very, very attached to. And I just lost one of my favorite people. And then I have one in the hospital right now. So it's very hard. I can't. It's very, very hard.
Lord forgive me. She said when she walked in the room, because when a patient dies, they have to bathe them and stuff.
Aww.
And she said, my daughter's just 20. So, she said she walked in the room. She said, Mom, they was putting towels over the mirrors and opening up the windows. I was like, why? She said, because the spirits.
Oh.
I was like, they need to be worried about what's walking around.
Oh my goodness.
Yeah, she said that that's what they do. It's like a part of what they do when they, after they die. They cover
That's
their mirror and they open up their windows to their room, like, to the outside.
oh, that's weird.
Very weird.
I never heard of that.
See, she's saying the same thing.
Oh, that's strange. I never heard of that. We don't do that where I work.
Y'all better start doing it. Them people probably just floating
No
around in there.
wonder. Because apartment 214, I said, we need to sage this apartment. Nobody lives. Every person that's moved in it has passed. They don't last long. I know, Gwen, when I used to work for the home where I don't know what to call them. Well, they were mentally challenged and they had disabilities too. So those kids were large. They were kids. They were in homes. Like we had a stationary building and then we had different homes. I did not know that. I don't think we do that where I work. I know we don't do it at my building, but I don't know if they do it at the assisted living building. But yeah, the place I've worked in multiple kind of places, but that's where I worked at a juvenile place. We had kids until they were 21 with mental disorders and disabilities. And yeah, those kids were violent as hell. Very, very weird place. It was cool, but it was also like it hurt. I've been slammed up against walls. Luckily I never had poop or anything thrown on me, but if that had ever happened, I think I would have lost my mind. I did get attacked by one of those kids though. He used to sit at the table. We used to be eating breakfast because we had shifts, 24-hour shifts, and mine was in the morning, and we made breakfast for the kids. And this one kid used to sit and he'd stare at me every morning eating breakfast, and he'd go, "I'm gonna get you. I'm gonna get you." Every morning. I was the only female that worked in that house with the dudes, and the guys were like, "We'll never leave you alone with him." And then one day I was sitting in the living room with the kids, and one of the guys got up to go into the kitchen and get something and left me in the living room with this kid. And that kid jumped across that room so dang fast. He was going to kill me. Knocked the lamps over, the chairs.
I'd have had him scared. I'd be like,
oh man.
I'd be like, it's me and you, bud.
He came after me so fast. I was like, holy crap, he wasn't kidding. He was going to get me. I was like, needless to say, I didn't go back to work after that. Did not feel safe.
They're just always immediately strong for some reason.
They are. They're like, well, I mean, what do we call my little dog retard strong, because he gets like super strong. He gets like strength that comes from like, when people are on drugs and they get that super strength.
Yeah.
That's the kind of strong. Yeah. Silencing Whispers. That too. Yeah. You and Gwen both, y'all know exactly. Yeah, that's crazy. Oh my goodness, China. Your daughter, she's only 20. That's wild.
Yeah, she's going into nursing, so I guess this is a step, but this is something she's just doing for now. She's getting ready to do travel nursing.
Ooh, that's money.
I mean, travel CNA, my bad. And they've already tried to get her to start now, but she didn't, because she's in the middle of school, but the first of the year she'll be able to do that.
Yeah.
But
that's good.
That she'll be working. The place they want her to come to is a hospital, and it's like maybe an hour and a half from here, so she wouldn't be too far from home. She had like she's scared to go too far anyway. She ain't like my other two kids. They was ready to get out. Not this one. She hanging on there, boy. But you gotta let them go when it's their time.
That's okay. Hey, tell her to stay as long as she needs to. Look here, honey. She don't want to be paying no bills yet.
That's what I try to tell her. I was like, it ain't no game out there. You better. But sometimes you gotta let them learn on their own.
you go potty? Did you go potty? Did you do something good? Good boy. Go get a treat. Let's go.
Yeah, she feels too, Sally